Good morning, everybody. Bright and early. Welcome back. Welcome back. It's actually not completely dark outside. It's the wonderful thing about this time of year where I have to get up at dark 30 to watch the opening statements in the Karen Read trial. And of course, we're going to be on the schedule for every day that this trial goes on. But you have that beautiful morning glow where the sky just kind of starts to get a little bit light before it gets pink. You kind of see the clouds come popping out a little bit. There's a few little stars left, and they kind of fade back into the background. I had to go do a very long watering of the bonsai trees this morning. And so I got to enjoy a little bit of that morning environment that I have to say I haven't really enjoyed since I've been out camping. It's one of the things I've always enjoyed about camping is you just get on a very natural schedule. Once the sun goes down and it gets dark, what is there to do? There's nothing to do but sleep. So you go to sleep, and then it might be very early, but it's dark. What else are you going to do? And then the light starts to come, and you wake up, and you just get to experience parts of the day that aren't part of my normal routine. So I'm actually enjoying that. Looking forward to that aspect of this trial, as long as I can maintain the discipline on the tail end to go to bed at a decent hour. So had some fun on stream last night with Ian Runkle, and it was great. I talked a little bit about this trial and what we expect. Guys, I'm thinking back on the first round. I'm remembering those opening statements from the first round. Who all was here for that? Who all was here for that? Now, I didn't cover the opening statements. I watched them, but that was back at the time when I kind of just thought I'm going to watch it and I'll do recaps or summaries or something like that. And it was, I think, about a weekend that I'm like, this is too crazy. I got to watch this thing live while it's happening. So I don't have a live stream from the opening statements last time, but I did watch them. I remember them so clearly because I remember how Mr. Lally, it was like he was reading us his grocery list, or his preparation for his opening statement was that he had the witness list in front of him, and he was just working through it and telling us the names of everybody who's going to testify. And it was dumbfounding from the get-go. Because it was just so poor from a technique standpoint. The opening statement is your chance to tell the jury what the evidence is going to show. And what you're hoping to accomplish in a best case scenario is you're setting the stage for the jury to know how to interpret what they're going to see. You are telling them, this is what the theme of the case is. This is what I'm going to show you. And here are the details that are going to lead you to the conclusion that I want you to reach. So we saw it done very effectively with David Yanetti's opening statement. Got right up, told us Karen Read was framed. Okay, that is a theory of the case. And then he spelled out, here are the things that are going to show all the missing pieces, the 47 pieces of missing tail light, the proctor's texting about how the homeowner's not going to have any heat come down on him because he's a Boston cop too. Explained how what we see is going to support this position that Karen Read was framed. That was not what Mr. Lally did. Mr. Lally just told us, here's a long list of people that are going to testify, and here are some things that they're going to say. And just really never tied that into a nice package of what I'm supposed to get out of sitting through this whole trial. How is this going to lead me to the conclusion that Karen Read is guilty of second-degree murder? And then we sat there for 25 days waiting for the Commonwealth to prove that John O'Keefe had been hit by a car, and came out of that part of the trial very unsatisfied. So, as unlikable as I personally find Hank Brennan to be, and I know that I'm not alone in that, I find him very off-putting. He is nevertheless a better lawyer than Adam Lally. I just think that's fairly obvious. He's certainly got different techniques and strategies as well. I don't trust him for a second. He's very fast and loose with the law, with the facts. I expect him to twist things, distort things, take things out of context, etc. But that said, even taking all of that into account, he's got a better understanding of just how the trial process works and what it's for than Mr. Lally seems to have. So I am definitely expecting a different strategy from the Commonwealth in this opening statement. I expect it to be more cohesive, for it to be more organized around the theme. And the real question is going to be, what is the Commonwealth's theme of the case going to be? I have a prediction. We'll see. We'll see how this ages. But my prediction is based on his announcement, I guess, the notice he gave that he intends to use at least one clip from the one of Karen Read's public interviews in his opening statement. We don't know which one. We don't know how many. I'm not sure we even know like which interview or the documentary or what exactly it's going to be sourced from. But I suspect that means he is going to organize his case around what Karen Read said. And this is potentially effective. This is potentially an effective approach. People find it very compelling when people tell on themselves, when people make admissions, when people talk about what could have happened, maybe it went like that. People find it very incriminating when somebody incriminates themselves. Now, did Karen Read incriminate herself? I haven't watched every single interview she ever did. I did watch that documentary, the one on ID. I don't even remember what it was called, what the network was called. I watched it streaming. I think it was on HBO Max too, but I didn't see anything particularly incriminating in it. There was one statement that she made at one point that I'm like, ooh, that you could have left that out. That didn't help anything. And I'm suspecting that's going to be the one that we hear in the opening statement. And it was Karen Read admitting that she'd had a number of drinks and that she was driving. And I think maybe like shouldn't have been driving or something along those lines. Now, granted, everybody in this town, including the police officers and their families, they were driving drunk. That seems to be just culturally not really out of place for this particular group of people. But nevertheless, it doesn't look good. That's not a good admission to have made. Particularly because I think for a lot of people, and certainly what we heard from Ronnie, the jurors interview from the first trial, the kind of easiest answer for everybody looking at this case and trying to figure out what happened is, well, look, she was there. She was drunk. That's where he was found. That's the easiest solution to this question of what happened and how all this went down. She hit him with her car. And then the question just becomes, did she do it intentionally? Did she do it accidentally? Did she know that she did it? And unfortunately, Karen gave them a fair amount of ammunition for that. I'm certainly not blaming her for it because the problem is this is normal. This is normal human behavior to question yourself, particularly if you're being a little gaslit, if you're being a little misled. This is what we see during the Read interrogations, for example, where somebody walks in knowing I didn't do anything wrong, I didn't commit a crime, and then they are so gaslit and lied to by law enforcement that it causes them to kind of question what they know, question their reality. Is it possible that I'm mistaken? Could I have dreamed it? Did I sleepwalk this thing? Normal people will have that kind of thing happen to them. So for somebody like Karen Reed, who's been hysterical this whole morning, she's clearly not in her best state of mind. And now she's being interrogated by police. They're taking her phone, they're taking her car, they're telling her that she did it, they're telling her that she said things, they're telling her that there's evidence. Okay, telling her, we all see it on the news within days of this crime happening. It's on camera, it's on Ring camera. Police have seen it. And then, of course, we get through the trial and it turns out there's nothing like that. Don't know exactly where that leak of information came from, or why. But turns out that that is not accurate. That is not, in fact, what happened in the investigation. But Karen Reed doesn't know this. She's hearing all this. You hear it's on video that you hit somebody and you have no memory of it. It's perfectly normal to question, am I the one that's wrong? Sane, normal, well-adjusted people don't automatically assume I'm right and the entire world is wrong. The evidence is wrong if it's out there. No, people will doubt themselves. So that's normal. And so the fact that Karen Reed may have initially thought that she did it because of that, to me, is, one of the most predictable, expected things from a person in that type of situation. But nevertheless, it's going to give the Commonwealth something that they can use to their advantage. That's why they use it. It's why they do it in the Read technique, is because it's very persuasive. If you can get somebody to acknowledge the possibility that they might have done it, then you get to go, aha. See, ladies and gentlemen of the jury, even she thought that she had done it. Even she knew. So it's compelling. A person's own words, a person's own admissions. And that's why prosecutors use these tools to try to elicit statements, use those statements to present a particular interpretation of the facts and interpretation of the evidence. That's my prediction of what Hank Brennan is going to do. So we'll see. We'll see. What theme he has and how he organizes it. But we know he can't focus on the evidence is going to prove John O'Keefe was hit by a car, because it doesn't. That's the weak part of his case. So he's got to get away from that, avoid that weak part as much as he can. Hey, it's ambiguous at best, but one thing that isn't ambiguous, Karen Reed's words. That's kind of how I expect him to be able to bring it back to what has the best potential to get him a conviction in this case. Now, the defense had that very clear. Karen Reed was framed theme during trial 1. But I don't think they're going to repeat that. I think they're going to modify that. And I think that's prudent. I've definitely talked about this a few times before. But we got that feedback from the interview with Juror Ronnie as well, that, all this third party stuff, that somebody else did it, we kind of thought that was all a distraction. And it's the risk of pointing the finger at somebody else, that if you don't have the receipts, if you don't have the goods, you don't have a smoking gun to prove that they did it, you lose a little bit of your credibility with the jury. You just unfortunately set up a little bit of a binary kind of situation where normal people are going to look at your theory and the Commonwealth's theory, and they're going to see their job as trying to decide which one is right. And that's not the jury's job. You put yourself in a box when you assume a burden of proving a theory to the jury. And so the Commonwealth doesn't have any choice. They have the burden of proof. They've got to come up with something to convince the jury. But you, the defense, you don't have to. You don't have to solve the crime. That's not your job. But you can point out problems with the Commonwealth's theory. And that's just the classic approach that a defense attorney will take in a criminal case. You don't have to prove anything. So you don't take on the burden of proving it unless you got something really solid. And so you'll see that in self-defense cases, for example. You've got eyewitnesses, you've got video, you've got other types of evidence that will substantiate you. Those tend to make good self-defense cases, even though it is, to some extent, the defense is taking on a burden of proof. It's a little bit different because self-defense has to be disproven by the state beyond a reasonable doubt. Like, it's one of these things where, again, it's not technically a burden that you take on, but just as a practical matter for a juror that's sitting there in that box and watching the evidence and trying to decide what the right verdict is, they're looking at it as, do I believe you or do I believe you? Which one do I believe? So you just give yourself a lot more room when your theory, your reason why you should believe me is because I'm just pointing out to you that you can't rely on what that guy is telling you happened. And I'm going to show you all the reasons why you can't rely on what that guy is telling you happened. So I expect the defense to toe a little closer to the line this time in terms of just sticking to reasonable doubt as really being their theory. And I think that was signposted for us in the pretrial conference when Judge Cannoni asked David Yannetti explicitly, are you pursuing third-party defense? Are you pursuing straight third party? Are you pursuing Bowden? Are you pursuing something else? And Mr. Yannetti said, he kind of stammered a little bit, but his direct answer was the second one, Bowden. They're pursuing the Bowden defense. So that's focusing on undermining the law enforcement investigation. The argument that, there is reasonable doubt because the investigation was so poor that they didn't rule out other reasonable possibilities for how this crime could have been committed. It's, from my perspective, just such a stronger argument because it really does make the most out of those weaknesses in the Commonwealth's case. Instead of trying to take those weaknesses and transform them into a different version of events, which then implicitly or not, you kind of end up having to sort of prove that to the jury. No, you just go ahead and rest on, how can we know this is the correct theory? Because number one, it doesn't explain for all the evidence. And number two, they deliberately chose not to look at reasonable possibilities. They deliberately chose not to look real closely at these homeowners, even despite all of the reasons why we might normally be inclined to do that. Like, I don't know, the fact that this guy doesn't look like he was hit by a car. Maybe that would be a reason why. So you don't have to you don't have to lead the jury to the conclusion that Karen Read was framed. The jury can reach that conclusion themselves if they want to, but it's also possible that this is just the most incompetent law enforcement investigation that's ever taken place in the state of Massachusetts. That's certainly possible as well. So let the jury choose. You don't have to shoehorn into one particular theory or not. They can come to their own conclusions about that. But the bottom line is just simply, this investigation, you can't rely on it. You can't rely on it as being credible. You can't rely on it as being unbiased. You can't rely on it as being an objective search for the truth. And given that you can't find that Karen Read is responsible for this death, because they can't even prove a mechanism of how it happened that's consistent with the evidence. A lot more that's going to be different this time around. A lot more is going to be different this time around. some revisions to the witness list. You got some different evidence. This is one of the things I am looking forward to most from this opening statement is there's been a whole year to do additional investigations. They've had the opportunity to follow up on what came out during the first trial. So everything that happened during the first trial, they get to use that as like a baseline, right? Because if people change their testimony from the first trial, oh, they're getting impeached with that testimony from that first trial. Absolutely no question about it. So everyone's kind of stuck in the position they took the first time around. That's one of the ways where the defense has an advantage this time, because Karen Read didn't testify, and their case as a whole was kind of minimal. You know, their real independent witnesses that they put up were basically their experts and Lucky Loughran, right? They didn't put on a whole bunch of, percipient witnesses. They didn't really need to. So the defense is locked into a lot less than the Commonwealth is locked into. The Commonwealth, I don't even remember the count now, how many people they put on, but all the people they put on over 20 some days, 4 weeks basically. Now they're locked into that. So if things have changed, if there's new information, it's going to be hard for them to adjust and to work around it. You're going to have to explain that your theory the first time was wrong. That's going to be a little tough. It doesn't make you look very credible. It doesn't make you look like you have really solved this crime. One area in particular where I think this is going to be an issue, because it was so close to being an issue in the first trial, but it just never quite crystallized. They just never quite pulled the pieces together to make it a real bombshell, was the shift in the timeline. And that's because the Commonwealth had a discrepancy between the texts that Jennifer McCabe had been sending to John O'Keefe on his phone. She's, texting him, "Are you here? Are you outside?" And in the initial reports that law enforcement took, Jen McCabe was explaining, "I was watching the car outside and nobody was coming in, so that's why I was sending these text messages." And it was after I sent the last text message. I don't even remember what the content is, but she's just basically telling him, "Pull up behind me. Are you there? Hello," things like that. And after she sends the very last text message at 12:45, she sees the car drive away. So she just thinks they decided not to come in and they went home, and nobody thinks anything else about it. And that's her initial story. But the problem is that it came out about Karen Read's phone connecting to John's Wi-Fi at John's house 6 minutes away at One Meadows Avenue at 12:36. So whatever Jen McCabe was doing, she was not looking outside the window while she was texting these things to John up to 12:45 a.m. That's not what was happening. Doesn't work. You don't connect to Wi-Fi from, a mile or so away, a couple miles away. It didn't quite crystallize in the first trial, and I think there were a few reasons for that. One of them was Jen McCabe herself. Jen McCabe was a very slippery witness. She did not mind changing anything, and she also did not mind just flat out saying everything else was wrong. The reports were wrong. The phone reports are wrong. The health data is wrong. Whatever. She's happy to just sit there and say, "That's wrong. What I say is correct, is the truth. The problem, of course, is all the various versions of what Jen McCabe has had to say. So when it came time to impeach Jen with the prior statements, it wasn't particularly effective because they didn't focus on it. They didn't drill in on it. When they asked her about the previous statements she'd made to law enforcement, she just said they got that wrong. They got that wrong. She didn't say that. She didn't say that. If you are really focused in your cross-examination and the points that you want to make, number one, your cross is short. Okay, Jen McCabe's cross was not short. Jen McCabe's cross was quite long. That also is going to end up being to the advantage to the defense this time because it gave them like a free interview, almost a free chance to get Jen McCabe's entire story, including how do you explain away this problematic stuff? Why are you in the police officer's driveway the next day? The guy who came in that morning to do the interviews of the Alberts at the house. Why are you in his driveway the next day for like an hour? Yeah, not real sure about that. But she had the opportunity to come up with explanations for everything. So they already know, they have her pinned down on really everything they could have wanted to know because they asked her questions for like a full day during the last trial. But the effect of that means it wasn't particularly focused. And so when it's not focused, you don't really know what's important and what isn't. You kind of end up expecting the jury to sort through that and make sense out of it. And maybe they will, but the big risk is that they won't. And so it's really your job as the attorney to do that digesting for them. Don't just throw it all out there. Don't just dump everything and hope that they sort it out. Target it. Just give them what they need and what they need to pay attention to. So that it takes some discipline and it takes some editing to really pare down your cross to what are the critical points I need to elicit from this witness. And you do that because you already know how you can establish the points you need to make. They were made in a prior statement. They were testified to in a prior proceeding. There's objective evidence like ring camera video, body camera video, whatever, that's going to establish the point I need to establish. And so you tell your story through the facts. You don't need to tell your story through the witness's explanations. The witness is unlikely to give you explanations anyway. So a well-constructed cross is something where it doesn't matter. It doesn't matter what they say because you have the tools that you need to back up the points that you're trying to get at. So in the first trial, if they really wanted to hammer on that point, it would have been helpful to not have, such an extensive cross, to have it more targeted and focused on that. So the jury knows, hey, there's only been like 10 questions here. This is one I need to focus on, because you're going to have to come back and follow up on it. When she says they got that wrong, they just wrote that down wrong. That's your clue that you need to follow up with that officer who took that statement. You follow up with that guy. Hey, she says you got this wrong. Is it your habit to get that wrong? This was pretty important. You think you got that wrong? You put the officer in a position of, are you going to fall on your sword over this, or are you going to back up? Are you going to stand on business? You're going to say, yeah, I did my job and I put in the report what was communicated to me. And yes, I understood it. No, I wasn't confused. Do you want to look like Keystone Cops, or do you want to look like you know what you're doing and you did a good job here? You got to put it back on that guy. But it's just much easier to follow that when your initial cross was crisp. It was clean. It wasn't cluttered up with just a lot of extraneous things that may or may not be important. a lot of slippery denials that just kind of got left there. They just got left there and didn't get followed up on. So I'm hopeful this time around. We might see a little bit, just a little bit cleaner, a little bit more focused. They had the first trial to do their fishing, so to speak, to see what they had to work with. Now they have so much. It's just a question of being able to utilize it in the most effective manner. That's the challenge. That's the challenge of being the defense lawyer every time. Well, unsurprisingly, they're not getting started on time this morning. Kind of a pattern in this court, but in fairness to this court, kind of just a pattern in trials in general. It gets chaotic. They're trying to, coordinate. What did they end up with? 18 people on the jury. That's a lot. That's a lot of people. Any one of them's late. Any one of them doesn't show up. Starts to throw things in a little bit of chaos. You got to decide, what are you going to do? Are we going to excuse this juror? Are we going to wait for them? The security stuff. I mean, we know that this courthouse is it's hopping. Buffer zone aside, there's a lot going on in the vicinity of this courthouse. So they have that to navigate. I don't envy the court having to accommodate a high profile case. I can imagine that they find it annoying. They don't want to have to be doing that. Sorry, guys, it's just the cost of doing public business. These are the public's courts. When they're curious about it, yeah, there's gonna be a lot of attention. A lot of people are going to be wanting to see what's happening in there. But it doesn't mean I don't have some sympathy for the pressure that this puts, not just on the courthouse, but on the community as a whole. Definitely saw it when I was down there in Delphi. It was one of the things that I found most egregious about the way that trial was conducted. The fact that it was so difficult to get into court meant that those of us who were there from out of town really didn't get any kind of opportunity to support the local community. One of the upsides about traveling to visit a trial, attend a trial, or really anything like that, is that you get to see the community. You get to see the shops. You get to support them. You get to buy your lunch there. Oh, it looks like court is getting started. And we didn't get to do that.
This court is in session. Please be seated.
2282 CR 117, the Commonwealth versus Kerri Reed.
So, good morning. I see all counsel are present. I see all counsel are present. Nobody said anything to Mr. Clerk about needing to see me, but I received 4 motions over this weekend that I assume we need to at least talk about briefly. Commonwealth's motion regarding defense opening statement. I think the first 2 motions we can do quickly. I'm not issuing an order. Mr. Brennan, the defense knows third-party culprit will not be in the opening. If you think that their opening goes beyond it, you can object. Defendant's opposition to the Commonwealth's request for use of independent readers, because there's an objection, the defendant's motion's allowed. So you will not have an independent reader. Is it fair to say that the 3rd and 4th motions, Commonwealth motion to enforce compliance with court's April 16th ARCCA discovery order and the Commonwealth's motion to preclude new expert testimony or alternatively to continue the trial date, that those motions will take a little bit of time, Mr. Brennan?
Interesting.
I don't think I'll be long in my argument.
I think that I need more information on one of them. And I think we'll do that at the end of the trial. I mean, at the end of today, we'll hear both these motions.
Well, then you're not
Mr.
continuing the
Jackson,
trial.
I did see that a list of text messages, 100 or so, is in your response to my order on Friday. Did you provide the text messages themselves? All right. In light of that and the fact that we don't have time, this juror's been waiting for some as many as 3 weeks now, I'm going to prohibit you from mentioning ARCCA in your opening statement. And then we'll deal with this later today. I ordered those text messages and they weren't delivered. So we're going to be bringing the jury in. I'll be in recess for 5 minutes.
Heard on that, I think the court respectfully may be factually incorrect on a key assumption of what Your Honor is ruling.
5 minutes, Mr. Alessi.
Mr. Jackson couldn't give you the facts. I would like to give the law back.
That's more than 5 minutes. I'll see you at Sidebar. Come up here.
Glad to see that he's jumping up to correct the record if she's got something wrong. So I guess she ordered production of text messages from the defense team. This was the ARCCA communications. You know, Mr. Brennan has been hammering on this because ARCCA is devastating to his case. And the defense has also now been following up with wanting additional investigation, additional opinions from them. So because they didn't have the opportunity initially to decide the scope of what ARCCA is going to do and what are they going to look at, what questions are they going to answer, what information are they going to rely on, they have the chance to do that now. And as soon as they were given permission to do that, they followed up on it. But because of that, Commonwealth has been arguing they're not complying with discovery. They're not disclosing everything that they're required to disclose vis-a-vis the relationship with ARCCA, the communications, the arrangements, and so forth. So they're ordered to produce these text messages, basically between the defense team, Karen, anybody that communicated with ARCCA about the work that they're going to do for the defense side. So they provided a list of text messages, is what Mr. Jackson said, but not the actual text messages themselves. That sounds like it's an issue unless there is a privilege, an invocation of privilege. Normally, a lot of this stuff is going to be work product if the attorney and the expert are talking about the defense theories. You get a perspective into the defense mindset. Those particular communications are often going to be privileged. So that's certainly a situation where I could see that the defense is not going to be turning over these actual messages. They're going to turn over a privilege log. They're going to identify what the messages, what messages were sent from whom, when, but they're not going to tell you what the content is. They're going to tell you these are privileged based on work product. So that's kind of what I'm anticipating is going on with this conversation. But I am glad to see Mr. Alessi jumping up to correct if she's jumping to a conclusion. I ordered you to do this and you didn't do it. And the argument is actually, we complied within the scope of what we are legally required to do. We didn't produce what we're not legally required to produce. Then that's clearly an important point that needs to be on the record. Why we had to go to Sidebar about it instead of just talk about it in open court? Okay, well, your guess is as good as mine about that one. I'm not sure if these sidebars are going to continue to be impounded. Didn't that come up? That came up pre-trial because she impounded the sidebars from the last trial. This time there was an objection. I kind of vaguely remember this being argued and her saying that since there's an objection this time, they're not going to be impounded, but we're still going to have the issue with the juror identification, of course, not being in the record. Let me know in the comments if I'm remembering that correctly, but it's an issue, you know. It would be very nice to know what's happening as it's happening to the extent we can. The jury is not in the courtroom right now. I don't know. Why are we at sidebar? Why are we at sidebar? We should be able to just have this conversation in open court so that if you are going to maintain that the defense doesn't get to mention one of their most important witnesses in the opening statement, that we all should know why. We should know what their explanation is, and we should know how you're going to handle that. So there's really no need for this to be at sidebar. That's a little bit annoying. 4 motions over the weekend. We saw the one about the defense opening. That one, it was a stupid motion anyway. This is the one where it looks like we're going to go out of session for a minute. Here's my guess. If that was indeed about privilege, she's going to be looking at the messages in camera. That's going to be my guess. We're going to take time. She's going to look over all of them. She's going to decide if they're privileged or not. And if they are, then she's going to say you've complied with your discovery obligations. So you can mention ARCCA. If they are not, or she thinks they are not, then she's going to do whatever it is that she's going to do. Just my surmise of what all this is about. So yeah, that motion that Brennan filed, it was a stupid motion. He basically said that because the defense wants to show in their opening statement the autopsy photo of John's arm, that this necessarily opens the door to third-party culprit theories, that they then have to, you know, violate the court's order where she said you don't get to identify specific third-party culprits in your opening statement. You have to wait until the evidence develops. I don't like this ruling because you have a whole first trial as an offer of proof. And during that whole first trial, you know, once that culminated and was in, they were allowed to name those third-party culprits. So that should be all you need for them to be able to make the allegation this time around. Then if they can't back it up, well, that's on them. That's a failure of proof. But it's not a lack of having substantiated a sufficient connection to be able to name them. They have a whole trial as an offer of proof on that. So I don't particularly like that ruling. Nevertheless, it is what it is. And since I've already said, I think the smarter thing to do anyway is not to do that, not to go pointing the finger, not to go trying to solve the crime for the Commonwealth. The whole point is that they did a shoddy investigation, so they didn't get the evidence, so they didn't tie these people down because they didn't want to. That was the whole point. And so because they didn't do it, of course, the defense doesn't have it available to be able to prove it. So instead of going down that road, it's much, much smarter to just go down the road of we will never know because of how badly they messed this up. And why they messed it up that badly? I don't know. Maybe they're incompetent. Maybe it's malicious. I don't know. All I know is that this investigation is trash. And it depends on you reaching the conclusion that a man who does not have injuries consistent with a pedestrian vehicle collision was hit by a car and that killed him. So Hank's motion is silly. It's silly. It doesn't matter anyway, even if it was granted. Be like, sure, I'm not going to say that. I'm not going to say that in my opening anyway. But it's telling, I think, because it shows a little bit of what his strategy is. He's trying to argue that anything that the defense really wants to use implicates a third party culprit defense. So this is doing a couple things. One, it is strawmanning the defense case. It is making up what the defense case is and then beating that apart. This is the same approach that we've seen online with this case for like a couple of years now, where people are like, oh, you gotta believe this massive conspiracy to think Karen Read is not guilty. You gotta believe this massive conspiracy that like every police officer in Canton and half of the MSP and all these supervisors and the prosecuting attorney, they're all in on it, and they're all doing it just to protect this random family there in Canton. No, you don't. No, you don't. That's called a straw man. That is caricaturizing what the defense is actually arguing, which is you got pretty good reason to suspect these other people. It's on their lawn. They were hanging out the night before. The guy doesn't look like he was hit by a car, but he sure does look like he was beat up and chewed on by a dog. That's the defense case. Just pointing out the implausibility of the Commonwealth's theory. But if you can paint it as something else and you can convince the jury they're actually telling you something else, and that something else that they're telling you is ridiculous, that could be effective. Hang a defense on them that they're not actually even asserting. I'm expecting this from Hank. He's going to try to characterize the defense argument for the jury and then rebut that. He's going to try to get them to look at it with contempt before they even present what their theory even is. So he's trying to shoehorn everything into a third party culprit because that's a strong point for him. The jury from trial number 1 already said, this is a distraction. This isn't effective. Don't focus on that. Focus on the more objective stuff, whether John was hit by a car or not. The folks who had the medical background on that first jury, according to Juror Ronnie, yeah, they had serious doubts about the Commonwealth theory because really hard to look at this evidence and conclude that this guy was hit by a car. So focus on that. That's the strong point of the case. That's why Hank doesn't want them focusing on it. He wants them focusing on trying to prove somebody else did it, trying to prove that there was a cover up, because those things are weaker arguments for the defense. So number 1, that's what he's trying to do strategically. He's trying to shoehorn the defense into a position so that he can rebut that instead of the actual defense that they present. But then he's also using that as a mechanism to try to get away from some of this more damaging stuff, some of the bad facts that the Commonwealth has to deal with. He wants to try to turn that all into third-party culprit. And it might work in some courts. It might work in some cases. I don't think it's going to work here. I really don't. The reason why is because the third party culprit issue itself, it's pretty narrow from a legal standpoint. You get to say, I didn't commit this crime. You get to say that. And you get to talk about the circumstances of the crime. What happened? Who was there? Who was drinking with who? Who said what? You get to raise all of that. That's part of a criminal case. All the third party culprit ruling does is it says you don't get to point the finger at somebody specific and say that person did it. Not me. That person. Until the evidence has reached a certain point that warrants that type of inference being made. So the restriction is essentially Karen Read cannot in opening get up and say, I didn't kill John O'Keefe. Brian Albert and Brian Higgins did it. They don't get to do that in opening. But to suggest then that she doesn't get to point out the evidence is inconsistent with the Commonwealth's theory, because the Commonwealth says John O'Keefe was hit by a car, but his arm was chewed up by a dog. And they at no point have provided any explanation for how he got dog bite injuries as a result of a pedestrian vehicle collision. That's not a third-party culprit defense. That's just a your case is trash defense. Your case is trash because you haven't explained the evidence. That's all that is. The more he could try to shoehorn, the more he could expand what is a third-party defense, he is getting into her ability to maintain her innocence, to really present a defense at all. He wants to try to cast as much of that as third-party culprit as possible to try to keep it out. But the reality is that the third-party culprit issue, it's extremely narrow. It's extremely narrow. So if she's not proposing to get up and say, Brian Higgins and Brian Albert killed John, then she's not violating the order. She can point out his arm was all dog bit. And by the way, there's a German Shepherd in that house with a biting problem. Just kind of one of those things that maybe ought to raise some suspicion about whether the Commonwealth's interpretation of this evidence is the correct one. That's not a third-party culprit defense. That is straightforward reasonable doubt. So that was a bad motion. I think that I appreciate how she decided that, because that's frankly how I looked at it too. There's already an order saying they can't raise third-party culprit. They're expected to comply with that. There's nothing that this order would do that isn't already in place as a result of existing orders. You don't need a second order or a cumulative order to be able to prevent that. And if you have a problem with what they're doing, you object to it. That's the rules. Now, it's kind of frowned on to object during openings and closings. It's not really sporting to do that, if you know what I mean. But it doesn't mean you don't do it. You absolutely do it. In fact, a lot of times you need to do it, particularly in closing. Somebody's crossing the line in closing, you need to do your objecting. And that has to do with the standards of review you get on appeal, depending on whether you have objected or not at the time. The independent readers are not being allowed. That, I don't know if I'm surprised about that or not. I mean, it's a very sensible and, from my perspective, correct decision. So, it always, I don't expect to think like Judge Cannoni very often. So when she articulates my thought process, it makes me wonder a little bit. Am I on the right page here? But I am a little bit surprised, just because I think it is this area where there's not necessarily a lot of law on that. I'm not sure that I guess I'm just not sure that it's been done so much, that there's going to be a lot of litigation about it. But yeah, this strikes me as problematic. It did from the time that Brennan sort of described what he wanted to do. It struck me as problematic. You want to read out text messages that were not a conversation, not an oral conversation. You can't have that done by just the witness who discovered the text messages through the extraction, or somebody who reviewed them from the extraction. Have them read the ones that they thought were significant. But otherwise, it's their text. They speak for themselves. Just put them in evidence, display them to the jury. Trying to dramatize it without dramatizing it, it was not ever going to be plausible. I don't think. You can't read things. You can't read something and not emphasize words. I mean, unless you're just reading in a perfectly flat robotic, how is that helpful? It's not helpful. It's more helpful for the jury to read it themselves and like imagine the tone and stuff in their own minds. So it was always going to be dramatized, and it was always going to be misleading because that's just not the nature of this communication. It wasn't a spoken conversation. They were texts. The parties read them. They didn't, articulate them. So it did have the potential to be misleading. It did have the potential to put weight on certain parts, certain things, certain words, convey a mood that may or may not be correct. Seemed improper to me. So the fact that she agrees has me thinking for a second, is this actually kind of okay? No, it's not. This is just a situation where I think she got it right. So then the last two motions that came in over the weekend, I haven't seen them. I can check Twitter real quick and see if they're up. But sounds like they're both dealing with ARCCA. So the Commonwealth doesn't want new opinions of ARCCA. So it sounds like that's been disclosed. We got that from the hearing last week. I got my notes here. See where we ended up with exactly what they were going to have to do. Oh, looks like we're back already.
You are
Maybe
muted.
just the sound.
You are unmuted.
Still that fan, but getting some noise. So Hank was still saying, I'm unsatisfied about ARCCA, and he wants information about the relationship between ARCCA and the defense since the exception. And voir dire wasn't going to be sufficient. Defense said there's lots that only ARCCA has, and so
Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable Beverly Cannoni, the Justice of the Superior Court, now holding in Dedham, within and Father County in Norfolk. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is in session. Please be seated.
2282 CR 117, the Commonwealth versus Karen Reed. Can I have counsel identify themselves for the record?
Morning, Your Honor. Adam Lally for the Commonwealth.
Morning, Mr. Lally.
Good morning, Your Honor. Hank Brennan for the Commonwealth.
Morning, Mr. Brennan.
Morning, Your Honor. Alan Jackson on behalf of Ms. Reed.
Morning, Mr. Jackson.
Good morning, Your Honor. Elizabeth Little, also on behalf of Ms. Reed.
Good morning, Ms. Little.
Good morning, Your Honor. Robert Alessi on behalf of Ms. Reed.
Good morning, Mr. Alessi.
Good morning, Your Honor. David Yannetti for Karen Reed.
Good morning, Mr. Yannetti. Good morning, Ms. Reed. Good morning, jurors. So I have 3 questions I have to ask you because I haven't seen many of you for a long time. And we do appreciate that you are all here, ready, willing, and able to get started early. We sometimes have to deal with a few things before bringing you in, but we do appreciate your patience. So those questions are, were you all able to follow the instructions and refrain from discussing this case with anyone since we last saw you? Everyone said yes or nodded affirmatively. Were you also able to refrain from doing any independent research or investigation into this case?
Yes.
Everyone said yes or nodded affirmatively. Did anyone happen to see, hear, or read anything about this case since we last met? Everyone said no or shook their heads. Thank you very much.
Jurors, can I have each of you stand and raise your right hands, please?
They are sworn. We are not continuing the trial. It's official.
Do each of you solemnly swear you shall well and truly try the issue between the Commonwealth and the defendant according to your evidence and according to the law, so help you God? Yes. Thank you. You can have a seat. Jurors, hearken to these indictments. Karen Reed of Mansfield in the county of Bristol, on or about January 29, 2022 at Canton in the county of Norfolk, did assault and beat John O'Keefe with intent to murder such person, and by such assault and battery did kill and murder the said John O'Keefe, and is guilty of murder in the second degree and not in the first degree in violation of Massachusetts General Law, Chapter 265, Section 1. 002, Karen Reed of Mansfield in the county of Bristol, on or about January 29, 2022 at Canton in the county of Norfolk, did operate a motor vehicle upon a way as defined in General Law, Chapter 90, Section 1, or in a place to which the public has a right of access, or upon a way or in a place to which members of the public have access as invitees or licensees, with a percentage by weight of alcohol in their blood of 8/100ths or greater, or while under the influence of intoxicating liquor, and did so operate said motor vehicle so that the lives and safety of the public might be endangered, and by such wanton and reckless conduct so described to cause the death of another person, to wit, John O'Keefe, in violation of General Law, Chapter 265, Section 13 and a half. 003, Karen Reed of Mansfield in the county of Bristol, on or about January 29, 2022 at Canton in the county of Norfolk, did operate a motor vehicle upon a way or in a place to which the public has a right of access, or upon a way or in a place to which members of the public have access as invitees or licensees, and without stopping and making known her name, residence, and registration number of her motor vehicle, to go away to avoid prosecution or evade apprehension after knowingly colliding with or otherwise causing injury to John O'Keefe, such injuries having resulted in the death of said person in violation of General Law, Chapter 90, Section 24, subsection 2, subsection A and a half, subsection 2. To these indictments, the defendant has pled that she is not guilty, and for trial has put herself upon the country which country you are, and you are sworn to try the issue. If she is guilty, you are to say so. If she is not guilty, you say so and no more. Jurors hearken to the evidence.
All right, thank you. All right, members of the jury, I'm about to make some preliminary remarks to you to acquaint you with some of the legal principles, procedure, and terminology that you may inquire during the course of this trial. These comments are not intended to be a substitute for the more detailed instructions on the law that I'll give you at the conclusion of the case. So you'll remember that this is a trial of a criminal case. Ms. Reed is charged with second-degree murder. She's also charged with manslaughter while operating under the influence and leaving the scene after causing personal injury or death, the indictments that Mr. McDermott just read to you. I'll describe the law in detail at the end of the case and the elements of these charges, but briefly, murder is the unlawful killing of a human being. In order to prove Ms. Reed guilty of second-degree murder, the Commonwealth must prove beyond a reasonable doubt that she committed an unlawful killing and that it was done with malice. In comparison, manslaughter while operating under the influence is an unintentional, unlawful killing caused by wanton or reckless conduct while under the influence of intoxicating liquor. And leaving the scene of an accident after causing personal injury or death requires the Commonwealth to prove that Ms. Reed knowingly collided with John O'Keefe, that she caused him injury or death, and then she fled the scene. These terms and the elements of the crimes will be explained to you in detail at the end of the case before you begin your deliberations. Now, please remember that Ms. Reed starts this trial presumed to be innocent. The fact that she was arrested or that she was indicted is not proof of anything. An indictment is just a piece of paper. It just makes an accusation. It is merely a formal manner of accusing a person of a crime and bringing that person to trial in the superior court. But it is only the jury, in other words, you folks, who can decide whether the prosecution has proved its case beyond a reasonable doubt. If the Commonwealth does not do that, then the presumption of innocence alone requires you to find the defendant not guilty. The law never requires a defendant to prove her innocence, to produce any evidence whatsoever, or to do anything other than attend the trial. This presumption of innocence remains with the defendant until you, the jury, make your determination after listening and considering all the evidence. Now, what is proof beyond a reasonable doubt? The term is often used and probably pretty well understood, though it is not easily defined. Proof beyond a reasonable doubt does not mean proof beyond all possible doubt, for everything in the lives of human beings is open to some possible or imaginary doubt. A charge is proved beyond a reasonable doubt if, after you have compared and considered all the evidence, you have in your minds an abiding conviction to a moral certainty that the charge is true. When we refer to moral certainty, we mean the highest degree of certainty possible in matters relating to human affairs, based solely on the evidence that has been put before you in this case. I have told you that every person is presumed to be innocent until he or she is proved guilty, and that the burden of proof is on the prosecutor. If you evaluate all the evidence and you still have a reasonable doubt remaining, the defendant is entitled to the benefit of that doubt and must be acquitted. It is not enough for the Commonwealth to establish a probability, even a strong probability, that the defendant is more likely to be guilty than not guilty. That is not enough. Instead, the evidence must convince you of the defendant's guilt to a reasonable and moral certainty, a certainty that convinces your understanding and satisfies your reason and judgment as jurors who are sworn to act conscientiously on the evidence. This is what we mean by proof beyond a reasonable doubt. Now, our system of justice depends on judges like me and jurors like you being able and willing to make careful and fair decisions. All people deserve fair and equal treatment in our system of justice, regardless of their race, national origin, religion, age, ability, gender, sexual orientation, education, income level, or any other personal characteristic. You have agreed to be fair, and I am sure that you want to be fair, but that is not always easy. One difficulty comes from our own built-in expectations and assumptions. They exist even if we're not aware of them and even if we believe we do not have them. Some of you may have heard this called implicit bias, and that's what I'm talking about. Of course, we judges have the same problem as everyone else, so let me share a few strategies that we have found useful. First, slow down. Do not rush to a decision. Hasty decisions are more likely to reflect stereotypes or hidden biases. Second, keep an open mind. Avoid drawing conclusions until the end of the case when you and your fellow jurors deliberate. Remember that when you deliberate, you will have all the evidence and all the time you need to make a careful decision. So there truly is no need to stop making up your mind before then. Third, you should listen closely to all the witnesses. That is the best way to ensure that you decide this case based on the evidence and the law instead of upon unsupported assumptions. Fourth, as you listen to the testimony about the people involved in this case, please consider them as individuals rather than as members of a particular group. And finally, I might ask myself, would I view the evidence differently if the people were from different groups, such as different racial, ethnic, or gender identity groups? At the end of the case, I will remind you of these strategies and ask you to focus on the evidence instead of any unsupported assumptions you may have. All we ask is that you, individually and as a group, do your best to resolve this case based upon the evidence and the law, without sympathy, bias, or prejudice, to the best of your ability as human beings. Now, when I finish these initial instructions, the Commonwealth, Mr. Brennan, will make his opening statement. Then Ms. Reed's lawyer, Mr. Jackson, can choose to make an opening statement or not, because again, remember, the defendant has no burden of proof and doesn't have to prove anything. Her lawyer does not need to make an opening statement. An opening statement is a summary of what the lawyer expects the evidence at trial will be. It is intended simply to introduce the main issues in this case to you. Next, the prosecution will introduce evidence in support of the charges in the indictments. After that, the defendant may present evidence on her behalf if she wishes to do so, but she is not obliged to do so. Remember, the burden of proof is always on the Commonwealth to prove that the defendant is guilty. The law does not require any defendant to prove her innocence or to produce any evidence at all. After all the evidence, each side will have an opportunity to offer you closing arguments about what conclusions you might draw from the evidence. Like the opening statements, the closing arguments are not evidence. They're merely intended to help you understand the respective contentions of the parties. Finally, after all the evidence and the lawyer's arguments, I will instruct you in detail on the principles of law which you are to apply in your deliberations when you retire to consider your verdict. Your verdict must be unanimous. Let me speak briefly about our respective roles in this case. As the judge, my responsibility is to see that this case is tried orderly, fairly, and efficiently. It's also my instruction to decide any questions of law that come up during the trial and to instruct you about the law that applies to this case. It is your duty to accept the law as I stated to you, whether you agree with it or not. Your function, you folks are the most important people in the courtroom. Your function is to determine the facts. You are the sole and exclusive judges of the facts. You alone determine what evidence to believe, how important any evidence is that you do believe, and what conclusions all the believable evidence leads you to. You will have to consider and weigh the testimony of all the witnesses who will appear before you, and you alone will determine whether to believe any witness and the extent to which you believe any witness. You can believe all of what a witness says, some of it, or none of it. It's entirely up to you. It is part of your responsibility to resolve any conflicts in testimony that may arise during the course of the trial and to determine where the truth lies. Ultimately, you must determine whether or not the Commonwealth has proved the charges beyond a reasonable doubt. The lawyers have their own important role in this trial. They are, of course, advocates. Their job is to bring to your attention the evidence and arguments that best support their position. They may also object to evidence offered by the other side that may not be admissible under our rules of evidence. Similarly, we may engage in sidebar conferences out of your hearing. These sidebar conferences are not intended to keep secrets from you, but to allow the lawyers a little more time to argue their points so that I may rule on what you may consider as evidence. If I agree with an objection to a question, the term I will use is sustained. You are to disregard that question, and you're not to speculate as to what the answer might have been. In the same way, you're to disregard any evidence that I tell you is stricken from the record. If I reject or overrule an objection, I'll permit the witness to answer. This happens a lot. You'll find this during the course of the trial. If I let the witness answer the question, but you're not allowed to give the answer any more weight than you would have no objection had been made. Please do not hold it against the lawyers if they make an objection. That's the important part of the lawyer's job. The lawyers have to let me know when there is a potential issue about the admissibility of certain evidence under our law. You must decide this case solely on the evidence presented in this courtroom. This will include the sworn testimony of witnesses and may also include any exhibits that are admitted into evidence, any facts that I tell you have been agreed to by both sides, and any facts that I indicate to you may be taken as a matter of common knowledge. Questions to witnesses, no matter how artfully phrased, are not evidence. Only the answers which you receive from the witnesses who are testifying under oath are evidence. So if a witness is asked, isn't it true that after you learned that your uncle left you money in his will, you poisoned him? And the witness's answer is no. Based solely on that question and answer, there is no evidence that the witness has an uncle, that the uncle had a will, that the uncle left the witness money, that the witness knew that he did, or that the witness poisoned him. Any information that you may have read, heard, or seen about the case outside of the courtroom is not evidence. My instructions to you and any other comments I may make, the lawyer's openings and closing arguments, and any comments they may make are not evidence. I will emphasize this point because it's crucial to your understanding of your role. If the lawyers or I make any comments during the trial, those comments are not evidence, and your verdict must be based only on the evidence. In Massachusetts, lawyers are not allowed to make comments other than during opening statements and closing arguments. They are permitted only to ask questions, but they cannot comment on the witness's answer. If a lawyer comments, you are to disregard it. In this way, communication in the courtroom is not like everyday conversation. If a lawyer seems to agree or disagree with an answer, or if a lawyer expresses confusion or any other reaction or emotion, you are to give no weight to what that lawyer does. In the interaction between a lawyer and a witness, you may consider only the witness's testimony as evidence. In a similar way, any comment I make is not evidence. But of course, you can't disregard what I say when I provide you with instruction or direction. Remember, however, I'm the only one who can instruct you or direct you in any way. Finally, on this topic, If one of the lawyers or I refer to some part of the evidence and that does not coincide with your own recollection, it is your collective recollection which you are to follow in your deliberations. Now, in this case, I anticipate that we will go by bus to an area that you'll hear about during the trial. You may consider as evidence anything that you observe about the layout of the area, including the scene of the alleged crime when we do go there. I will give you further instructions prior to our leaving for the view. Now, in this case, I'm going to allow you to take notes. Any jurors who wish to take notes during the course of the trial, except during opening statements and closing arguments, because remember, those aren't evidence. If you wish to take notes, you may do so once the evidence begins. Notebooks and pencils will be provided to you. The notebooks will be collected each day and they'll be locked up and they will remain confidential and they're destroyed at the end of the trial. Nobody sees them. You're not required to take notes. The choice is entirely up to you. Some jurors may feel that notes are helpful, particularly if the case involves many witnesses or complicated issues. Notes also can help you remember specific testimony or evidence, such as times, places, dates, names, relationships, events, distances, things like that. Other jurors may feel that note-taking is a distraction and may interfere with hearing and evaluating the evidence. If you do take notes, I suggest you keep them brief. They are not and cannot be considered official transcripts of the trial testimony. However, bear in mind that although the court reporter is recording everything that transpires here, we do not have the capability of providing you with a transcript of the testimony at the conclusion of the trial. So you'll have to rely on your own memories of the testimony, perhaps supplemented by your notes. Regardless of whether or not you take notes, please remember that how a witness testifies may be just as important as what he or she says. Therefore, your observations of the witness's appearance and demeanor on the witness stand may play an important part in your assessment of his or her credibility. Do not let note-taking distract from an appreciation of all the evidence. If you have any trouble hearing or seeing during the trial, please raise your hand or let a court officer know and we'll make any necessary adjustments. We generally take a morning recess at around 11 o'clock or so, but if you need a break at any other time, please raise your hand and let a court officer know. We'll take a break. If you need to communicate with me during the trial, and I'm not suggesting for a minute that you need to, but if you do, please speak with the court officer or give the court officer a note to bring to me. Now, I'm going to address the issue of public interest in this case again, and the duty of this court and this jury to adhere to the rule of law, because it is so very important. John Adams famously said that we are a government of laws, not of men, and that the law must be deaf as an adder to the clamoring of the public. He meant that while public opinion about a given subject may ebb and flow, the law must be steady, reliable, and even-handed. We know that on the subject of this case, there are people advocating for one outcome or another with great intensity, but unbound by any oath or even any inclination to follow the actual evidence. The law works in a different way, and the difference is crucial to our system of justice. This jury, selected for this trial, will hear and judge the evidence. You will decide what the facts are. Where the evidence is contested, you will determine where the truth lies. Ultimately, this jury will decide whether the Commonwealth has carried its burden of proving that the defendant is guilty of any crime beyond a reasonable doubt. People outside of this building have rights, and we know that they have voices, but this trial will be decided by you, an independent jury, free from outside interference, based only upon the evidence presented in this courtroom and the law. This is the only way to ensure that every person who comes before the court receives a fair trial. It is just that simple and that important. So while public comment will likely continue, you must ignore it so that the rule of law will be upheld. Which leads me to the fact that it is very important that during this trial, until you deliberate, you must not discuss this case with anyone. This includes your family and friends, and even your fellow jurors. Nor should you allow anyone to communicate with you about any specific aspect or any aspect of this case. You must not conduct any independent research about this case, the matters in this case, and the individuals involved in this case. In other words, you must not consult the internet or do anything else to try and find out information from any source outside the confines in this courtroom. Please be very careful with your social media use. Please do not use X or Twitter, Facebook, Instagram, or Reddit. Though you may never have seen anything about this case before on your social media feed, you cannot control what may pop up. You should also remember that use of these platforms can be public and traceable, and any searches undertaken or information received by you can and likely will be discovered. So please be extremely cautious. If you inadvertently see something about this case, please disregard it and let us know. As best as you recognize them, please have no contact with any of the participants in this trial or anyone associated with either side, including the lawyers. Please do not visit any locations that may be mentioned during the trial. We'll go on a view, as I told you, and I'll discuss that with you before we go. Remember, you were instructed that you must not, and you assured us that you would not read, watch, or listen to any account of any aspect of this case in any news media, social media, or from any other source. It is critical that you follow that instruction. Finally, please continue to keep an open mind. I know that you will try this case according to the oath that you've just taken as jurors. When you took that oath, you promised that you would well and truly try the issues between the Commonwealth and the defendant according to the evidence and the law. If you follow that oath, approach this case with an open mind, and make your decisions fairly and without prejudice or bias or sympathy for anyone, then you will arrive at a true and just verdict, and that's all we ask of you. So it's now time for the opening statements. Mr. Brennan.
It was like 30 minutes of
Thank you, Your Honor.
preliminary instructions. Here we go. What's he got? Are his palms sweaty, you think? Yeah, they are. Why he's rubbing them.
At 6:04 a.m. on January 29, 2022, the alarm bell sounded in the Canton Fire Department. Firefighter Paramedic Timothy Nuttall knew what that meant. His heart skipped a beat. He raced to his equipment and he picked up his bag, which was meticulous. There was a sign and a signal, and then there was a voice commanding that there was cardiac arrest. The most serious of calls for a firefighter and paramedic, that means that a person's heart has stopped. He didn't know who it was, he didn't know where it was, he took his bag, he had just gotten to the station, and he rushed to the ambulance. He was one of the most senior paramedics that morning. Another paramedic, Anthony Flamati, would be running this mission. He jumped in the back of the ambulance, the door shut, and they headed off to 34th Fairview Road. As they drove, firefighter Nuttall could not see anything. He couldn't hear anything other than the engine of the ambulance. He could feel it sliding across the road. It was near blizzard conditions. He calmed himself, he steadied himself. This is what the firefighters and paramedics are trained to do, to focus. And he focused on his task. He looked around the back of the ambulance to make sure that all the tools were in place. The ambulance was meticulous as well. This was Anthony Flamati's ambulance, and it was well stocked. He calmed himself and he thought about what was going to happen. What should he be looking for? What is his next steps? He played the scenarios through his mind, and eerie calm was above him. As the car pulled up to 34th Fairview, the ambulance, he stood at the back door, the doors open, and he stepped out into Bedlam. He could hear a woman screaming and shrieking, the cold, hard air slapping on his face, and the wind, blizzard conditions swirling around him. You will hear him tell you how he trudged towards those screams in the darkness to snow. And when he got there, he saw 3 women surrounding a man lying, not moving on the ground. He walked up to the man and he reached down and he tried to find any signs of life, pulse, anything. And he found nothing. And he got up and he walked over to the woman, and he walked over to that defendant, Karen Reed, and he told her that he thinks that that man is gone. And then he heard the yell from Anthony Fomati, the chief, and he said, come back, let's go. Because you'll learn that in the cold, even if somebody's heart stops, even if they are presumed to have passed, sometimes you can still save a life. So you'll see on a dash cam video, you'll hear through testimony, he went back to that man who's John O'Keefe. He went back to him, and that crew, coordinated effort, they did everything they could to save his life. They got on their knees, they began CPR, and firefighter Nuttall will explain as he kneeled over John O'Keefe, he looked up, and the defendant approached him, and you'll see it on the video. Now, he wanted any information, because when you're trying to save someone, you want to know, are they on drugs, medication, do they have a heart condition? And he looked up at Miss Reed, and he said, what happened? And you'll hear her words through firefighter Nuttall. She said, I hit him, I hit him, I hit him. And it was at that time, with the words of the defendant, that she admitted what she had done that night, that she hit John O'Keefe. Now, those words didn't mean anything to firefighter Nuttall. They weren't in context, they didn't reconcile with the injuries, it didn't help him in his treatment, so he ignored it. Now, firefighter Nuttall is not a police officer. He is not an investigator, he is not a detective. He's a first responder. And so he takes that information, it was useless to him, he continues to work on John O'Keefe, trying to save his life. You'll see the team put him on a stretcher. And when they lift him from the ground, even though there is snow accumulating, underneath John O'Keefe is simply grass, hard, brown, frozen. And beneath his body lay his cell phone. They bring him to the ambulance, and while they're bringing him to the ambulance, you'll see on the videos that other first responders speak to the defendant. One first responder, Mr. Fomati, she will say, I hit him, oh my God, I hit him. And then she was interviewed or asked questions for background information, not a criminal investigation, just background to try to help John. And she was asked questions about his background, and during that conversation, you won't hear her see the defendant with a person by the name of Jen McCabe and a firefighter McLaughlin. And she tells Fire McLaughlin, with her first responder, I hit him. They bring Mr. O'Keefe to the Good Samaritan Hospital, and his body is cold. The doctors work feverishly. They treat him, trying to save him. They try to warm his core. And unfortunately, firefighter Nuttall's first instinct was accurate. John O'Keefe passed. So why are we here today? We are here today because John O'Keefe was killed by the actions and conduct of that defendant, Keri Reed. You will learn through this case, through facts, science, and data, you will learn that on January 29th, 2022, when the defendant and Mr. O'Keefe were in front of 34 Fairview Road, all the way to the left side in a dark corner near a flagpole, you will learn that Mr. O'Keefe got out of the car. He got out and he stood by the side of the road after an argument with the defendant. That argument, that anger fueled by heavy intoxication, you will learn from the science and data as he stood by the side of the road, the defendant in her SUV drove away. She drove at least 35 feet away, the argument was over, it had ended. But then she stopped. She stopped, she put the Lexus into neutral, and she waited for 2 minutes. And the facts and the science and data will tell you that despite the fact the argument was over, she then put the Lexus into reverse, put her foot on the gas pedal, and began to press, not 25%, not 50%, up to 75% acceleration. There was a light dusting of snow, the Lexus tire spun backwards, she went backwards at least 70 feet, she clipped John O'Keefe, he fell backwards, hit his head, broke his skull, and there he lay at the corner of Fairview Road, on the ground, lying on top of his cell phone, alone. And then the defendant will later tell that when she left, he didn't look mortally wounded, yet he was. And she simply drove away. Now, before I tell you about the data and the facts and the science, and I walk you through that, I'd like to tell you a little bit about John O'Keefe. John O'Keefe was a young man, a local kid, very well liked, loved. John O'Keefe is the son of Peggy O'Keefe, John O'Keefe Sr., and the brother of Paul O'Keefe. Grew up in Canton, worked hard, he became a police officer. But what you're going to learn, the fact that he worked for the Boston police officer, as a Boston police officer, was just a fraction of his life. It was a small, really unimportant part, because the biggest part of John O'Keefe is he was a family man. Not in the traditional sense. You see, John O'Keefe never had biological children. John O'Keefe was never married. But John O'Keefe had a sister, and she had 2 children. And when the children were 6 and 3 years old, his sister unfortunately died. And shortly after, his sister's husband died. And John O'Keefe was a help. He didn't sit by. He saw these 2 recently orphaned children, and he stepped in and he said he was going to raise them. So he put aside his career, he put aside his job, and he moved in with the children and raised them like they were his own. They were his passions, his love. He was a new parent, successes, failures, like all parents. And he raised the children with the help of people in the community, with the help of his brother, with the help of his family. And they led a good life. Enter Karen Reed. Around COVID, the defendant and Mr. O'Keefe reacquainted, and they started a relationship. And you'll hear that even though the defendant had her own home, she was staying with Mr. O'Keefe a lot, 4, 5, 6 times a week. And to most of the world, it was a pretty good relationship. They spent time together, they did activities with the children together. She helped with driving the children, feeding the children. It was a steady relationship until about the beginning of 2022. And then things began to unravel. There was tension, there was arguments. In fact, just a few days before this incident, you'll hear that Mr. O'Keefe asked her to leave, but she wouldn't. You're going to be able to read text messages of their conversations on January 28, 2022, and you will see the tension and the unraveling of the relationship. You will read about the discord between the defendant and Mr. O'Keefe. You will see that when he would ignore her calls, they would become incessant. When he would try to push away, she would come closer. You will read those text messages and you will realize that this was the beginning of the end of this relationship. That night, they decided they would go out together. I want to tell you something about data and science before we get to that night. I mentioned that underneath John's body was a cell phone. A cell phone is an amazing piece of technology. It is like a computer. It carries extraordinary data. And when they found the cell phone, the only contained John O'Keefe that night, they studied the cell phone, and there'll be some remarkable data that you will use in this case to find the truth. I want to mention 3 different things you will find in a cell phone that are critical to this case. The first is called location data. Waze we've all heard of, Google Maps. Well, at some point that night, John put his Waze on, and Waze is like a breadcrumb that will show exactly where the phone goes second by second. It is the strongest, most accurate location data that you can have. And that night, John was using Waze. It also will have healthcare data. Healthcare data will show when somebody is moving. Sometimes it's qualified as steps, but it doesn't necessarily mean somebody's stepping, moving their arms, walking, turning. It doesn't show what direction or how far, but it shows movement of a person. Healthcare. And the third thing, remarkably, there'll be an expert in this case who found a data file on the phone, and it tracks the temperature of the cell phone battery. That will be critical to your analysis in this case, the temperature of the cell phone battery. And so with that, I want to take you back to the timeline of that night. After the discord, both the defendant and Sir O'Keefe decided they would meet at a bar called McCarthy's. Now, McCarthy's is a local bar of visitors pending, and people are getting together in a celebratory mood. They go to McCarthy's and you see a video of McCarthy's, and you will watch both Sir O'Keefe, friends, and the defendant drinking alcohol. And you will count 8 vodka drinks that the defendant drank. They arrive at 8:50.
That's not 11 anymore?
9:45. She consumed at least 7 of those drinks in less than 2. The last drink, you'll see when they leave the bar, she puts it under her jacket, and they walk out and they go to another bar to meet other friends called the Waterfall. They reach the Waterfall sometime around 10 p.m. And when they go into the Waterfall, you'll see a video. And when I said celebratory mood, you will see a group of friends of John O'Keefe, many who are friends with Karen through John, and you'll see them clapping and happy and joyous that they're there. You'll see many hugs between John O'Keefe and his friend and the defendant and many of the people there. And they spend some time together, they're drinking, and they all do a shot. And that will be at least the 8th drink within 3 hours that you consume. You will see from the data, not just the cell phone data, but there's some other very important data. And the other piece of data that goes hand in glove with the cell phone is information on the defendant's Lexus vehicle chips. You might have heard of black box in an airplane, or there's some type of event that captures a small amount of time. Well, that was captured in the defendant's Lexus. That black box information with the cell phone data will tell you everything you need to know in this case. It will bring us step by step through the entire night to the death of John O'Keefe. And so they leave the Waterfall bar at 12:12, and you'll see that the ignition goes on to the defendant's Lexus. And both John O'Keefe and the defendant in the car, and they decide that they're going to go back to 34 Fairview Road, what we talked about earlier. They're going to go there for a get-together for one of the homeowner's sons who's having a birthday party. And so as they drive back, we'll be able to follow them to this location data. When they go back to Fairview, they don't know exactly where it is, and they get lost. And so John O'Keefe makes a phone call. Has a phone call with one of his friends, Jen McCabe. And during that phone call, which the defendant listens to because she recounts it, and trying to get directions, Jen McCabe tells John O'Keefe, it's near Bella's mom's house. You'll learn that Bella, or her mom, is somebody that John had dated before the school. And so as they make their way through Fairview, you will see there's a road that comes down like a loop and that leads to Fairview. They take a wrong turn loop, and then they do a 3-point turn in the driveway. You'll see the exact precise driveway they turn into because some type of acceleration movement triggered that black box in the Lexus. And that's important because that's 7 minutes before the collision. And you'll see from the waves exactly where the car was. You'll see from the black box the event of the 3-point turn in the driveway, and then a return down to Fairview. But before they get there, at 12:23, a truck is coming the other way. And the witnesses in that truck will say they blinked the lights. One of them saw a man and woman in the car, John and the defendant, and then they followed the Lexus because they were going to the same house. The truck stopped at the driveway, and the Lexus, the defendant's car, you will hear because of the waves and be counted second to second, never stops. It rolls very slowly all the way to the end of the yard in the corner where there's a tree line and a flagpole. And they reach that location at 12:34:33. And they're in the car and they stay there. The truck waits, they speak to somebody in the house who comes out, the person goes back in the house and they're there for about 5 minutes. We're now down to 2 minutes before the collision. The truck leaves, and now it's just the defendant and John. And while they're waiting outside at 12:27, John gets a text from Jen McCabe, park behind us. driveway. 12:29, she texts again, are you coming in? You'll hear that Jen McCabe and others look out the window and see the defendant's Lexus in front of the flagpole at the far end. It's snowy, it's dark, it's windy, they're waiting. You will know that John O'Keefe was in that car, that Lexus, and didn't move because his healthcare data is not moving. It's not moving until 12:31:56. At 12:31:56, he begins to move. He will have 20 seconds before he falls. 20 seconds. He gets out of the car, the Lexus, and in that 20 seconds, you'll hear that user initiated. He looks at the phone, at the text message from Jen McCabe. It's now 12:32:09. He closes the phone the last time. It will be the last time he uses that phone. From the waterfall bar, you see that he's in that pocket. And at that time, 12:32:09, last user, he has 7 more seconds he will move before he lies dormant the rest of the night. We'll also have the information from the defendant's Lexus black box. The clocks run differently, there's a 30-second variance, but it's right in the heart of that time. And you will see in the data at that time, when he makes his last movements with the phone, is when her car leaves 34 feet at least, stops, neutral, and then shoots into reverse with the tire spinning right towards him, right where he got out. You'll know they're arguing because the next morning she tells the firefighter, I'm sad because our last moments were fighting. She drives away. They said he's made later statements that when she left, he didn't look mortally wounded. He lied on the ground on top of his phone, light dusting of snow, the snow now picking up. And he's just there. It's 12:37. Now, when he's in the car, before he gets to Fairview, the battery temperature of that phone is 77 degrees. 77 degrees in the warm car. Now that he's been outside the car for 5 minutes, drops to 72 degrees. She drives to his house. She makes a phone call at 12:33 after she's left Fairview. She calls again at 12:36:33 and leaves a message. You'll hear it. And you will hear the anger and rage in her voice. She leaves a message. John, I fucking hate you. Pardon my language. You will hear the simmering. When she leaves that message, he lies on the side of the road. He gets another text message that's unanswered from Jen McCabe. Where are you? 12:45. Battery temperature, 61 degrees. So, he gets almost 40 calls from the defendant that night. His phone rings, but he never answers. You'll hear from an expert that the light never initiates, the healthcare data never holds. John alone with his only companion, his phone. At 12:53, cell phone drops to almost 60 degrees. 12:59, the defendant leaves another message on John's phone. Now, she hasn't spoken to anybody. Nobody has spoken to her, but her message is telling. You'll learn the message says, John, nobody knows where you are. And this is where the plot in the cover-up begins.
No.
The evidence will make clear that she knew he was there, but she did not call 911. She did not go back to him. She did not leave an anonymous tip. She left him. The night wears on. It's now 1:07. Battery temperature 55 degrees. 1:14, she calls her mother, no answer. 1:14:53, battery temperature 50 degrees. The defendant had healthcare data on her phone as well, and you'll hear that it stops around that time. And you'll later learn that she admits to falling asleep and passing out. But then she wakes. It's 5 o'clock, she is frantic. She wakes up John's niece, and she is unintelligible. She is yelling, she's screaming, she asks for the niece to call Jen McCabe. She calls Jen McCabe, and you'll hear Jen McCabe recount out of a deep sleep. She wakes up and she hears, Jen, 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 screaming Jen's name. John's dead. Hangs up the phone. Jen McCabe calls down. And then she, what's going on? And she told, well, I left him at the waterfall. At the beginning of her. She tells Jen McCabe, I left him at the waterfall. Jen calls back and says, he saw you up front. You didn't leave me at the waterfall. She hangs up. He then minutes later calls another person, Kerri Roberts, a friend of John O'Keefe. Someone who's not friends with the defendant, but they know because they helped raise the kids and they interacted. She had nothing to do with the night before, wasn't at the bars, was home with her family. She calls her and says, I think John got hit by a plow. I think he's dead. Now, Kerri, with that information, calls 911. She calls hospitals, you can hear her voice. She's concerned, not dead. And then she gets another call from the defendant. And she tells the defendant, come to my house. I will help you look for him. And the defendant says, I was so drunk last night, I don't remember anything. Waiting for her to arrive, she learns she doesn't arrive. Instead, the defendant goes to Jen McCabe's house. Kerri Roberts, the other friend, then goes to Jen McCabe's house, pulls behind the car. And when she does, she's on the Bluetooth, and she can hear the defendant say, my taillight's broken, my taillight's broken. And she looks, and the snow packed in the right taillight, she can see a piece of the taillight missing. The defendant desperately wants to go to 34th Fairview Road, but Kerri Roberts takes over and says, we're gonna go back to John's house. Maybe he's in the house and you didn't see him. So both cars, driven by Kerri Roberts and then Jen McCabe, with the defendant, go back to John O'Keefe's house. You'll see a ring video where you see them go into the house and they look around, and you'll hear about the woman, Jen and Kerri, enlisted into this task. Look for John O'Keefe, they cannot find him. And then when Kerri Roberts comes into a room, she sees, rather than looking, the defendant simply standing there, staring at the wall. At that point, the defendant insists they got to go back to Fairview Road. They decide to take one car. Kerri Roberts is taking charge. She's going to drive. They leave Mr. Lexus and John O'Keefe's driveway, and they drive back towards 34th Fairview Road. You'll hear it is blizzard-like conditions. It is dark. They can barely see a thing. And when they get close to the edge of 34th Fairview, you hear the defendant start to scream, there he is. Both women look and they can't see anything. She starts kicking the door. The defendant's kicking the door, let me out. Kerri Roberts stops the car and lets her out, and she sees the defendant run exactly to where John O'Keefe is in the darkness. Just where she left him. Kerri gets out of the car, starts to walk towards where the defendant is, and she sees the defendant lying on a body. She can't tell who it is because the face is still covered with snow. And she comes over and looks, and she wipes off the snow from John O'Keefe's face. She realizes it's one of her best friends in the world, is John O'Keefe. And she starts to try to do first aid. They start to move him, and coincidentally at 6:06, when they start to move him, the cold air hits that cell phone battery. It drops from 50 to 43 degrees. And they try, Jen McCabe calls 911. And that's when a police officer arrives, Firefighter Nuttall and his crew. And when they lift him, that cell phone battery that is shut down to 37 degrees, Kerri Roberts picks it up and puts it in her pocket, and it immediately starts to warm. As she moves to help get a data, showing movement starts again. At that point, nobody knows what happened. The Canton Police Department come. You can see the police cars and cruisers. They're not sure, so they look in the area where John's body is and find a glass from the bar near his body. They find blood spots. They try to put the blood spots in plastic containers. They don't know what they're looking for at this point. There's no information. They don't believe or know that there's a crime. They just know that John O'Keefe somehow ended up here with the broken glass and the blood. And so that morning, you can see the work of the Canton Police Department try to uncover a little bit around his body to see what they could find, which was very little. And then Kerri Roberts goes and picks up Jen O'Keefe, tells her the news, and they go to the hospital. They go to the Good Samaritan Hospital, and Kerri Roberts is walking, and Peggy O'Keefe is going to go see her son with her husband. And as she walks down the hall, Karen Reed is also in the hospital. See, there was some reports of maybe she was upset or suicidal, so they sectioned her. They put her in for evaluation to make sure she was safe. You'll hear Peggy O'Keefe tell her she walked down the hall to go see her son. The defendant was screaming, "Is he dead? Is he dead?" As she walked by Karen Reed, she stopped and she said, "Karen, what happened?" And you hear that Karen was excited and yelling, "Is he dead?" She stops her excitement, comes going, doesn't say a word. Peggy pays respects to her son, and then she has to go back home because she has to tell the children. Now, while she's out, the Canton Police Department sent an officer to the house to make sure the children are safe because they're alone if they're home. And when the officer pulls in, he doesn't notice anything, but you'll see in the dash cam video notices something. That tail light has a big missing piece to it. They can't find the children. Ultimately, Peggy comes home, a friend can take it down, and they bring the nephew home, and he is distraught. And then Peggy hears a knock on the door. It is the defendant and her father. They want to come in. They come in, open door, Mrs. Peggy, and they ask, "Can we go upstairs to John's room?" And she's busy consoling her grandson. They go upstairs, they're upstairs for about 15 minutes. They come down, and quickly they leave. Now they got there from the defendant's father, drove his wife and the father to that house. But when they leave, they take two cars. They take the Lexus with the broken taillight with them back to the defendant's father's house. And you will learn that when police start getting some of the information, they learn about the broken taillight, they learn information that she had told people that she had hit him. They went down to see her. And on their way down, they decided they would get a warrant to take the Lexus. When they get down to Dighton, where the car is, you'll hear from Trooper Buchanan, who took a look and you can see the missing taillight. They went in and spoke briefly to the defendant. They took the car, they brought it back to Canton. And so what you'll learn from the forensic evidence that will help with the science and data is that not only was the cell phone left behind, but also around that area, broken taillight was littered around John O'Keefe's body. Littered around that area. When they got to the hospital, they noticed there was a shoe missing. As time went by, snow melted, they dug the excavations, they found the shoe on a little berm on the border between the street and the grass. You'll learn days later when they did a plant excavation, they found his cat frozen into the ground. Ultimately, they would find over the course of 10 days that the snow melted almost all every piece of that broken taillight in that area. The hat, the sneaker, the glass. When the defendant left Mr. O'Keefe behind, he took with her something of Mr. O'Keefe called trace evidence. You'll learn the back of her Lexus around the taillight area was John's DNA and stuck to the side, grasping one last piece of John O'Keefe's hair. Now, John O'Keefe fell backwards and hit his head after he was clipped by the car. And you're going to hear from a very renowned doctor and neurosurgeon who has treated thousands and thousands of head injuries. And the wound on the back of the head, when he fell backwards, not only cracked the skull, it's called a basal fracture. It created an injury called counter-coup. After he was put by a car and fell backwards and hit his head on that hard rock ground, remember there's no snow, it's just a dusting at this point, the back of his brain hits the back of his skull and bounces up. When it bounces up, it leaves marks showing that impact. And this neurosurgeon will tell you, he treated thousands of patients, that this injury, to a reasonable degree of medical certainty, is counter-coup caused by falling backwards and hitting your head. When the medical examiner for the state looked at it, they generally said blunt force trauma. They had it as undetermined. So we brought it to the renowned neurosurgeon who does exactly this. You're also going to hear from an accident reconstruction. His name is Doug Welch. He does not work for the state police or local police. He was hired to take a look at this case and the data. He will come in and explain to you exactly what I talked about, how the data from that black box coincides with the cell phone and the movements of the car, the moments before, during, and after the defendant struck John O'Keefe with her car. Now, just a few more things I want to share with you. There are 3 charges against the defendant in this case. The first one, second-degree murder. When most people hear murder, they instantly think shooting somebody, stabbing somebody, putting a little bit of premeditation. Or I will instruct you on the law. I'm not going to trample in that area, but I can tell you clearly, we are not going to try to prove that Kerri Reed tried to kill John O'Keefe. We're not going to try to prove to you that she intended or wanted him dead. That's not second-degree murder. What we will prove to you is she engaged in an intentional act, driving back at him at that speed in the storm, in the darkness, knowing that he had just gotten out of her Lexus. She intended that act, which would cause a plain and strong likelihood of death. That's what will prove to you second-degree murder. Also, operating under the influence of alcohol, manslaughter will prove to you that she drove her Lexus recklessly. She hit John O'Keefe, and because she hit him and he fell back, she caused his death. The third charge is leaving the scene after knowingly causing death. Again, she hit Mr. O'Keefe with a car. She knew he was injured. She left him behind. He died. That's the whole group. This case will come down to the science and the data. The science and the data that the cell phone is the best of historians. It doesn't suffer from intoxication. It doesn't suffer from memory loss. It doesn't suffer from emotion, pride, or prejudice. It is facts. It is data. And that facts and data will lead you to the truth in this case. But after Ms. Reed was charged, she began what you'll learn as a campaign to make public statements. 2020, Nightline, Fox 25, a documentary. And we've had an opportunity to get many of her statements in the footage, and we're going to show much of it. And her statements to you will confirm what you already know from the science and the data, what you will already conclude from the facts independent about what she did that night. Her word simply confirmed that her judgment is sound. And you're going to hear from her own lips in many of her statements, her admissions to extraordinary intoxications, her admissions to driving the Alessi, her admissions to being angry at John that night. And I dare say her admissions that she told shit. I'd like to play for you clip 1. You're going to hear the first of the statements that she made after she was charged.
I mean, I didn't think I hit him, but could I have clipped him? Could I have tagged him in the knee and incapacitated him? He didn't look mortally wounded as far as I could see, but could I have done something that knocked him out and in his drunkenness and in the cold didn't come to again?
And this would have been the moment you dropped him off at the party.
Yeah, would have had to.
Ladies and gentlemen, I simply ask you to follow the evidence, follow the science, follow the data. Ignore speculation, surmise, conjecture. Stay true to the evidence. It will lead you to the truth. That on January 29th, 2022, a very intoxicated defendant was angry and arguing about the relationship with John O'Keefe. And after the fight was over, she left but she brought the fight back to him in the form of her SUV. She clipped him, he fell backwards, he broke his head, and then this man who helped, a lifetime of help, was left at the corner of that yard, left to die with no help. The facts, the data, and the evidence will bring you to the truth, and the defendant's own words will confirm everything you've already concluded.
Well, interesting trying to appropriate facts and data.
But I have just a moment to readjust.
Sure, the court officers will be kind enough to help you.
That's a bold move to try to claim the facts and science and data. We'll see how that goes.
May I, Your Honor? The evidence in this case will establish above everything else 3 points. There was no collision with John O'Keefe. There was no collision. There was no collision.
Is that the
John
3
O'Keefe
points?
did not die from being hit by a vehicle, period. The facts will show that. The evidence will show that. The data will show that. The science will show that. And the experts will tell you that. You'll learn that the Commonwealth has pinned its entire case on a brazen and a flawed assertion that is untethered, unconnected to the facts and to the evidence. And their assertion is contrary to science. Because at the end of the day, folks, there was no collision with John O'Keefe. So how did we end up here? How does Karen Reed end up sitting in that chair on trial for something, for an event that literally never happened? Well, the evidence is going to explain it. And it can be summed up in the following text message at the very beginning of this investigation. Mm-hmm. A text message of a now fired Massachusetts State Police officer named Michael Proctor. He was the lead investigator on this case, and he was talking about a fellow officer, a fellow cop who owned the property where John O'Keefe's body was found. Text message with a buddy. Question, is the homeowner going to catch any shit? Answer, nope. He's a Boston cop too. That quote defines the lack of integrity of the Commonwealth's entire case, its entire investigation, and this prosecution. During the course of this trial, you'll learn much more about Mr. Proctor, why he said that, and what it really means. What you'll see and hear in this courtroom in the coming weeks is not just a story of a tragic loss. And make no mistake, John O'Keefe's death is and was a tragic and tragic loss. But the story you'll hear is about an investigation that was riddled with errors from the beginning, a rush to judgment, conflicted and corrupted from the start. Corrupted by bias, corrupted by incompetence, and corrupted by deceit. Finally, it was corrupted by a deliberate effort to avoid and to cover up the very truth that you are seeking. Mm-hmm. You'll find when you hear the evidence that the Commonwealth's case is the literal definition of reasonable doubt. They won't be able to talk their way out of it. They won't be able to explain their way out of it. They won't be able to excuse their way out of it. And they can't meet their extreme burden of proof, which the court will tell you is beyond any and all reasonable doubt and to a moral certainty. Members of the jury, Karen Reed found John O'Keefe dead on the front lawn of a Boston police officer, Brian Albert, at 6 a.m. on January 29th, 2022. Picture the scene. Blood-curdling screams, ambulances, emergency lights on, fire engines, ladder trucks, paramedics, patrol vehicles, patrol cruisers, police officers, first responders, firefighters, all swarming all over Brian Albert's lawn, literally feet under his bedroom window. Yet Brian Albert, a sworn peace officer, a first responder himself, never came outside. Never went outside to see what the chaos was about, never went outside to see if he could assist a man in need, never walked outside his house to see if he could help a fallen fellow officer on his own front lawn. More shockingly, you'll learn that lead investigator for the Massachusetts police, Michael Proctor, never set foot inside Brian Albert's house that day. Never engaged in any investigation inside that house that day, even though a party with much alcohol had just occurred in that house, and even though a Boston police officer was found dead or dying just mere feet from the front door on that lawn. He never secured the crime scene, never separated and secured witnesses. He never properly collected evidence. He never secured the evidence. He never searched for signs of a struggle inside or outside the home. He never properly canvassed the neighborhood. Michael Proctor never did any of these things, even though fellow officers of Michael Proctor's actually mentioned, in their words, not mine, that it looked like John O'Keefe may have been, quote, in a fight. You'll have questions about that conduct. During the course of this trial, you'll find that the Commonwealth will not have answers. You'll see from the evidence in this case that this case carries a malignancy, one that is spread through the investigation. It's spread through the prosecution from the very start, from the jump. A cancer that cannot be cut out, a cancer that cannot be cured. And that cancer has a name. His name is Michael Proctor.
Michael Proctor. Ooh.
Now, you didn't hear his name in the prosecution's opening statement. Not once. And I suspect that was probably by design. But make no mistake about it. The evidence will show in this case that Michael Proctor is the very definition of the Commonwealth's case. And he's also their Achilles heel. He was the lead investigator on the case officer, the architect of the entire prosecution. You'll learn there's not a single part of this case, folks, not a single part that he didn't touch, that he didn't direct, that he didn't orchestrate personally. Every single bit of it has his fingerprints on it. You'll learn that Michael Proctor was a longtime family friend of the Alberts. And he's been disgraced by his own agency, not by us, by the Massachusetts State Police. Investigated, suspended, and fired. The evidence will show that Massachusetts State Police found Michael Proctor guilty of bringing dishonor to the department for his conduct, not in some other case, not in some tangential case, in this case. The investigation of Karen Reed. Conduct that included bias in favor of his friends, the all-powerful Albert family, and bias against my client, Miss Reed, the outsider. Do you have any idea how hard it is for a state trooper to get fired? Mm-hmm. Well, the evidence is going to show that Michael Proctor earned it. Ooh. Every bit of it. You'll hear that within hours of a Boston police officer being found dead on Brian Albert's lawn, Michael Proctor, the lead investigator, who had investigated exactly nothing up to this point, right at the beginning, made an early pronouncement that Brian Albert himself was not going to, quote, catch any shit, end quote. And that was for one reason and one reason only. He's a Boston cop. The evidence will show that Michael Proctor made this statement in a text conversation with his high school buddies. A text he never thought would see the light of day, certainly never thought we would get a hold of. And when he thought no one was looking, he actually said the quiet part out loud. He's a cop too. We'll give him a pass. You'll learn that in Michael Proctor's world, rank has its privileges. And the evidence will show that's privileges that you don't get and I don't get. But apparently a Boston police officer, Brian Albert, and his friends, they do get. You'll learn that in Michael Proctor's world, he didn't care about finding the truth. In his world, his priority was to protect the brotherhood, to protect that blue wall, to protect his friends who were at the Alberts' house that night. I want to take a step back, if I could, and spend the next few minutes talking a little bit more detail about what the actual facts in this case will show, not based on speculation, not based on surmise, not based on guesswork or conjecture, but the actual true facts that you will learn through the course of this trial. On January 28th, 2022, it was a Friday night. John and Karen had made plans to meet up with friends for drinks. It was a happy and normal night for them. They were affectionate, they were loving, they were in good spirits, nothing out of the ordinary. They started at a local watering hole called C.F. McCarthy's. You've heard that name before and you'll hear it again. And eventually they made their way over to the Waterfall Bar and Grill, another bar where they ended up. When they got to the Waterfall Bar and Grill, the Albert family was already there, already heavily drinking. You'll learn that this was no ordinary family, the Alberts. The Albert family was a well-known Canton family. Some might even describe them as a very powerful Canton family. Brian Albert was there at the Waterfall. You'll hear that he's a longtime Boston police officer. His wife, Nicole Albert, was there with him. His brother, Chris Albert, a powerful Canton politician. He sits on the select board. The select board actually governs the police department, the Canton PD. He was there. His wife, Julie Albert, was there. Their daughter, Caitlin Albert, was there. His sister-in-law, Jennifer McCabe, was there. Her husband, Matt McCabe, was also there. They were all there drinking before John and before Karen ever arrived. You'll learn that a man by the name of Brian Higgins, also a law enforcement officer and longtime friend, longtime pal of Brian Albert, he was also there. And the two of them, the two Brians, had been drinking most of the night together. You'll see video footage from the waterfall, which will show you that Karen and John were happy. They were affectionate. They were caring. They were loving. Just business as usual, out on a date on a Friday night. But that exact same video footage which lead investigator Michael Proctor plainly chose to ignore that video footage. It paints a very different picture of Brian Higgins. You'll learn that Higgins had romantic designs for Karen. That becomes important. Brian Higgins had engaged Karen in flirtatious texts, but days earlier she had put a stop to it. She had ghosted him in common parlance. In other words, just ignored him. The evidence will show that the first time he saw her and was in her presence after being rejected by her was when she walked into the Waterfall Bar and Grill along with her boyfriend, John O'Keefe. At 11:58 p.m., just minutes before John ultimately arrived at the Albert residence, you'll see a video at the Waterfall of an unsettling interaction, troubling interaction between Brian Higgins and John O'Keefe. And unlike the lead investigator, Michael Proctor, in this case, you won't ignore that evidence. As the bar was closing around 12 midnight, the Alberts invited everybody back to their house for a get-together to just keep the night going. And you'll learn that Karen and John ultimately pulled up to the house. They got out of the SUV to make sure they had the right address. You see, neither John nor Karen had ever been to 34 Fairview. They weren't even sure they were at the right address. And the evidence will establish that John got out of the SUV and went into the house. Let me say that again. The facts unequivocally, the data, the science, the witnesses will all unequivocally establish that John O'Keefe went into the Albert home that night. Eyewitnesses and forensic data will establish that fact. When he didn't come back out, you'll learn that Karen grew increasingly frustrated. She got upset. She was left alone in a car, in the cold, in the middle of the night, with the car idling. John had gone into the house. She expected him to come right back out. And when he didn't, seconds turned into minutes. and minutes started to clock away. She left John a voicemail, then another voicemail, voicemail after voicemail after voicemail, text messages. But he was unresponsive. He didn't pick up a single call. He didn't respond to a single text. The longer he didn't respond, the more upset she got. The Commonwealth will intimate, as they already have in their opening statement, that these voicemails are evidence that the two were fighting. The actual evidence in this case, however, will show the exact opposite. You'll hear that Karen was very agitated. You'll hear some voicemails where she's swearing. You'll hear voicemails where she calls him names. There's name calling. But you'll also hear the context of those voicemails. And every single one of those voicemails was left for John after he failed to come back out of the house, after he failed to respond to her voicemails and to her texts. Karen believed John had just left her sitting there, grabbed a beer, was partying with his friends. The evidence will actually show that John and Karen never had a crossword, not a single crossword that entire evening before he left that SUV and went inside the house. And you will learn what Karen had absolutely no way of knowing at the time. It wasn't that he wouldn't respond to her. It's that he couldn't respond to her. And the evidence will show you why. Let's talk about that. We'll introduce you to a doctor named Elizabeth Lopesada, a renowned forensic pathologist, a medical examiner, and a professor at Brown University. She will tell you that the injury to the back of John's head, first of all, was immediately incapacitating. And that has meaning. At the moment he suffered that fatal head injury, he couldn't walk, talk, grab his phone, cry for help, nothing. He was completely incapacitated, completely unconscious from the moment he suffered that injury. He was completely still and incapable of interacting with anyone or anything. But the doctor will tell you something more, and just as important. She'll tell you that John O'Keefe did not suffer from hypothermia, as the Commonwealth will undoubtedly allege. His body showed no signs of it. No frostbite, no cold-induced injuries to his organs, no damage based on cold or frost. Ladies and gentlemen, the scientific evidence and the medical evidence will establish that John O'Keefe had to be injured somewhere else, somewhere warmer, and his body had to have been moved out into the cold. And that's where, ultimately at 6 a.m., Karen found him the next morning. You will learn that John did not have a single injury consistent with being hit by a car. Let me say that again. The evidence will establish that John did not suffer a single injury on his body consistent with having been hit by a car, not one. You'll learn that John's torso, his ribs, his chest, his arms, his hips, his legs, his knees, his ankles, his feet, all of them, no broken bones, no fractures, no contusions, no torn ligaments, no internal injuries, not even a bruise.
Not even a bruise, except on his hands.
Nothing consistent with a car accident, despite the Commonwealth's contention that he was slammed into by a 6,000-pound SUV. Not a bruise. Dr. Lopesada will tell you with medical certainty that, in fact, John was not struck by a vehicle. Medically and scientifically, he could not have been struck by a vehicle. Therefore, as I said, there was no collision. She will tell you that the patterned abrasions on John's right arm, the patterned abrasions you see over my left shoulder, they're not the result of being struck by a car or a taillight. You'll take one look at these injuries and you'll agree with Dr. Lopesada. The evidence will show that these injuries are from an animal, like a large dog, like the large dog that was inside the Albert house that night. You'll learn that Brian Albert has actually admitted that his large dog, the family dog, is, quote, not good with strangers. And of course, John, never having been to the house before, was a stranger that night. You'll also learn that oddly, very oddly, after having their family pet for 7 years, a short time after this incident, the Alberts got rid of that dog. They called it rehoming her, but she was gone. Dr. Laposado will also tell you that the injury to John's head was not the result of falling backward onto a flat lawn, cold or otherwise. Rather, Dr. Laposado will tell you with medical certainty that the injury pattern to his scalp was produced by an impact from a raised or ledged surface, a surface that does not exist on Brian Albert's front lawn where John was found. The medical evidence will establish no hypothermia, no injuries from a car strike, no collision with a motor vehicle. And forensic analysis of John's cell phone, Mr. Brennan mentioned that in his opening statement. The Commonwealth's own expert will ultimately support the exact facts that I just told you, including the temperature data. John O'Keefe was injured someplace warmer, and he was moved. That alone is reasonable doubt, but there's much more. You'll also learn that there were many people at that after-hours gathering at Brian Albert's house who would have left by the front door just feet from where John O'Keefe's body would have ultimately been, had he actually been there, right after 12:30 a.m., which is what the Commonwealth's claim is. There were nearly a dozen people who walked out that front door directly adjacent to the precise spot where John O'Keefe would have been lying. Not a single person, not one, not a single person saw a 6'2", 216-pound man laying sprawled in the front lawn in dark clothing on a light white dusting of snow. Not one. Then the evidence will also show that every one of those same people drove by that same spot, not walked by it, drove by it to leave the house, and still not one of them saw John laying in the yard when they left between 1 a.m. and 2 a.m. in the morning. But you know who else you'll find never saw a body on that lawn? The snowplow driver, a completely independent witness charged with plowing the streets in Canton that night. You'll hear that Michael Proctor, oh, he's not done yet, Mr. Proctor. You'll hear that Michael Proctor wrote a report where he claimed that Fairview had not been plowed that night. You'll learn that that was completely false. That was a lie. Michael Proctor did not want any more witnesses. He didn't want the truth, and he falsely claimed that the road was never plowed. You'll learn that he wouldn't look for the plow driver, but we did, and we found, and we'll introduce you to, Brian Loughran. He plowed Fairview that night, and what he's going to tell you is that there was no body on that lawn at 2:30 in the morning. You'll learn that Brian Loughran passed by 34 Fairview, traveling right next to Brian Albert's front yard, and at 2:30 a.m., John O'Keefe was not there. But you'll see that the plow driver also provides some other troubling information, troubling testimony for the Commonwealth. You'll learn that after making that pass at 2:30 a.m., he showed up with his plow an hour later. He stopped at the entrance of Fairview. He was looking up Fairview to decide whether or not to plow it, but he saw an obstruction. At 3:30 a.m., he looked down the street, and in the very spot precisely where Karen would later find John's body laying at 6 a.m., there was a car parked in front of it, a Ford Edge. You're going to ask yourself, who's moving a car at 3:30 in the morning into a blizzard on the side of the road? You'll learn that Michael Proctor, the lead investigator, intentionally ignored this fact as well. He did no investigation to find out who owned a Ford Edge, but again, we did. And the evidence will establish that the Ford Edge happens to be a favorite model of the Albert family. More than one Albert owned a Ford Edge at the time. You'll learn that those facts will add to the mounting and the overwhelming evidence that there was no collision and John O'Keefe's body was moved onto that lawn. You'll find that this is yet additional reasonable doubt in the case. You'll be introduced to science and physics even from the Commonwealth's own experts. That science will establish that Karen Reed's SUV was not damaged by hitting a pedestrian, and conversely, John O'Keefe's injuries did not come from being struck by a vehicle. The Commonwealth mentioned triggering events, but what you'll actually learn from the experts, some of them the Commonwealth's own experts, is that a triggering event is not evidence of an accident. It does not evidence a collision. That's why we're here. A collision. And there's no evidence of one. Zero. You'll also find that those exact sort of triggering events that the Commonwealth will rely on are relatively commonplace on Karen's SUV, and none of them are associated with a claim of a collision. Folks, the science will not lie, and the physics cannot lie. And that science will tell you with certainty there was no collision with John O'Keefe. You'll add that to that rising mountain of reasonable doubt. I want to take you back to the night in question, January 29th, for just a few minutes. Remember, Karen had gone home after dropping off John and John walking to the house. While Karen was asleep at home with John's 13-year-old niece, what were the people who had been at Brian Albert's house that night? What were they doing? While she slept, what you'll find and what the evidence will show is that they were extremely busy. You'll learn that after a long night of heavy drinking, Brian Higgins left the Albert residence, but he didn't drive home. Rather, he drove over to the Canton Police Department, where he kept an office at about 1:25 a.m. Not a Canton police officer, but he kept an office there. Why go back to his office at 1:25 a.m.? Why go back to the Canton Police Department at 1:25 in the morning on the night of a blizzard? You'll learn that while there, Higgins made a call at 1:30 a.m. Higgins will later deny that he made that call. You'll find that curious. And his explanation for that late night visit to Canton PD, you'll find that it changes nearly every time he's asked about it. You'll learn that after everyone left Brian Albert's house, Brian Albert actually claimed he had no contact with anybody else except his wife. No contact. Until he woke up the next morning. So he says. Then you'll learn that that too is a complete lie. His phone records establish that he placed a call to none other than Brian Higgins at 2:22 a.m. shortly after Higgins completed that late night visit over to Canton PD. You'll wonder, what did they possibly need to talk about at 2:22 a.m. that night? The evidence will establish that Brian Albert called Brian Higgins first. Brian Albert then disconnected that call when Higgins didn't answer it. Seconds later, Brian Higgins returned the call. Brian Albert then did answer that call. They spoke for 22 full seconds, had a conversation, then they both hung up their respective phones. You'll learn that when they were asked about these calls and conversations, both Brian Albert and Brian Higgins lied about it. Both of them. They said they never had a call with each other. But then ultimately, when they were confronted with their own cell phone records and they could no longer deny the calls, they were asked independently, explain yourself. And they both came up with the exact same explanation: a butt dial. The evidence will make you question, why did Albert and Higgins speak at 2:22 a.m. and why did they both try to cover up that phone call? You'll also learn after this incident and within days of one another, both Brian Higgins and Brian Albert, both police officers, both trained investigators, got rid of their phones. Both of them. And what else you'll learn Brian Albert got rid of? Shortly after this incident, Brian Albert got rid of his house, the whole thing. Just sold it. His childhood home, a home that had been in the Albert family for generations, he literally sold it mere months after this incident. Dog rehomed, phones destroyed, house sold. You'll learn that all these things happened shortly after the incident where John O'Keefe was found unresponsive and dying in Brian Albert's front lawn. And you'll also learn that Michael Proctor looked the other way. He did not investigate any of what I'm telling you. He pre-selected Karen Reed from the start and he ignored everything and everyone else. Let's get back to what was happening with the others while Karen slept. What you'll learn during this trial is that Brian Albert's sister-in-law, you've heard her name before, Jennifer McCabe, she was at the waterfall that night and she was over at the Alberts house that evening as well. She left the after-hours gathering about 2 a.m., a little before 2 a.m., got home around 2 a.m. And you'll learn that according to the Commonwealth's own evidence from a forensic software program called Physical Analyzer made by Celebrite, it's considered the gold standard for forensic tools. You'll learn that a Google search was discovered on Jennifer McCabe's phone. A Google search that Michael Proctor and his investigators never revealed to us, but we found anyway. A Google search that was time-stamped according to their own data at 2:27 a.m., 5 minutes after that 2:22 a.m. call that Higgins and Albert denied having. And that Google search on Jennifer McCabe's phone read, "Hoslong to die in cold." Hoslong to die in cold. Now she misspelled the first word. Hos is supposed to be how, but the meaning's the same.
Hoslong.
How long does it take to die in the cold? Time-stamped 2:27. And then that search was also noted by the same Celebrite program as having been deleted. The evidence will force, why is there a search on her phone? Why is it logged at 2:27 a.m.? When the Commonwealth claims that she first learned of John's death and where his body was hours later at 6 a.m. So what you'll learn is that while Karen slept, here's what was actually happening by some other very busy bees. 1:25 a.m., Brian Higgins makes an unexpected visit to Canton PD. 1:30 a.m., he makes a phone call that he later denies ever making. At 2:22 a.m., Brian Higgins and Brian Albert talk. They both deny and lie about having made that phone call. 2:27 a.m., 5 minutes later, a Google search appears on Jennifer McCabe's phone, Hoslong to die in cold, hours before John's body was ever discovered. A Google search she denies making, and that she later, or at least it was later logged as deleted. Meanwhile, at 2:30 a.m., the plow driver confirms that O'Keefe's body was not on the lawn of Brian Albert's house, not at 2:30 in the morning. And at 3:30 in the morning, that area was obstructed by a Ford Edge like the one the Albert family liked to own. The evidence will show in the meantime, Karen dozed in and out of a fitful sleep for the rest of the night, only to awaken just before 5 a.m. And that's when she realized, in a panic, John had never come home. And you'll see, it wasn't like John to not come home. That morning, you'll see and hear evidence that Karen's emotions had morphed. It'd gone from frustration and anger, which you'll hear in the voicemails, to abject fear. Fear that something bad had happened. The evidence will establish by this time, Karen was panic-stricken. She had a feeling something was very, very wrong. She was unable to get a hold of John. Karen went to go look for him. She got in her Lexus and she backed up to leave her garage at One Meadows. You'll hear a lot about that address, One Meadows. That was John's house where Karen was staying. She backed out of the garage, and during the course of the trial, you'll hear that she actually struck another car with that right rear taillight. During the course of this trial, the Commonwealth is going to desperately claim that Karen Reed's taillight was actually damaged by hitting John O'Keefe. They'll have no evidence of it, mind you, none, but they'll make the claim. We'll show you a video of exactly how that taillight was originally damaged, or exactly what happened at 5:07 in the morning. The facts will show that it was damaged in John's own driveway at 5:07 when Karen backed up and made contact with another car in the driveway. This is 5 hours after she dropped John off and he went into the Albert residence. As a result, the taillight was minimally cracked, but it wasn't completely shattered or damaged or broken. And that's the condition of the SUV when Michael Proctor got a hold of it. That becomes important. You'll hear from an independent police officer, an eyewitness to the damage on that SUV, someone not connected to Michael Proctor or under his control. And he'll tell you that he saw the taillight damaged before it was in Michael Proctor's possession, but it was not completely shattered. And you won't have to speculate how that taillight got cracked originally. You'll see it for yourself. It's on video. You'll learn that part of the reason that Karen's Lexus hit that car at One Meadows is because she backed out looking for him at a time when she was absolutely panic-stricken and grief-stricken. Where was John? Why hadn't he come home? What had happened to him? Is he hurt? Is he passed out somewhere? Her mind was reeling. The evidence will establish she wasn't giving anything away. Everything was on the table. What could have happened to John? You'll learn that when she woke up and he still wasn't home, she was just racking her brain for what could have happened to him. And she was worried about possibly the worst. He'd gotten out of the car. He'd walked to the house. She was confused. And later, when she found him at 6 a.m. on the lawn, where she last saw him going toward the house, her mind started reeling, oh my God, did a plow hit him? Did I hit him? Could I have hit him? What could have happened to him? And that video clip that you saw, out of context, when she said the words, he did not look like he was mortally wounded, she's not talking about at midnight. She's talking about at 6 a.m. when she found him.
Yeah.
That's what she was talking about. Your job will be to make sure that the evidence isn't presented to you too cute by half.
Mm-hmm.
She was saying all those things. Did a plow hit him? Could I have hit him? Did I hit him? She was saying that to herself and to other people. And the Commonwealth, very obviously, will try to seize on that panic and twist this into some admission. But here's the actual truth. That's not a confession. Could I have hit him? Did I hit him? Could a plow have hit him? That's a person trying to make sense of an unexplainable circumstance, a natural concern of a bereaved significant other, a woman desperately trying to piece together what could have happened on this tragic night. John didn't come home. And the evidence will show that Karen Reed never said, I hit him. Never. Not in the background of the 911 recording, not on any dash cam video, not on any audio, not on any police body cam, not to a first responder. It's never mentioned in a single report. It's never reported in a single report from January 29th, not by one person, because it never happened. The evidence will show that there were at least 13 members of law enforcement or first responders and 2 civilian witnesses that were intently focused on what was happening at that scene. They were all over the lawn. They were all over Karen. Officer Sarath, Mullaney, Good, Lank, EMT Nuttall, Flamati, Kelly, Walsh, Woodbury, Whitley, Becker, Robery, McLaughlin, Kerri Roberts, Jennifer McCabe. They were all there, watching and listening. On January 29th, when John O'Keefe was found, not one first responder reported having heard Karen Reed say the words, I hit him. Not one. Not one civilian reported having heard Karen Reed say, I hit him. The facts will show that the first time this improved statement was ever claimed to have been made was some 24 hours later by a single EMT in an interview. Now listen to this, in an interview coordinated by a Canton police detective named Kevin Albert, Brian Albert's brother. And remember, Chris Albert, the other brother, is a board selectman to whom the Canton Police Department reports. And what's more, you'll learn that Katie McLaughlin, that's the EMT, that's the single EMT, the first person to have claimed to have heard this unrecorded and unreported statement, is years-long close personal friends with a young woman named Caitlin Albert. You heard that right.
Those pauses.
Brian Albert's daughter.
Caitlin.
During the course of this trial, you'll become familiar with and you'll realize that the Alberts are indeed a powerful and indeed an influential family. And that will mean something. You'll learn that there are other major problems with the prosecution's case. The evidence will establish that Michael Proctor himself, the lead investigator and architect of this entire case, has a long-standing and personal relationship with the Albert family. Yes, that same Albert family. His sister was close friends with Julie Albert. He personally sat at head tables at weddings, or at a head table at weddings with the Albert family. He entrusted the Alberts with babysitting his own children. You heard that correctly. And yet he was the lead detective assigned to investigate the circumstances of a Boston police officer laying dead on the Alberts' front lawn. That's not just bias, you'll learn. That's not just coincidence. That, folks, is corruption. And you'll see how far it went. Michael Proctor was alone with all the critical evidence in this case, alone with Karen Reed's phone, alone with John's phone, alone with video footage, alone with the taillight material, alone when he claimed to recover evidence from 34 Fairview. He wrote the search warrants, he transported the evidence, he secured it, he submitted it, he did it all. That's Michael Proctor. And he did it without any reasonable oversight. You'll see during the trial that he intentionally lied and fabricated evidence during the course of this investigation. He lied in reports, warrants, he lied under oath. He lied about the time that he actually secured Karen Reed's vehicle. Why? Why would he lie about that? The evidence will give you the answer. He lied because he did not want it revealed that he had access to that vehicle and he had access to that taillight before any taillight fragments were found at 34 Fairview. Appreciate that. He had access to the vehicle before a single piece of taillight material was ever found at the scene. You'll find that there were two searches. The first and second search found zero, nothing. Nothing around John's body, nothing in the street, not one piece of taillight fragment. But once Michael Proctor had that SUV and had the taillight in his custody and control, suddenly items started magically showing up. And not just a few items, 46 pieces of bright red taillight laying in the snow, supposedly found in the exact same spot that was searched not once, but twice by independent officers. It came up with zero. To be clear, you'll learn that before Michael Proctor had access to that taillight, not a single piece was ever recovered at 34 Fairview. That will become vitally, vitally important. And what about those shards of plastic, by the way? What about this DNA that the Commonwealth mentioned? They're going to try to dazzle you with talk of DNA because it sounds so scientific. The DNA was on the taillight, but you'll learn that there was no DNA on the actual shards that they claim came in contact with John's arm. None. There was no blood, no tissue, no skin, no DNA on a single shard of plastic that they claim cut deep abrasions into John's arm, the arm that you saw overhead. The DNA that was actually found, the actual science will show, was found outside of the taillight housing where anyone with access to that vehicle would have touched. And it wasn't just one male's DNA. In that exact same sample, there were 3 men found, John and 2 unidentified males. So unless the Commonwealth is going to shift their theory that that SUV hit 3 men that night, their entire theory falls apart.
Oof.
And speaking of DNA, the evidence will further establish that John O'Keefe's shoe, the one that he was wearing when he was found, was sampled. And that DNA revealed 5. Count them, 5 unidentified males. Recall that the evidence will establish independently that John was injured someplace warmer and had to be moved onto that lawn. 5 unidentified males touching that shoe. You'll also learn that you are not the first person, not the first to hear about the Commonwealth's theory of this case, that John was hit by an SUV. That's their theory. The Commonwealth presented this exact same claim to their own medical examiner, a woman by the name of Dr. Irini Scordi-Bello. And you'll learn that after reviewing what's called a law enforcement accident notifier, with law enforcement's theory of the collision written in it, defined in it, after conducting the autopsy herself, after examining John's injuries in detail, she refused to conclude that John's death was a homicide based on the Commonwealth's presentation and their theory. That's right. The Commonwealth's own medical examiner will not deem the manner of death in this case, a homicide. She won't do it. But they're nonetheless back again trying to present the exact same theory to you in this trial. Again, the evidence will show that that is reasonable doubt. Throughout this trial, the Commonwealth will try to convince you of paranormal events, phones calling themselves, messages deleting themselves, Google searches made and then unmade, evidence magically appearing and evidence magically disappearing. But all that smoke and all those mirrors will not ever reach their burden. Because that's what this case is ultimately about. It's about the Commonwealth's burden of proof.
Good job.
You'll learn that during the trial, the Commonwealth bears the highest burden known to our justice system. They must prove every element of every charge beyond a reasonable doubt and to a moral certainty. And you'll learn that moral certainty means the highest level of certainty known in human affairs. It's not a small thing. They're not going to be able to do that. Not when every piece of this case was handled by a disgraced investigator with a motive to protect his friends, not when the physical evidence contradicts their very theory, not when their own medical examiner won't call this case a homicide based on the exact theory that they're presenting to you, not when the conduct of those in the House and the utter lack of investigation speaks volumes about those who actually have something to hide. By the end of this trial, you'll conclude that Karen Read is not guilty of hitting John O'Keefe with her SUV. There was no collision. She's the victim of a botched and biased and corrupted investigation that was never about the truth, folks. It was about preserving loyalty. You'll find that this case is the very definition of reasonable doubt. And at the end of this trial, we'll ask you to return the only verdicts, all three of them, that are consistent with the evidence, the science, the truth, and justice. Not guilty, not guilty, not guilty. Thank you.
Thank you, Mr. Jackson. Folks, why don't we take our morning recess? About 15 minutes.
Well.
You are muted.
Mute the court there. Oh, guys, what did you think? What did you think? There was no collision. I like it. I like it. I like it. I'm going to go back to Mr. Lally because, or Mr. Lally, I'm already calling him Mr. Lally because I expected more from Brennan. I expected a non-Lally-ish type of argument. And he's a better storyteller than Adam Lally. He was able to, flesh out more of the details and describe them in sort of evocative terms. John lonely in the corner, the cold, all of that drama. But the actual substance of what he gave, remarkably similar, wasn't it, to Mr. Lally? Where was the theme? The only theme I really got from him was facts, science, and data. Facts, science, and data. That's what he is going to hang his hat on. And then Karen Read's words are going to confirm what you will already know from the facts, science, and data. But the only explanation he gave, the only detailing of what exactly are you talking about here? He says generally black box. He talked about ways. And now we have this new information about the phone temperature. This was something we didn't have at the last trial. So this is new information. And they're both going to be claiming that this supports their theory of the case. So according to him, the phone temperature starts to drop beginning at 12:37. The battery temperature is 77 degrees. It drops to 72 degrees after 5 minutes. 72 degrees, isn't that a normal indoor house temperature? I mean, even maybe a little bit warm. I like my house a little bit warm in the winter, except at night. It's got to be cold at night. Like it'll be winter. I'll have the windows open. I got to have a little bit of cold at night or I just won't sleep well. 72 degrees. That's your indoor home temperature. Then at 12:45, the battery temperature drops to 61 degrees. So an 11-degree drop. Now, is this instantaneous? How quickly does this temperature drop happen between 12:37, 12:42, and 12:45? If it's from 12:37 to 12:42, which is the 5 minutes, that's the drop from 77 to 72 degrees over 5 minutes. That sounds like a phone that is reaching the ambient room temperature and then just hanging out there. But then suddenly in 2 minutes or 3 minutes between 12:42 and 12:45, it drops 11 degrees from 71 or 72 to 61. That now sounds like a little bit more of a dramatic change to the outside. So I'm going to be interested in this detail of how exactly, what triggers a measurement to be recorded by this phone. It's clearly not showing like a graph, an actual real-time temperature. It's showing specific points. And so what's triggering those points? Because why would it only fall 5 degrees to room temperature-ish for 5 minutes, but then suddenly over a much shorter period of time drop significantly lower? But then by 12:53, it's only 60 degrees. It's only dropped 1 more degree over 8 minutes. That sounds like maybe it went back inside. I don't know. I'm not sure. It's stabilized for a fairly long period of time. And then by 1:14, it's down to 50 degrees. It took an hour, not quite an hour. Sorry, reading that wrong. It took like 20 minutes for it to drop 10 degrees between 12:59 and 1:14, between 12:53 and 1:14, when it only took 3 minutes to drop 11 degrees between 12:36, 12:37. Sorry, my notes are like a little bit of a mess in this one because of how he described it. 12:37 at 77. 5 minutes later at 12:42, it's at 72. And then from 12:42 to 12:45, it falls from 72 to 61. 3 minutes to lose 11 degrees. But then 20 minutes later, later on in the morning, it barely loses 10. By 1:14, John should have been out there for about an hour. Give it the Commonwealth's timeline, a half hour, right? It seems like they're going back to the 12:45 timeline. It seems like they're actually leaning in to Jen McCabe saying, I saw that car outside, and that's why I sent these text messages all the way up to 12:45. But nobody mentioned that Wi-Fi connection at John's house. It's going to be interesting to see how that plays out this time. So this is what Brennan is claiming as facts, science, and data now. This battery temperature, seems like, and black box. We already know a lot of details of that stuff from the last trial. We already know the issue with the key cycles and what shows what when, and the fact that it doesn't have a time that corresponds with it. So they had to just kind of back into the key cycle by counting the number of times that the key had been turned since they took possession of the car. And they walked through that in real time with Mr. Jackson and Trooper Paul, where they counted the key cycles and pointed out, this isn't the right key cycle. You had to turn the car on to pick it up from Karen's father's house in Dighton. You had to put it on the tow truck. You had to turn it on to take it off the tow truck. You had to turn it on to take it out into the CPD lot where you did all of this testing. That's 3 key cycles. Plus, we know the car was parked at Karen's house, parked at John's house that morning before Karen took it to Dighton. That's a 4th key cycle. We know that Karen drove it there from Jen McCabe's house, where she had left it when they went looking for John that morning. That's 5 key cycles. The math didn't add up to be the one that they wanted it to be. So we kind of already know what the black box is, and I don't know how that is going to get any stronger for the Commonwealth. I suspect it isn't, or they would have given us the details. But the only details they gave us were this temperature data. And I suspect it's because that's the only facts, science, and data that hasn't already been debunked in one way or another. Very interesting how he is now trying to shift the story to Keri. Keri is the one in charge for the entire morning, not Jen. It wasn't Jen who decided we're going to Meadows Ave, which pretty sure I remember that's what the testimony was from the first trial. Jen said we're going to go check at John's house first. Now it's Keri. Now it's Keri that's in charge of everything. I think they may be leaning into Keri because Keri did come across as a very sympathetic witness in the first trial, and the defense didn't cross-examine her at all. Didn't cross her at all. See if that holds up during the second trial. Anticipating now testimony from Peg O'Keefe. She didn't testify at the first trial. We had Paul. We had Paul testify to kind of give the family's version. Paul's wife Erin testified to give a little bit of the family's version. Didn't hear anything about John in this one, or didn't hear anything about Paul. We hear that the family story is going to come from Peggy O'Keefe. Why is that? Well, there's kind of been some issues with Paul's behavior, hasn't there? He hasn't really done himself any favors with his own public statements. His behavior apparently told Karen, at the end of the last trial, this isn't over. Just to had a little bit of his own messy conduct that I'm not going to get into at any great length. But also there's the fact that there's a pending lawsuit against Karen, as well as against the Waterfall and CF McCarthy's by the O'Keefe family, specifically the O'Keefe family heirs. Does Peggy O'Keefe stand to benefit from that? I'm not sure. I don't know what John's will says. I don't know how all that is laid out, but might be an effort to distance her from that type of criticism. You have a vested interest in thinking that Karen Read is guilty because you get a big payout if your version of events is correct. So that's impeachment evidence. Is that something that is maybe not going to land so well on Mrs. O'Keefe as it would on Paul? Possible. Noticed a little, shifting of narrative yet again. So first, when they find John, it's bare ground. They lift him up and it's bare ground underneath. We have photographs from that morning. There is not bare ground underneath John O'Keefe. There is compressed ground where he was lying, where everybody was walking around him. There is no bare ground. So they're going to be able to disprove that. Later, it's not so much, just a dusting of snow on the ground. It's not so much that it would stop the frozen ground from causing the head injury. Facts and science. We've seen in the pretrial hearings what facts and science mean to the Commonwealth. It meant canine forensic odontology. That's what they're claiming as the facts and science, the mantle that they say that they hold to prove that this accident happened the way that they said it did. It's just kind of wild to think about. But the frozen ground is the cause of the injury. We kind of knew that they were going to go down that road from the pretrial hearings. But now there's a dusting of snow. It's not bare ground. It's a dusting of snow, not enough to interfere with the rock hard ground. And Judd Welcher is going to tell us all he's the hired guy. Why their own people can't present their case. Oh, that's going to come up. Okay. It's going to come up when Trooper Paul fell apart on the stand during trial 1 because he didn't understand basic physics. He didn't understand Newton's laws, like the things that you learn in, 8th, 9th grade science class in high school. He didn't know those, and he didn't know how they would apply in an accident reconstruction. When that guy didn't give you what you needed, you went out and you had to go out and hire somebody else. That's how the Commonwealth is shopping for facts and science to try to claim this mantle of superiority, of rightness and of truth. That's a commitment to the jury. Remember, the opening statements, they're a commitment. That's why you got to be very, very careful what you tell the jury the evidence is going to show, because they just might hold you to it. So if the Commonwealth is claiming science, facts, truth, better have a pretty good explanation for John's injuries. You better have a very, very good explanation for John's injuries. And that's why he's terrified of ARCCA. That's why Hank doesn't want the ARCCA witnesses testify, especially to new opinions, follow-up that they've been able to do at the behest of the defense, now having the benefit of the Commonwealth's reconstruction from Trooper Paul in the first trial. They get to present that to ARCCA, and then the ARCCA witnesses get to get on the stand and they get to laugh their heads off and say, that's the most ridiculous thing I've ever heard. That's not how any of this works. We'll see how Mr. Welcher explains it. That will be interesting. That will be very interesting. So the Dateline clip is the one that he went with. I didn't think I hit him. I thought maybe I could have clipped him. He didn't look mortally wounded. Of course, she's talking about when they saw him the next morning. Of course, that's what she's talking about. And that's what the Commonwealth has to take to try to twist out of context when it has a perfectly reasonable interpretation that's consistent with what we already know about the case. She's trying to figure out what happened. She didn't think. She's wondering, could I have clipped him and just not known it? But he didn't look mortally injured when she found him. If the Commonwealth is hanging their hat on Karen Reed's talking about what she saw that night, that's weak. That is a very, very thin gruel. That is a very thin gruel. But it is definitely a preview of the distorting, taking things out of context, the trying to twist the facts to support their theory that I, for one, am very much expecting from Mr. Brennan. So by and large, his opening statement, Mr. Brennan's opening statement, I grade it as C-. I graded a C minus. It was, you know, like I said, it was a little more dramatic of a story. But it really didn't tell you how he's going to get there and why it's going to lead you there. The temperature data, I think, is the best explanation for it's his best effort at sciencing up his opening statement. Look, we have facts, we have data, but you notice he didn't explain what any of it meant. He just dropped numbers. At this time, it was this degree. At this time, it was that degree. Okay. Well, what does that mean? Because I just went through that. I just went through your timeline of what happened with that temperature data. And I'm not sure I understand what it means. I don't understand why it held steady at room temperature until 12:45. And then it suddenly dropped 11 degrees in 3 minutes. And then it slowly dropped after that, and it took 10 minutes. No, took half an hour, took like 20 minutes to get down to 50 degrees when it's supposed to be outside the entire time. In the same place, no change of conditions. So what's changing to make these temperature changes so variable? He didn't explain any of that. So having facts is really no better than what Mr. Lally did in his opening, saying there are witnesses and they will say things. That was basically Lally's opening. Brennan's opening, there are temperature measurements at different times. QED, Karen Reed is guilty. Like, you got to square the circle. You got to make sense out of the information. He never explained how this ties together other than to just wave the banner of facts and science and data. But facts and science and data, they have to be interpreted. They have to mean something. And he never told us. He never told us why it means what he's telling us it means. So he gets some credit for being able to tell a story, being able to put you in a place, being able to vision things, chaos. When they opened up the ambulance doors, it was bedlam, a woman screaming, people everywhere, man on the ground, lights, sirens. Although, you know, Mr. Jackson did quite some descriptive moments of his own. So he gets some points. Brennan gets some points for being able to tell a good story. But when it comes to substance of convincing me how you're going to show that Karen hit John with a car and killed him, you got a big problem. When you have to acknowledge in your own opening statement that everybody ignored Karen saying, I hit him the morning of, which is a pretty critical part of your case. Karen saying, I hit him the morning of. Everybody ignored it because it wasn't congruent with his injuries. It didn't match his injuries. You're in a bad spot. You're in a bad spot when you have to acknowledge that in your own opening statements. His injuries don't add up to a car accident. It's a big, big hole the Commonwealth has to fill, and they went absolutely nowhere to get over that hurdle in the opening statement. C minus. Alan Jackson, I like the drama. I like the drama of how he opened, right? Because you guys know I'm a big note taker. And so he says the evidence will establish 3 points. I'm like, oh, great. I write down my number 1, number 2, number 3. Oh, no. There was no collision with John O'Keefe. There was no collision. There was no collision. 3 points. No, it's 1 point. There was no collision. And that it's such a strong theme because that is the reasonable doubt right there. That's the reasonable doubt. There was no collision. His body shows there was no collision. Her car shows that there was no collision. That in and of itself is enough. But now let's tack on the shady behavior by everybody inside 34 Fairview. Let's tack on what the data, the forensic data, John's phone, Karen's phone, all of this information, everything that it shows, the black box data. Let's go ahead and put all of that in as well, because none of it shows that there was a collision. It undermines the Commonwealth's theory of the case. So the battle lines have been drawn. I think that's very clear now. This is a tug of war over facts, science, and data. And who is going to get to claim ownership of facts, science, and data? It's an interesting configuration because that really is setting up a battle of the experts. We lay people don't know what it means for a phone to go to room temperature over a period of 5 minutes and then apparently hang out there for, like 10 minutes and then suddenly drop 11 degrees over 3 minutes and then gradually drop after that. We don't know what that means because we don't know how these measurements are taken. We don't know like what's triggering them. How does the software work? You're going to need experts to explain this kind of stuff. The injuries on John, we all got the eye test, okay? And the eye test was enough for me to look at this case and be like, I don't think that guy was hit by a car, okay? Said a million times, and I'm sure I will say over and over again as this trial continues, blood does not drip down the front of your face, onto your clothes, onto your pants, and onto the top of your shoes when you're lying on your back. It doesn't happen. It does happen like that when you get in a fight. It definitely happens like that when you get in a fight and you get a bloody nose, or you get a bloody lip, or you get a cut eye. You get something bloody on your face, drips right down your front, right onto the top of your shoes. So we all have the eye test that we can look at and be like, yeah, I'm not so sure about this car accident, but we're not medical experts, right? We're not medical experts. I don't know. I haven't worked in an ER and seen thousands of car accidents, pedestrians getting struck by a vehicle. My mom got hit by a car. I remember when my mom got hit by a car, broke her pelvis, pretty sure broke her hip. I think that's kind of what's normal and what's expected. So you need experts for that. Looks like we are getting ready to be back live. So they're really setting it up. They're really setting it up to see whose experts are better. And that is a daring move when you know the defense has the crash daddies. This is why he's hoping
Back in session, you may be seated.
they don't have the crash daddies.
All right, Mr. Brennan, your first witness, please.
Thank you, Your Honor. The Commonwealth calls Timothy Nuttall.
Starting with Timothy Nuttall. This is going to be rather like Lally's presentation as well. Lally started with Paul O'Keefe. He didn't get to Timothy Nuttall until like the fifth witness.
The court and jury in the case now and hearing the truth, the whole truth, and nothing but the truth, so help you God. Sir. Thank you. You can take a seat.
Sir, could you pull the microphone down a little bit closer to you, please?
Yes, sir. Or yes, ma'am. Excuse me.
All right, whenever you're ready, Mr. Brennan.
Thank you, Your Honor. Good morning.
Good morning, sir.
Could you please introduce yourself to the jury?
So my name is Timothy Nuttall. I'm 28 years old. I've been a firefighter paramedic ever since I graduated high school. I graduated in 2015. I took my EMT class and got my certification while I was actually still in high school. From there, I moved on to the BLS transfer side of EMS. There's 911 EMS, and then there's transfer, which is basically back and forth from hospital to hospital. I was brand new and very young, so I started on the transfer side, kind of learning the job. I started primarily in the city of Chelsea, Everett, Malden, Somerville, up there. And then after a little while, I got my feet wet in the 911 side. So I was running BLS 911 in those cities as well. And then I progressed on to become a paramedic. So
Why do you have such an interest in being a first responder at a young age?
I kind of grew up in a first responder household. My father was a firefighter in a local town. So we spent kind of a significant amount of time at the station when he was on shift. It's just kind of how I grew up, kind of learning the ins and outs of public safety. That's just kind of how I came to be interested in the profession, and then I took it from there. So
I want to take us back just a little bit. When you first became interested in training to be a first responder, did you share with us your first training was as an EMT?
Yes, sir.
Can you share a little bit with the jury what that entails?
So to become an EMT, there are two sides of EMS, and then there are two sides of providers. There's EMT basic, and then there's paramedic. To answer your question, sir, to start as an EMT, it's about a 4-month process. You take classes. I believe mine was Tuesday, Thursday, every other Saturday. Learning just anatomy and physiology, basic pharmacology, and kind of how medications interact with the body and different disease processes. From there, you start learning basic interventions, backboarding, C-collars.
As part of your work in learning to be an EMT, are you active in the field?
The initial training is, like I said, that's mostly classroom-based, but once you sit your national written test and you're able to pass all that and pass practical, then you're able to progress into the field.
And did you succeed through the EMT training?
Yes, sir.
At that point, did you decide you wanted more training? You wanted to proceed through the profession?
Yes, sir. So after a little while, I worked for about 1.5 years in the field and decided that I genuinely enjoyed the work that I was doing. I then made the decision to progress to the paramedic level. That's a significantly more challenging academic portion. And
can you briefly share with us a little bit of the training that you needed to complete to be a paramedic?
Yes, paramedic training is about, I would say, generally takes people about 2 years to complete. There's about 1 year of classroom. It delves far deeper into not only diseases, but how they interact with multiple body systems, multiple different treatment modalities that we can pursue, multiple different interventions, a whole host of medications, far more medications than a BLS. As a paramedic, I have a much wider range of drugs that I would be able to select to treat different patients.
As you worked through your training and got this experience, did you ultimately become employed by the Canton Fire Department?
Yes, sir.
What did they hire you as?
They hired me as a firefighter paramedic.
And so you were both a firefighter and a paramedic?
Yes, sir.
Does the Canton Police Department, in their units, do they include paramedics and firefighters in the same division?
The Canton Police Department? Or the Canton
the Canton Fire Department.
Canton Fire Department, the vast majority of the employees of the Canton Fire Department are paramedics. I believe there are I want to say 5 EMTs, but now as a requirement to remain employed by the Canton Fire Department, you have to become and maintain a paramedic certification.
So when you would go to work as a firefighter or paramedic, was it always the same, or did you get assigned as a firefighter one night and a paramedic a different night?
So we would cross-man trucks. We were always fire suppression personnel, but we were also cross-trained as paramedics. So for example, if a fire call were to come in the town of Canton and I was assigned to ambulance 1 for the day, I would take all my equipment off ambulance 1 and I would transfer it to ladder 1. And then we would take ladder 1 to the fire call and operate as fire suppression personnel. If a medical call were to come in, I'm assigned again to ambulance 1. Then we take on the role as EMS. I take my paramedic skills and put them to work in the town on ambulance 1.
Let me ask you one more background question about how the Canton Fire Department works. When there's a call, an emergency call, is an ambulance sent with other vehicles or alone to the call?
Yes, sir. It's typically the engine of that district and the ambulance of that district. Depending on call volume, that can change. But if all is not to use the word quiet, it's kind of a taboo word, but if all is everybody's in quarters and there's a dispatch in District 1, it'll be Canton Engine 3 and Canton Ambulance 1, and they go as a unit together.
Mr. Nuttall, I want you to take us back, if you would, to the early morning hours of January 22nd, 2022. I want you to bring us a little bit before 6 a.m. Do you remember what you were doing?
Yes, sir. So that particular morning, I arrived at work earlier than I normally do. There was inclement weather that morning. So I left earlier than normal just to get in before the roadways got particularly difficult to travel and to relieve anybody that may need to get out if they needed to get home before the roads got particularly bad. I arrived just before 6 a.m. I was walking in. I was assigned to Ambulance 1 for that oncoming 24. I was scheduled to be there at 8 a.m.
Could you share with us a little bit about how the weather was as you arrived around 6 a.m.?
It wasn't great. I was driving. It's about a 35-minute ride for me to get to Canton. The roads were starting to they weren't great. They had been treated, but they weren't pristine. The wind was starting to pick up. The snow was starting to come down a little heavier, which is the reason that I left at the time I did.
And so I may have misspoke. January 29th, 2022, that morning, around 6:04, did you hear a tone or did you hear an alarm?
So the tones went off right as I entered the building.
Tell us what a tone is.
So the tone is the emergency alert tone. In the town of Canton, we have 3. We have one for fire, we have one for investigation, and we have one for EMS. The EMS tones went off and the lights came on. Whenever there's the tones go off, the lights come on as well. I was just walking into the building when the tones went off and the lights came on.
And is there information that accompanies the tone, information about the call that needs response?
Yes. So after the tones had cleared, there's an overhead dispatch, which is our dispatch center, communicates to us before we get in the trucks and on the air responding. Basic nature of the call. In that particular instance, we were dispatched to an unresponsive male in a snowbank with no real further information to follow up on.
So what do you do?
So as I said, I arrived pretty early that morning. But hearing that dispatch and that nature of the call, those typically tend to be more involved, both personnel-wise and work-wise. The crew that was working that morning was getting on the truck, and it was firefighter paramedic Anthony Flamati and firefighter EMT Matt Kelly. Matt Kelly has since become a paramedic, but at the time he was an EMT. So off the bat, that crew, not to say that they were at a disadvantage, but paramedic Flamati was the only paramedic on that
So
ambulance.
what did you do?
So I made the decision. I checked with the shift commander, and I jumped on ambulance 1 to just give a second set of hands as being a paramedic myself, just being able to hopefully help if there was any advanced interventions that needed to be done or needed to be performed.
What happened?
And just a second set of hands.
What happens next?
So I got in the back of the truck. I was actually still in civilian clothing at the time because I had just walked in the door. So I got in the back of ambulance 1 in the patient compartment. The other 2 gentlemen were up front driving to the scene. I actually had to don my turnout gear because, again, I was in civilian clothing. I wasn't quite ready to go. So I had to put all my structural turnout gear on and then my Canton Fire jacket. Once I was sufficiently dressed for the call, I started prepping all the gear that we might need for a call such as that for an unresponsive male in the snow. In this case, it was our first in bag, our airway bag, and our cardiac monitor. Everything was all together. They were all in 3 separate bags. But I just, on the way there, I just got in. I didn't know how their night had gone. So I just took a real quick look at everything just to make sure everything was there and everything was exactly how it needed to be. So I was able to just grab all 3 bags, put them on my person, and get ready to, so as soon as the ambulance was on scene, just step off and go to work.
Not knowing much information about what you're going to confront, what goes through your mind as you prepare before you get off the ambulance?
Just basic scenarios. I mean, again, unresponsive male in the snow could mean several things. Not having much to go off on the dispatch was, it left much to be desired in terms of what we might need. So in gathering all the equipment together, it can kind of cover all the major bases, if you will, in terms of what we were expecting to meet once we got on scene.
How was your focus before you get off the ambulance?
I was ready to go. A dispatch like that, any unresponsive male in the snow, it can kind of up the level because you just don't know what you're walking into. You know, it could be anything.
In the back of the ambulance, you can't see outside. Could you tell anything about the weather conditions based on the way the ambulance was moving?
Again, being in the back, as you noted, it just seemed to be taking a little bit longer than normal. I really had no visibility at all. Like I said, I was in the patient compartment. It's very limited visibility in the back, and it's limited visibility. There's like a peephole that's maybe 1.5 by 1.5 to kind of peek up front. But again, I was so busy getting everything together, I really didn't notice, but I did note it took a little bit longer. We were going not slow, but we were going cautiously.
When the ambulance finally stopped and the doors opened, tell the jury what you see.
So as I mentioned, I had the 2 bags and the cardiac monitor. So 3 pieces of equipment with me. And I stepped out of the back of the side of the truck. There's a back compartment, or a back door and a side door. I stepped out of the side door. And I immediately noted the wind had picked up and the snow seemed to be heavier. And I could hear like a distant screaming off in the distance. Wasn't exactly sure where it was coming from.
What was the visibility like?
It wasn't great. It was still dark out. The sun had not come up yet. The snow was coming down, as I said, heavily. And it wasn't great all around.
Was it cold?
It was cold. Yes, sir.
And so when you hear the screams, what do you do next?
I started making my way kind of towards the sound, following the sounds. I couldn't see anybody yet. So I just kind of followed the sounds. And then once I was able to get around the side of the truck, that's when I was able to see a group of 3 individuals with Canton Police. And I started making my way over to them to see where the patient might be located and what was going on.
As you get closer, tell us what you see.
So as we approached the scene, as I said, there were 3 individuals, and Canton Police were on scene as well. And then there was what appeared to be a human figure laying supine in the snow. I'd say about 6 to 8 feet, kind of where the sidewalk met the front lawn of a residence.
What does supine mean?
So he was laying on his back.
Okay.
From there, I made my way directly over to that individual and started checking for signs of life.
How do you check? Do you get close? Do you get down on the ground?
Yep. So I knelt right at his head. Typically, to check for any signs of life, it's just as you see in TV or anything like that. You check the carotid pulse, and you check for any signs of breathing or anything like that.
Where's the carotid pulse?
So the carotid pulse would be right in the neck. Just real quick, 2 seconds, you can check either side. They're on both sides. Those are the strongest pulses that you can grab quickly. So I just real quick went right to that gentleman. Like I said, I looked for any signs of breathing. I found none. I checked a carotid pulse and I found none.
How was his skin to the touch?
He was very cold to the touch.
He wasn't warm?
No.
And so after you touched his cold skin and you felt the carotid artery? Is that how you?
Yes, sir. Carotid artery.
Did you come to any initial quick assessments or conclusions in your mind?
So I found, like I said, I checked for signs of life, the carotid, the signs of breathing. I found none. From there, we had ascertained that there is no signs of life. as I was checking that, the other two individuals on the ambulance came and met me, and they began doing the same thing just to check. I mean, sometimes you can look and you can miss. So the other paramedic, Anthony Flamati, started checking my work, and then we kind of went from there. But I found no signs of life in my initial.
So firefighter paramedic Flamati arrived to this person after you did?
Yes, sir. I was the first one to actually put hands on the individual and check for signs of life.
Did you later learn the name of this man?
I did.
And what was that?
John O'Keefe.
After you found no signs of life for John O'Keefe, did you get up and go to speak to anybody?
I did. So as being a second set of hands on the call, it's really not my call, like in terms of treatment modalities and how we want to progress. So after I found no signs of life, I kind of got up to kind of look around real quick. I went over to the individuals, the three individuals that were there, and just said, hey, I just have found no signs of life. We're gonna see the next steps. And as I was saying that, that was when Anthony Flamati, who is the lead paramedic on this, made the decision this is a workable cardiac arrest.
Let me ask you two questions. The first is, as a paramedic firefighter, are there times when you're the lead paramedic on a call?
Yes, sir.
And so it changes call by call, but this one was firefighter paramedic Flamati's lead.
Correct. He was the lead paramedic on this call.
There are other times when you're the lead and firefighter paramedic Flamati is on your crew and you lead?
Yes, sir. So we typically switch off. We'll do one, and then once my rotation is complete, we'll do the next one. So it's patient for patient, typically.
When firefighter paramedic Flamati called you back and said it was a workable situation, can you explain to the jury what that means?
Yes. So in medicine, there is a term that is, you're not dead until you're warm and dead. Meaning your core temperature, your core body temperature has to be within normal limits for it to be considered a futile attempt at resuscitation. Noting that, Tony, the other paramedic, Tony Flamati, realized that this gentleman was very cold to the touch and that this was now a hypothermic cardiac arrest, or a cardiac arrest in a hypothermic setting, which means as providers, we have a duty to initiate life-saving measures, CPR, ventilation, and continue those efforts until we get him to a hospital and a physician is able to take over and they are able to monitor his core body temperature for a certain amount of time.
When I asked you about a term you used, you said a hypothermic situation. As a firefighter paramedic treating a patient at the scene, you're not diagnosing hypothermia, are you?
No, sir.
So you're not making a medical diagnosis, you're just saying it's a hypothermic situation because of why?
Just because of the conditions. He was extremely cold to the touch, and he was in the elements. We didn't know how long, so taking the fact that he is extremely cold to the touch and he had been outside for an unknown amount of time, that quantifies it to us as a hypothermic arrest or a cardiac arrest in a hypothermic setting.
Is there anything about Mr. O'Keefe's fingers or hands or his face that gave you any indication if he had been there just recently or had been there for a while?
His fingers were quite cold. They were not well perfused at all. They were very.
I don't know. What does not perfused mean?
Sorry, did not appear to have been any blood flow at all. Just because he was, again, presumably being outside, his fingers were very, very white. They were very stiff, which can be signs of hypothermia and frostbite. And again, touching the neck. So typically, when you get cold, you kind of work back from your extremities in. So again, I noted his fingers were quite cold, but also when I checked his carotid, his neck felt quite cold as well. That just kind of tipped us back further down the road of a hypothermic cardiac arrest.
I see. When firefighter Flamati called you back,
yep.
Where did you go exactly?
I went, so when I was told that this is what we're doing, I turned around and I went right back to where I previously knelt, which was right at Mr. O'Keefe's head. And then I took over the ventilation aspect of a cardiac arrest. So I was in charge of the airway. So I began giving him positive pressure ventilations with a bag valve mask, which is just a glorified balloon that you can push oxygen through and down into your respiratory tract to get oxygen moving. While I was doing that, I believe firefighter EMT Kelly had begun CPR.
So is this fair to say it's a team effort?
Yes, sir.
A coordinated effort?
Very much so.
And depending on where you're placed, whether in the back of the ambulance or driving or leading, does everybody have an important role to play?
Yes. Yeah, we work in conjunction with each other. Typically, the most well-defined roles in a cardiac arrest in EMS is your airway monitor, which was myself in this situation, and then your cardiac and medication administration, which is that would be Anthony Flamati, that would be Tony. Just because of my position at the head, I just took over the ventilation aspect, and that was where I remained throughout the call.
You said you went back to try to help Mr. O'Keefe, and you were helping at the airway. Do you have to actually get on the ground to do that?
Yes, sir. I was kneeling at his head.
While you were kneeling at his head, well, let me ask you more of a background question. Is it helpful to get information about the history of the person when you're trying to treat them when you happen upon a scene and you don't know the history?
Yes, sir, very much. Getting information on medications, history, and allergies is our top priorities in any call, not even this call, just really any your run-of-the-mill fall or chest pain. That's typically the first questions that we ask. What medications are you on? What medical history do you have? And do you have any allergies? The medical history is important because if you've had heart attacks in the past, or just using a generalized example, if you've had heart attacks in the past, does this feel like a previous heart attack? It kind of gives us something to go off of.
As you were nailing, I want you to take us to that moment. As you're nailing, trying to help Mr. O'Keefe, did you have a chance at any point to look up?
I did.
And when you looked up when you were trying to help Mr. O'Keefe, can you tell us who you saw?
I saw a middle-aged middle-aged female with blood on her face. And real quick, as I was in the process of providing ventilations, I said, do you know this person?
The person that you looked up and saw that was standing over you with blood on her face, do you recognize that person in this courtroom?
Yes, sir.
With the court's permission, sir, could you point out that person that you looked up and saw?
Dramatic in-court identification.
In between Mr. Jackson or next to Mr. Jackson.
I see. So when you looked up and saw that person and asked about any background, what did she say to you?
I hit him.
How clearly do you remember her words saying to you, I hit him, I hit him, I hit him?
I remember it very distinctly.
You've been to a lot of calls over the years and since.
Yes, sir.
Would you say hundreds or thousands?
Thousands.
Do you remember all of them?
I remember aspects of various calls, but not all of them, no.
Do some stand out more than others?
Yes, sir.
Did this particular moment stand out more as compared to your typical or most calls that you've been to?
It did, just because of the setting. I mean, it was the weather, it was the unknown factors, and it was the attempting to try and get information and not really being able to glean anything from that.
After the defendant said to you, I hit him, I hit him, I hit him, did you ask any follow-up questions?
I really didn't get a chance to, because following that, the individual just kind of walked away, or just kind of went in a different direction. I wasn't able to ask any follow-up questions.
Okay.
Have you ever received any police training?
No, sir.
Are you a police officer?
No, sir.
When you're helping a patient, do you have any interest in detective work?
No, sir.
Do you have any interest in investigating potential crimes?
At that time, in this particular instance, because I was at the airway, that is a pretty critical aspect of a cardiac arrest, I was stuck there. I couldn't get up and kind of follow up on that at all. I was
yell?
there doing that ventilation.
Is it your job to investigate cases or simply to get information to help treatment?
Just the information.
When you go out as a firefighter paramedic, do you have a purposeful cause?
Yes, sir.
And what is that?
To save lives.
And is that your only focus?
In this instance, it was attempting to restore circulation and breathing.
At some point with your colleagues, did you lift Mr. O'Keefe from the ground?
We did.
When you lift him, what do you put him on?
So we put him on, it's called a scoop stretcher. It's basically just a hard plastic moving device with some seatbelts on it, just to get the patient up and onto the stretcher. And then from there, we can move from the stretcher to the ambulance.
After you lift him to the stretcher, tell us what happens next.
So we put Mr. O'Keefe on the scoop stretcher and we were able to get him onto the stretcher itself and then off to the ambulance. From there, I maintained my role as the airway individual on this call. So we made our way to the ambulance. I got in the tech seat, which is directly behind where the stretcher locks in. So I had access to the airway again. I was continuing to provide positive pressure ventilations to Mr. O'Keefe, and we had put in an OPA as well, which is just a plastic hook, if you will. It just keeps the tongue from falling back into the airway, so we can continue to provide positive pressure ventilations. Once we got him in the truck and we continued that effort, we set up a suction system and we prepared to intubate Mr. O'Keefe. We prepared a suction system just because as I was ventilating outside of the ambulance, there were some secretions in the airway that I could see, and you could kind of hear it as you go to squeeze in breaths into the individual. You can kind of hear the secretions kind of getting like bubbly and stuff like that. So we knew we were going to need to suction him. So we got him in the truck. We really quickly suctioned him, and then we were able to intubate him successfully to definitively give him an advanced airway and give him better ventilations, get more oxygen into his system.
Now, you mentioned that he wasn't warm, he was very cold.
No, he was still very cold.
What does the team do to try to assist with that?
The most basic thing that we did, we turned the heat on as high as it would go. We also stripped all of his clothing off, just getting all of that wet clothing off of him. I didn't really have a role in that particular part of it, just because once you're on the airway, that is kind of yours. Nobody can breathe for him. So every time I squeeze that bag, he gets a breath. So I'm kind of tied to that airway for the duration of the call.
So when your colleagues are stripping the clothes off him, is your attention on the clothes or more on the airway in your job?
No, I'm maintaining the airway. If an endotracheal tube is dislodged for whatever reason, it is typically more difficult to get one in. So the integrity of that tube staying where it is and not being dislodged, that is another key aspect of airway management.
As you're doing that, do you notice what any of your colleagues are doing to help?
Like I said, they were working on clothing removal. I believe they were also getting intravenous and intraosseous access on this individual to begin medication administration. But again, I was quite focused on that airway, just making sure that it was maintained and we didn't lose any tube. We didn't lose any end-tidal CO2, which is just another monitoring device that we use to confirm that tube is in place.
How quickly do you get to leave the scene and start moving towards the hospital?
I honestly couldn't give you an accurate estimate. It didn't seem to be out of the ordinary realm, though. We were able to move within the flow.
In addition to Mr. Keefe being very cold, did you notice any other injuries on him?
So I noted that he had a hematoma right above his right eye.
Could you explain to us what that is?
Yep, it's just, for lack of a better term, it's just a big egg. He had a pretty good bump over his eye.
And you said his right eye?
Yes, sir.
Did you know how that hematoma was caused?
No, sir.
No idea?
No.
In addition to the hematoma above his right eye, what other injuries did you see?
There were also several scratches on his right arm, just below his shoulder and traveling down his right humerus. They terminated right about his right elbow, just above it.
Those scratches, have you also described them as abrasions?
Yes, sir.
Is there any difference in your mind, difference between scratches and abrasions?
Nope. These were they were deep, and they were not bleeding, but they were notably deep.
Did you ever describe it as furrows?
I did.
And in describing those scratches, do you have any idea how they were caused?
No, sir.
Okay. And did you notice any other injuries on Mr. O'Keefe?
No, sir. Those were the only ones that we noted. As I mentioned, we suctioned a little bit of blood out of the back of his airway as well. I believe it was blood, mucus, and saliva. But those were the extent of the injuries that I was able to note.
Did you notice anything about the back of his head?
Actually, yes, I did. I apologize. There seemed to be a little bit of matted blood around in his hair around there. Really didn't see anything too obvious at the time. He was also placed in a cervical collar as well, following intubation, and that was kind of there just to maintain his cervical spine. But there was, like I said, there was noted to be a little bit of dried blood on the back of his head.
At some point, did you finally make your way with Mr. O'Keefe to the Good Samaritan Hospital?
Yes, sir.
And just share with us what happens when you get there.
So after we got there, we handed off care to Good Samaritan Medical's physicians and ER nurses. We were able to give a report to the physician of just basic what we've done, what we've given for medications, in my case, what he was intubated with, and how he was being ventilated, how well he was being ventilated, and any other further pertinent information. Typically, we noted that Tony was the lead paramedic, so that is typically he kind of holds the room for a minute when we get in there and gives a big rundown, and then we back off and let Good Samaritan take over.
When the defendant told you that she hit him, did that have any significance to you?
No, sir.
Did it reconcile with the injuries that you saw before you that Mr. O'Keefe was suffering from?
No, sir.
And so at that point, was that information insignificant in perspective of your care?
Objection.
Sustained.
Okay. What role did that information play in your care after the defendant told you she hit him? How did that contribute or not contribute to what you were doing?
It really didn't help at the time. Again, I wasn't able to chase anything down from that. I just kind of took it, noted it, and moved on with my aspect of the cardiac arrest.
Okay. Have you had an opportunity at any point to see any video of that morning taken from any source, police car, dash cam?
Yes, sir.
Okay. All right, I'd like to introduce a video stream.
Okay. So this will be in evidence. There are agreements with some of the evidence already?
I believe there's no objection, but I don't want to speak for the defense.
There's no objection.
Okay, thank you. Yes, you can show it.
And for the record, if I may note, this is Cruiser 683 Stream 2.
I'm sorry, what?
I'm sorry. It is Cruiser 683 Stream 2. Going to have to play a portion of it that's relevant to Mr. Nuttall. Ms. Gillum, if you would please move to 6:11 a.m. Please stop the video. Mr. Nuttall, do you see the red lights reflecting on the left?
Yes, sir.
Do you know what those red lights are?
Presumably, those would be ambulance 1.
Yeah, so not what you presume. Do you know what they are, sir?
And those are the lights for ambulance 1.
Do you see the weather conditions as it's depicted on this video?
Yes, sir.
Oh, as you stood outside, was it the same or different to how it appears on this video?
That is the same.
When you look to the left, you see a straight line about an inch or two from the left of the screen. Do you know what that item is?
Sorry, sir. Repeat the question.
If you look to the left of the screen, you'll see a straight item from the bottom halfway up the picture. Do you know what that item is?
I believe that's a flagpole, sir.
Okay. Do you see a little bit of movement of bodies near that flagpole?
At the present time, no.
Okay. Could we continue to play, please?
Yep, there they are.
Could you stop, please? Did you see the first person in line now behind the person with in front of the person with the blue hat?
I'm sorry, sir. Can you back it up like 10 seconds?
Certainly.
He doesn't know what he's supposed to be looking for.
Keep going, please. Do you know who that person is?
I believe that's me, sir.
Okay. Could you please continue? Is this your first assessment?
Yes, sir. This is ascertaining any signs of life or breathing.
Is that you approaching?
Yes, sir.
Could you stop, please? After informing your return, is that after Firefighter Flamati called you?
So right after that, when I turned around, that was when Tony said, "Hey, we're working this."
Okay. Please continue. Stop, please. And do you see a person come over to where you are?
Yes, sir.
Is it at that point or another moment when the defendant said, "I hit him, I hit him, I hit him"?
It was right there, sir.
Could you continue, please? Could you stop for a moment? There's no voices or noises from people coming through that audio. When you were there that night, throughout the event, was it silent or were people speaking? Did you hear people speaking?
There was, as I noted when I got out of the truck, there was quite a bit of screaming. It was quite chaotic. The wind was also a factor, but there were people around. They were speaking within themselves too, but there was screaming, there was wind, and there was different side conversations as well.
And when you were working on Mr. O'Keefe, were you having conversations with your colleagues?
Yes, sir.
So
They're not picked up on the audio?
No, sir.
Suddenly
Please
became
continue.
conversational tone to say, "I hit him, I hit him, I hit him."
Sir, are you still at the flagpole?
Yes, sir. I'm kneeling at the head of the patient.
I'm gonna make myself a little smaller because we can't see that corner. So that's John being moved on the stretcher. Maybe not.
Are you included in that group of first responders?
I am not, sir. I have actually exited to the side with the bags. I believe I'm entering the ambulance at this point.
Okay. Thank you.
So you left
We can
the airway.
conclude the viewing. With the court's permission, I'd like to approach and show a few exhibits to Mr. Nuttall. They've been shown to the defense.
Yes,
Thank you. May I approach?
yes.
Thank you. No objection. Okay. Going to show you a photograph.
Yes, sir.
Sir, do you recognize what's in that photograph?
Yes, sir. Those are the scratches on Mr. O'Keefe's arm.
Does that appear the same as when you saw his arm that morning, or is there any differences? And if there's any differences, can you share them with us?
That appears how they were to me at the time of the incident.
Okay. May I approach you, Andrea?
Yes,
I'd like to introduce this as an exhibit, please.
okay.
Here also.
I'm going to hand you a.
Hold on.
I'm sorry.
Thank you.
Pardon me, Aaron.
Nothing's going to be identified for the record. It's not
It was
particularly
published to the
helpful.
jury.
Yes.
Defense team, it would be nice if
Is
you
that the
made them make
photograph
the
you just
record.
identified on the screen?
Yes, sir.
Showing you a second photograph. I'd like to ask you some questions about it.
Can we take that one down, Mr. Brennan?
Yes, of course.
Please, Ms. Gilman?
Thank you. Does that photograph, do you recognize that area?
Yes, sir.
Is that the same or substantially the same area where you helped try to treat John O'Keefe?
Yes, sir.
Does that look to be a fair and accurate representation of the area?
It does.
With the court's permission, I would introduce this as an exhibit, please.
Okay, and there's no objection to any of these three?
None.
Okay, yes.
This is where the berm was cleared, just out of curiosity.
With the court's permission, could I publish exhibit 2?
Yes.
And sir, that's what you recognize as the area where you were helping to treat John O'Keefe.
Yes, sir.
I've left one last photograph in front of you.
Yes, sir.
And do you recognize that?
I do.
Tell us about any differences between when you were there and what you see in that photograph.
The street appears to be plowed. There's bare pavement. The weather conditions are significantly better. It is also daytime.
Okay. If we could take down that exhibit 2, Ms. Gilman. May I approach, Your Honor?
Yes,
I would move to introduce this as exhibit 3.
all right.
Exhibit 3 somewhere.
For the court's permission, I'd like to publish exhibit 3.
Sure.
Thank you for the better record.
Is that the photo you just identified?
Yes, sir.
Okay, we can take that down. Thank you. Thank you, sir. I have no further questions, Your Honor.
All right. Jackson?
Couple differences from his previous testimony. Talked about seeing a blood pool before. Blood from his nose.
Thank you, Your Honor. May I?
Yes, please.
Good morning, good afternoon, Firefighter Nuttall.
Good afternoon, sir.
Nice to see you again.
You as well.
Before your testimony this morning, how many conversations had you had with any member of the prosecution team in anticipation of your testimony today?
I believe it was 3, sir.
When were those?
I could not give you dates off the top of my head.
Give me a time frame. Within the last 3 weeks, within the last 3 months, last 3 days?
Within the last 3 weeks, I believe one the week after that, and then one last night.
One?
Last night.
Last night. What you did discuss, let's take them in order. First of all, who'd you meet with 3 weeks ago?
I met with Mr. Brennan and his staff.
And when you say his staff, who else?
I honestly couldn't tell you, sir.
Mr. Lally?
No. No, sir.
Male, female?
One female and one, I believe, state trooper.
Okay. Had you ever met State Trooper Tully previously?
Yes, sir. Actually, I believe that was him.
It was State Trooper Tully?
Yes, sir.
Who you met with several times, correct?
Prior to that, I believe only once or twice.
He was the one that he has formally interviewed you previously, correct?
I believe he arranged the meetings with Mr. Brennan, but beyond that, I can't speak to.
What did y'all discuss 3 weeks ago?
The first meeting, going in order, it was mostly just kind of an introduction. I had not met Mr. Brennan yet. I really didn't know him. So it was mostly that, and then just kind of seeing where we were at with testimony, going over previous testimony and in that sort of realm.
Prior to today, how many times have you testified under oath concerning the incident on January 29th, 2022?
Once at a grand jury hearing and once last year.
All right. As a matter of fact, last year in this courtroom.
Yes, sir.
Okay. Did you look over your testimony at the grand jury 3 weeks ago during that meeting?
No, sir.
What about the testimony from last year?
We did go over the testimony from last year. Yes, sir.
Were there any issues that Mr. Brennan or anybody else in that meeting brought up concerning any of your testimony?
There was just a question of how many times the I hit him came up. It was 3 times.
And were you advised that that's not what you said at your testimony last year?
No, sir.
2 times?
What was that?
You said it was 2 times last year?
I honestly can't recall, sir.
Okay, but you just saw that, or you just read that and went over that 3 weeks ago?
I believe so, sir, yeah.
But you can't remember, as you sit here today, just 3 weeks ago, what y'all discussed in terms of how many times you previously testified that you heard the phrase, I hit him?
So previously testified possibly to 2, but it was 3.
Okay, your memory is clearer now than it was, for instance, a year ago when you testified.
Repeat that?
Sure. Your memory is clearer now, as you sit here, that it was 3 times you heard that, than it was a year ago when you testified that it was 2 times.
Yes, sir.
Okay. Does your memory get better with time generally? Your memory. I'm not talking about the royal you. I'm talking about you.
Oh, boy.
In certain settings, I mean, there are certain things about different aspects that I recall better than others.
Okay. And does your memory tend to get better, or does it fade over time? That's my question.
It can fade over time, but it depends on the context.
But in this case, you're telling this jury that your memory is better now than it was a year ago when you testified about the exact same circumstance, correct?
Yes, sir.
Okay. You then met about a week after that, which would be 2 weeks ago.
Yes, sir.
Who'd you meet with then?
The same group.
And what did you discuss at that meeting?
Again, just prior testimony. And that was really the gist of it.
And tell me the specifics of the prior testimony that you...
Again, it was the how many times we had talked about saying, I hit him. Again, it was 3 times. And then there was also the video that was just played for me.
If I'll take the video in just a second. If y'all had met 3 weeks ago and you indicated to Mr. Brennan that it was actually 3 times, not 2 times that you heard the I hit him, why did you need to discuss it again a week later to verify the 3 times versus 2 times?
Not sure, sir. That was just the way that the conversation went. And I just, again, repeated what I said and what I remember from that morning.
Well, tell me about that conversation. Did Mr. Brennan say anything like, well, are you really sure that she said it 3 times?
It was that morning what was said to you. And I said, I hit him. That was how it went that morning, and that was how I remember it.
Okay. And did Mr. Brennan say, well, that's not consistent with how you've testified previously concerning the number of times you heard the I hit him phrase?
Yes, sir.
He did say that.
He wanted to he acknowledged that I had said it twice. However, again, as I mentioned, it was said 3 times to me.
So now you do remember last year that you only said you only said that it was repeated twice.
One more time, sir.
So now you do recall that last year when you testified, it was inconsistent with how you're testifying today. Let me put it that way, correct?
I believe I said I hit him twice on the stand last year.
Right. And if you're saying I hit him 3 times instead of twice, that firefighter Nuttall is inconsistent with your testimony today, correct? You
yes,
agree
sir,
with that?
but that is how it went that morning, though, sir.
Okay, that's not my question. Let me see if I can do it again. So I'm asking you, if you testified last year,
yes, sir,
that you heard the phrase twice, and now a year goes by and you're testifying in front of this jury this year that you heard it 3 times, those 2 statements are inconsistent with one another, correct?
Yes, sir.
Okay. Did you talk at the meeting 2 weeks ago about any other inconsistencies with your testimony?
Not to my knowledge, sir.
Well, you were there. And you say not to my knowledge, meaning?
No, sir, we did not.
Okay. So it was just about the number of times that you heard the phrase, I hit him, correct?
Yes, sir.
All right. You cleared that up in the 2 meetings, 3 weeks ago and 2 weeks ago. What did you talk about last night?
Mostly just making sure that everything was as it had been. I mean, and by that, I mean, it was 3 times and that we were
so 3 times
continuously making sure that everything was the way that it had happened that morning.
Everything was the way that Mr. Brennan wanted it to be.
No,
3
sir.
times
The way that it was
had
in,
to check.
I remember it and I recall it happening.
Okay. So he asked you 3 weeks ago about how many times you heard that phrase.
Yes, sir.
You changed your testimony at that time and said it was 3 times instead of 2 times. We agree on that, correct?
Yes, sir.
Then he called you a week later or met with you a week later and again reiterated, making sure you stick with that testimony that it's 3 times, not 2 times, correct?
Yes, sir.
And then last night he called you just to make sure one more time you're going to stick with that testimony that it was 3 times, not 2 times, correct?
Yes, sir.
Ooh,
Just a second. May I have just a moment, Your Honor?
Yes.
Okay. And when you talked last night, did you assure Mr. Brennan, nope. When we come in tomorrow, I'm certainly going to say it was 3 times, not 2 times?
No, sir. I told him I would tell my recollection of that morning.
Okay. And did you tell him that what my recollection is, I'm going to tell the jurors it was 3 times that I heard it?
That was what I heard.
Okay. Did you tell him that's what you were going to say today?
No, sir.
You didn't?
I told him I was going to tell him what I remembered from that morning.
Which was what?
I hit him.
Which is how many times?
3 times, sir.
And that's inconsistent with what?
I believe a year ago.
Okay. Now, you also talked about, I want to get back to the other thing that you talked about. You said that at some point, either in the meeting 3 weeks ago, the meeting 2 weeks ago, or the meeting last night, you were shown a video.
Yes, sir.
Which one of those meetings were you shown a video?
I believe the second one.
Okay. Were you shown the entire video? He showed you the clip that you showed. He showed you the clip that you just seen on direct examination, correct?
Yes, sir.
Did you tell him where you were?
Yes, sir.
Did Mr. Brennan ask you to define exactly where it was that you supposedly heard this phrase, I hit him?
No, I was able to give that to him, sir.
Okay. And what you told him was that moment when you see my client walk over sort of to the left of the screen, correct?
Yes, sir.
And you defined, that's the point at which she said, I hit him, I hit him, I hit him.
Yes, sir.
And that's in response to your question. I want to make sure I'm clear about this. You asked, do you know him?
Yes, sir.
And she repeated the phrase 3 times, I hit him, I hit him, I hit him.
Correct.
Okay. We'll talk more about that in just a second. Did Mr. Brennan ask anything else about that specific video?
No, like I said, he kind of asked me to point out different individuals on the scene, and that was really the extent of it.
You saw that same video last year when you testified, correct?
No, sir.
You didn't see it last year?
Not to my knowledge, no.
In preparation for your testimony last year?
I did not.
Did you see it before your grand jury testimony?
No, sir.
Okay, so this is the first time that you've seen it.
Yes, sir.
And you were able to establish for Mr. Brennan exactly when it was that you believe you heard the statement based on your view about 2 weeks ago of that video.
No, that was the way that I remember it.
Right, that's not a trick question. My question is much more simple. You were able to establish after 3.5 years now, exactly where you were and where Miss Reed was and who else was around at the time that you believe you heard those 3 statements in order. I hit him, I hit him, I hit him.
Yes, sir.
Okay. You testified last year as well that there is a normal protocol for removing clothing from a patient, and it's essential to just discard it and get it away from the patient so that you can concentrate on the life-saving measures that you're undertaking, correct?
Yes, sir.
That could be done in the ambulance, it could be done in the hospital, it could be done in situ out there in the field, correct?
Yes, sir.
But the point is you want to get as much clothing off of the person as possible so that you can assess that person's physiology.
Yes, sir.
There's not really a lot of care taken to preserve the clothing from an evidentiary standpoint in your view, correct?
We're trained to try and, just to take example of a shooting, try not to cut through the entrance wound of the clothing.
Fair enough. I mean, when you're literally trying to save someone's life, your job is to get the clothing off and get it out of the way.
Yes, sir.
You're not sticking it in an evidence bag and sealing the evidence bag, things of that nature.
No, sir.
So it might end up on the ground.
Yes.
Right? Might end up with some debris on it.
Yep.
Might end up on the floor of the ambulance.
Yes, sir.
Could end up in the floor of the hospital or on the floor of the hospital. Is that right?
Yes, sir.
Okay. And if it's tossed in the floor of the ambulance, the clothing may well pick up debris from the ambulance.
Oh, yeah. Yes, sir.
Or the debris from the floor of the hospital or wherever. Is that yes?
Yes, sir.
Okay. You testified previously at the grand jury in April of 2022, correct?
Yes, sir. I believe so, sir.
Okay. So this happened in January of 2022, that same year in the springtime. You testified at a grand jury, April 20th, I think it was.
Yes, sir.
Does that sound right?
Yes.
Okay, I want to take you back to that testimony for a second. You testified at that hearing that Mr. O'Keefe was, quote, dressed appropriately for the weather. You remember that?
Yes, sir.
All right. It was obviously well below freezing at that time.
Yes.
That night that you responded?
It was.
We just seen the video. It looks cold as hell, right?
It was chilly.
All right. The wind was howling.
Yep.
It was snowing. Is that right?
Yes, sir.
And you testified that John O'Keefe, quote, had a heavy coat on and possibly 2 other layers of clothing.
Yes, sir.
In April 2024, you reiterated your very specific memory of and you even called it a puffy heavy coat that he was wearing, which was then removed so that you could assess his injuries, correct?
Yes, sir.
All right. Not to get too colloquial, but a puffy coat is like, it's got down and stuff in it, right?
Correct.
Looks kind of like Stay Puft Marshmallow Man, right?
Yes, sir.
Okay. Pretty distinctive article of clothing.
Yep.
And you testified last year that Mr. O'Keefe was wearing that clothing, which you had to remove or somebody had to remove in order for him to be properly assessed.
I did testify that way. Yes, sir.
Okay. And you mentioned that your memory of that big, heavy winter coat was as clear as your memory of other specifics in this case, correct?
Yes, sir.
I asked you that exact question, didn't I?
You did.
And I said, your memory of him having that big puffy coat on, which stood out in your mind, was just as clear as the other specifics that you've testified to about the case.
Yes, sir.
About that night. And turns out you were completely wrong about his clothing, correct?
Correct.
Matter of fact, he wasn't wearing a coat at all.
No, sir.
He wasn't wearing a winter coat, correct?
Nope.
He wasn't wearing a heavy winter coat, correct?
Correct.
And he wasn't wearing a puffy, heavy winter coat.
He was not.
Yet you testified that he was wearing all of that, and that was clear in your mind at the time.
Yes, sir. Did
Mr. Brennan bring that up during the meeting 3 weeks ago?
he asked about what I had meant when I said appropriately dressed.
So you did talk about something other than just I hit him, correct?
Yes, sir.
When I asked what y'all talked about, why didn't you tell us that?
To be perfectly honest, sir, I did not remember until right now.
So your memory is fading even after 3 weeks.
Yes, sir.
Got it. The fact is, well, let me ask you a different question. Did Mr. Brennan tell you what Mr. O'Keefe was actually wearing?
No, sir. Actually, I believe you did.
Last year, didn't I?
Yes, you did.
It's a short sleeve t-shirt and a little thin wool hoodie, right?
Yes, sir.
Okay. Wasn't wearing a hat.
No, sir.
Wasn't wearing, as a matter of fact, didn't even have a shoe on, correct?
Not to my knowledge.
And obviously, goes without saying, but I'm going to ask it anyway, that's not being appropriately dressed for the winter.
No, sir.
Yeah.
Thought about it.
You indicated that you did notice certain injuries on Mr. O'Keefe's person.
Sir.
Once you got him back in the ambulance, obviously it's lighter, meaning brighter lights. You have more equipment in the back of the ambulance. You can better assess somebody's well-being, correct?
Yes, sir.
And you indicated you had a, quote, much better picture of what we were dealing with, correct?
Yes.
You noticed once in the back of the ambulance that he had trauma to the right side of his head.
Correct.
And as a matter of fact, when you were pointing at it, I'm doing that on purpose because you pointed to the right side of your sort of forehead above your right eyebrow, correct?
Yes, sir.
Okay. The majority or the worst injury that Mr. O'Keefe suffered was actually to the back of his head, which you indicated, you noted was quite matted with blood, correct?
Yes, sir.
I want to talk about the injury to the right side of his head as distinct from the back of the head injury for just a second. Before I get to that in detail, let me ask you, because I just sort of want to cover the bases. You noted the back of the head injury, correct? Is that yes?
Yes, sir.
You also noted the front right side of the head above the right eye, correct?
We did.
You noted some injury to his eyes. They looked blackened.
Yes, sir.
But primarily the right eye was blackened.
Yep.
And there was a golf ball size egg, I think you put it over his right eye, often called a hematoma.
Correct.
And you also noted when you got his shirt off that he had scratches along the right side of his arm. Is that right?
Yes, sir.
You indicated on direct examination today that you believe those scratches ended where? Meaning from top to bottom? And I'm not using anatomically correct language. So from shoulder to wrist, where were the scratches that you noted?
There were several. As I noted, they were on his right humerus area.
Tell me what a humerus is.
The right arm.
Biceps.
Look right about here.
Okay.
No, a little further, like between where your bicep and your tricep kind of meet. Right about in there.
Okay. And what did the scratches look like?
They were deep. They infamously referred to them as furrows. But they were quite deep. You could tell that there had been some material removed.
Okay. Material meaning skin and flesh.
Yes, sir.
Okay. Some biological material.
Mm-hmm.
Is that yes?
Yes, sir.
And were they parallel? Meaning they were going in the same direction?
Yes.
Were there any scratches below the elbow as well?
There were. Yes, there were. They were not as significant as the ones in the upper arm, but they were noted.
Okay. And those were parallel as well?
Yes, sir.
And they looked like scratches to you. That's how you described them?
They did.
Last year, when you described those scratches, you curled your fingers up, exposing sort of the nails, and drew it across your biceps. Is that what you were using to describe what the sort of scratches looked like?
I just kind of used that as a landmark, to be honest with you, sir. It was just kind of how I quantified it in my mind.
Okay. But what you did was you did this motion.
Yes, sir.
As you said, there were furrows. And remember, there was an embarrassing moment for me.
Both of us, sir.
I couldn't understand the word furrow because of the accent, right?
Yes, sir.
All right. Let's talk a little bit about the hematoma above the right eye for a second. That's basically damage to subdural blood vessels that causes acute swelling, right?
Correct.
And a very common cause of a hematoma over one's eye could be being hit or punched in the face. We talked about that.
There could be several causes for hematoma, such as that.
Obviously. I mean, it could be a golf club, a baseball bat, or it could be a fist.
It could be.
Okay. We talked about that last year. I asked you if the injuries that you saw on Mr. O'Keefe's face, including the laceration over his right eye, was consistent or inconsistent with a physical altercation, and you said it was consistent with a physical altercation as well.
Excuse me?
Objection to referring to past testimony before a question is asked.
So sustained.
Sure. Do you remember a laceration, in addition to the hematoma, about a 0.8 centimeter laceration over his right eye?
I do.
Tell me I'm using a word that maybe not everybody understands. I didn't understand it when we first started this thing. What's a laceration? What's the difference between that and a cut?
A laceration is they're basically the same thing. A laceration is just a deep cut.
Okay. So it's a parting of the skin.
Correct.
In other words, where the skin separates.
Yes.
And that can be from blunt force trauma, meaning something hits it rather than cuts it.
You can get
Sustained.
What are some of the causes of lacerations?
You can get a laceration, as you noted, blunt force, but you can also get a laceration from a slashing movement, from a stabbing. I mean, that is still a laceration.
What about a hematoma?
That is primarily caused by blunt force trauma.
Right. And the hematoma and the laceration were right next to each other, correct?
Yes, sir.
Okay. And you indicated last year, or let me ask you this way. Is that consistent or inconsistent with a physical altercation?
Objection.
Can you answer that?
I could not say, Your Honor.
Okay, next question.
Well, last year, you indicate you can't answer that. Last year, you did answer it, didn't you?
Objection.
So I need to see counsel at sidebar for just a minute, please.
She doesn't like him getting into the prior testimony. So last year, he said that when Karen, he asked, do you know him? She said, I hit him. And he did repeat that twice. I hit him. So it was only 2 times. However, the first time he reported this statement at all was during a February 8th conversation with Michael Proctor. At that time, he said that he heard Karen say, I hit him, to another female on the scene, and the other woman told Karen to be quiet. So now the situation has changed to she is saying it to him directly in response to this type of this inquiry that he made. He said his memory is a bit faulty as to that time frame, and he doesn't recall right now all the way, exactly what he said to Proctor, but he didn't tell anyone else at the hospital she said it. He didn't write a report. He didn't document the statements. He didn't pass them on to CPD. I want Mr. Jackson to follow up on, wouldn't it be helpful for your treatment to know if the man was hit by a car? Because you would expect different types of injuries, things you might need to be concerned about. You might need to be concerned about internal bleeding. You might need to be concerned about other types of internal injuries. You might need to be worried about, concussion, brain trauma. I mean, you're expecting a high impact, high force type of collision that's going to produce potentially catastrophic injuries. Surely you would want to know about that. Not able to follow up. You can't call her. You can't ask anybody else at the scene. On the one hand, this is apparently in front of everybody, but on the other hand, everybody else just seems to ignore that this statement was ever made. With this guy, I would like to see Mr. Jackson tie that back in with, wouldn't that be helpful history to know about as far as the treatment? When did you hit him? How did you hit him? What did you hit him with? When did you hit him? Okay, a time frame for how long he's been out there. Wouldn't that potentially be helpful in terms of determining what sort of treatment you may be needing to give? Potentially understanding his coldness. It's a little bit of a different medical situation if he's been out there for 6 hours, 5 hours, than if he's been out there for
Mr. Nuttall, we are going to let you take a break with the after the luncheon break. So this is
Sounds good.
The luncheon break. There's lunch here for you. I assume Tony is it there? Going to lunch. Okay. There's lunch here for you. We'll see you in about a half an hour.
All
half
right,
an hour.
please. Jurors, we can open to the chairs.
So we're taking a short lunch today, which means I am going to need to do a quick run for my lunch break very quickly before I lose myself in my train of thought and start talking. And then before long, the entire lunch period is gone and my chores are not done. I got to run out and check the bone size. We're getting very close to twice a day watering. I gave them a good watering before we came on this morning, so they're probably fine, but I need to check and yeah, get my tea reset. Guys, I will be right back. Hang tight with me. Thank you for sticking with me while the stream popped out. That was my fault. I moved wrong and it hit the mouse in a way it shouldn't have, I guess. So I've readjusted things here so that we don't actually accidentally yeet the stream. So with that, I will be back in a few minutes, guys. Hang tight. That is quite the music from court TV there. Wow. I thought maybe that was StreamYard doing something for me, but no, that's court TV giving us a little elevator music. I don't mind it because it helps me not do the jump scare when I come back on camera. So hopefully nobody was traumatized by me having my business all wrapped up and getting back. So I am going through the last little bit of my notes from when Timothy Nuttall testified in the first trial. There's a couple more inconsistencies that I've noticed. So one, in the first time he testified about the suctioning of John, he said he suctioned blood, mucus, and bile, vomit. He didn't mention any of that this time around. I got to think that Mr. Jackson is going to jump on that just because that seems like an important piece of the story in terms of what was happening physiologically with John and exactly, how this happened. His nose also, there was a little bit of blood coming from his nose. Mr. Nuttall testified to the first time. She said, I hit him in response to a question about what happened. She said it several times. Lamati was the lead. We knew that. He also reported seeing what he described as a pool of blood. Let me see if I can see if there's more of a description. There was a small pool of blood underneath him. That's really all that he says. And there was a photograph that they introduced that depicted what he described as the blood pool that he saw. This is important stuff to follow up on, I think, because where is the blood is a big question here. He shifted his testimony a little bit about the matting in John's hair. He described it this time as being a small amount, a little bit of matted blood. And my suspicion for why he's saying that is because they didn't catch this injury. They didn't know what was the most serious, in fact, the fatal injury on this guy, which was the skull fracture, the injury to the back of his head. And with a laceration that's, almost 2 inches wide, it's big. Like how do you miss that? Just how do you miss that? I mean, I can understand you would miss it if the entire back of your head is matted in blood and you would need to clean that out, which is frankly what I would expect from an injury like that, right? Not just a little bit of blood matting. I would expect a man who's been knocked onto his back by a car and left to lie on frozen ground for 5 hours while he died. That blood is going to flow. It is going to pool. It is going to completely mat the entire back of his head and his neck and all of that. So a little bit of matted hair just doesn't really seem to fit with me with the injuries that have been described. But if they miss this entire injury, then that doesn't look very good, right? So you might want to minimize that. Well, we just didn't notice because it was just a little bit of matted blood, and so just didn't really look further, I guess. I don't know. Not really a great explanation for that during the first trial. But I also want to hear the blood from the nose being elicited because I think that's important. You can see when we get to the photos of John. I mean, I'm sorry, it's one of the first things I noticed when we got the autopsy photos was face looks pretty mashed up. Like this guy looks like he's gone a few rounds, and part of that is his nose. Yeah, his nose does look a little red, a little touched up. Blood from his nose would tend to support that theory that this was a fight. This was not a car accident. I like that Mr. Jackson is focusing on the hematoma over his eye. Where's the explanation for that in the Commonwealth's theory? Where's the explanation for that going to be? Where did he hit the front of his head to also hit the back of his head, cause the skull fractures, and die on the ground? Don't think it was the car. Pretty sure it wasn't the car. So where did that come from? The way that he is emphasizing the nature of that arm injury. This is really good stuff. It looks like some blood and some tissue has been removed. Where would it be? You would think it would be on the implement that caused those injuries. But the Commonwealth says that's the taillight. But there is not a speck of blood, skin, hair, DNA, as far as we know, on the tail light pieces that were found at the scene. Nothing. So the things that actually cut him don't have any of those residues on them that would tend to suggest they were not the instruments of the injury. So I like what he's doing with that already. Boy, I already talked about he didn't have a chance to follow up. Well, did you want to ask follow-up or not? Was the issue you didn't have a chance, or the issue was it didn't matter because it didn't make any sense because it wasn't consistent with the injuries that you saw? This is really not a good explanation for how the I hit him, whether it was 2 or 3 times, allegedly emerged in this setting. He says, well, I didn't have a chance to ask follow-up questions. Well, why would you need to ask follow-up questions if it wasn't important anyway? Which Mr. Brennan made a whole point of eliciting. It didn't matter. I'm not a cop. I'm not a detective. I'm not interested in whether there's a crime. But you want to know about the injuries, and it's pretty relevant to the injuries. Pretty relevant to what you'd be treating him for if you knew what had happened that caused him to be in this situation where he's now unresponsive in the snow out in front of this house. You're going to have a different suspicion if somebody punched him versus a car hit him versus he had a sudden heart attack and keeled over. You're going to have a different approach depending on how long has he been lying there. If he's been lying there for 5 hours, doesn't that probably change your equation in terms of whether we should be giving CPR, life-saving treatment at all? Wouldn't that probably change the calculus in terms of whether this is a viable resuscitation? It would explain, a lot of why he's cold and why he's in cardiac arrest. It didn't happen recently. You don't typically do CPR on people that have been in cardiac arrest for like an extended period of time. One of the first things they teach you in first aid is seconds matter. Critical. Most of the time, a resuscitation is going to fail anyway, but the sooner you can get it started, the better likelihood you have that it's going to be successful. So wouldn't it make a difference if you're like, I hit him 5 minutes ago and he ended up here versus I hit him 5 hours ago and it ended up here? This all seems quite relevant to exactly what he is there to do and what he's supposed to be doing. And yet we have these competing explanations. It didn't matter because it wasn't relevant, but also I didn't have a chance to follow up on it. Maybe somebody can square the circle for me, because I don't know why you follow up on something that isn't relevant. You just wouldn't. It's not about not having a chance. If she wandered off, there's lots of other people at the scene. There's people right there. You can call her back. You can call one of them over. Hey, get more information from her. She said she hit him. I need to know what that means. What did she hit him with? Where did she hit him? When did she hit him? Is that what caused him to have these injuries? It really doesn't seem that difficult to do. So chaos or not, you're not helpless in this situation. You're not helpless. You're literally there to intervene and to try to Try to get what you need to know to be able to be helpful. You didn't have a chance to, or it didn't matter. Which one is it? It's both. It's both. That's what tells you it's neither. If it's both and they don't add up, that tells you it's neither. This time I already mentioned, he said he suctioned blood, mucus, and saliva from the airway, but last time he did mention bile. And I think bile is potentially important because there isn't any at the scene. There is apparently some on John's clothing, but no, once again, on this rock hard frozen ground that we're now being told is the condition of the lawn at 34 Fairview, few hours after it started to snow. Frozen ground is not absorbed, doesn't absorb fluid. So blood would be there, vomit would be there. Where is it? No sign of it anywhere. So this time, yes, he just says there's a little bit of dried blood on the back of his head. Just a little bit. Just a little bit. That's not consistent with the injury that he had. A little bit of dried blood on the back of his head is not consistent with having a 2-inch laceration and a bunch of skull fractures. That is an injury that is going to bleed and bleed and bleed and bleed and bleed and bleed and bleed. Where's the blood pool? So maybe we'll get back to that. Maybe Mr. Jackson will get back to that. Interesting approach to the cross, to walk him through the prep 3 times. 3 times. He has to reassure Mr. Brennan that he's going to say, I hit him 3 times. Not twice, 3. That's what you needed 3 prep sessions to get that straight. That's awfully hard for me to buy. It's awfully hard to me to buy. And frankly, even if it's true, it doesn't look good. Even if that's true, that doesn't look good. You shouldn't have to ask a million times and make sure you get the right answer. If you're telling the truth, it shouldn't change, right? It should just be the same thing every time. But the problem is, it's been something different almost every single time he said it. Because initially there was no report to anybody. Then on February the 8th, it was the statement to Proctor that she said it to a female who was present. The female told her to be quiet. Then it changed in his testimony to she said it to me in response to my question. Then it became she said it the 3 times in response to me at this exact point in time on the video camera. That's a detail. Guys, remember when we watched this last time? This is how the pieces fall apart when information is not correct. And I want to be clear. Is Mr. Flamati lying? I don't know. Not Mr. Flamati. We're on Mr. Nuttall right now. Is Mr. Nuttall lying? I don't know. He could just have a particularly bad memory. And we certainly have some indications of that within weeks of this accident happening. He's testifying John was in a big puffer and he had this vivid memory of having to have the puffer coat cut off of him. And none of that happened. And that was, a couple months after he responded to this scene. So we already know his memory is not necessarily very good. People do confabulate, not necessarily on purpose. It's just part of what happens. Is he going to have loyalty to his team and his people? Oh, 100%. I don't doubt that at all. And so to the extent that this is backing up Katie McLaughlin, I think that is a motivation for him to remember things occurring in a certain way. Is it lying? I'm not prepared to say that it's lying. Like, I don't know that he's part of some cover up, but would he be somebody who could be tainted? Yeah, I think so. That's my impression for sure. So his story has evolved every single time that he said it. That's really, I think, the critical point of what's being brought out here. But Oh, Mr. Jackson did such a good job of illustrating how sketchy that looks, right? The whole prep session. You needed three prep sessions with this guy, all about making sure he said, I hit him 3 times, when you already know his previous testimony was twice. You already know about the discrepancies. That seems a little bit hard to believe. A little bit hard to believe. And then last night was just making sure everything was as it had been. What a weird choice of words. Everything was as it had. So nothing had changed. Why would it change? Why would anybody expect it had changed? Why did you need to follow up 3 times within 3 weeks of trial to make sure nothing had changed? Did you need to change your story for some reason? That was just a really bad choice of words. And then he just gave the characterization to Mr. Jackson the whole time. He confirmed with you about that you were going to change your testimony to say the 3 times. Yeah. He just gave him that. It's inconsistent. Yeah, just gave him that. The first time he'd seen that video was at the second meeting. Did you guys notice when he's describing this, there was a point where he made a little bit of a face at Mr. Brennan. He looked down at Mr. Brennan and made a kind of, oh, well, looking kind of expression. Did you guys catch that? I can go back and try to find that and clip that, because that to me just kind of, it spoke to loyalties, right? It spoke to who he's there for and what he's there for. That's who he's affiliated with. If something is coming out that isn't good, if something that's coming out that just it is what it is, what's your inclination? It's to communicate with Mr. Brennan about it. A sort of, oh, well. They went back through the hoodie, went back through the injuries, and now they're getting into consistency with being in a fight. It doesn't really matter. This is one of those things. Yeah, he did testify to that before. He said, the blood on him could be from the laceration. He had a black eye on the right side. First, he said he couldn't say it's consistent with being in a fight, but then he said it is consistent. That's what's in my notes. First, he said he couldn't say, but then he said, yeah, it is, because Mr. Jackson just walked him down that primrose path a little bit. Use your common sense. Use your common sense. A guy has a black eye, a big egg, no, some blood coming out of his nose. No other apparent injury on him. You might think maybe he's been in a fight. It would be consistent with that. You wouldn't be crazy for thinking that. Yeah, it's consistent. So I don't know what they're arguing about at the bench. I don't know if they're arguing about it's improper impeachment. I don't know if they're arguing about I don't like how he's referring to the previous testimony. I don't know. I don't know. I did like how Mr. Jackson snuck in. He testified just a year ago here in this courtroom, right here in this very courtroom. That was sly. So now the jury knows from the very first witness, if they didn't already, we already had a trial on this. We already had testimony on this a year ago on top of the grand jury from back in April. Then they're going to be hearing about, a different grand jury. I think if Mr. Jackson is on this, the jury is going to get the hint. There have been multiple testimonies, procedures. You're not going to get to know the details, but you might be able to read in between the lines. state grand jury, some other proceeding, then testifying here again last year. I think they're going to get the point that many, many times this case has been presented. It was funny when he did that in opening, wasn't it? It was a little bit of a head fake. They've presented this case before, and we're like, oh, is he going to talk about the first trial and the mistrial, the hung jury? Oh no, he presented it to Scordy Bello. That was good. That's a good way to kind of transform her from being a state witness and a medical examiner into being a decision maker, into being an advocate, into being a fact finder. It's very clever how he did that. But he's not wrong. I mean, that is the process that they described, that she doesn't just take into account the autopsy. They bring her their theory and their evidence that they have to support it. We saw how Proctor reacted to her determination in his texts. We saw what he called her. And after seeing all that, just like, yeah, I can't say homicide. Can't say it. So that was compelling, and it was sneaky. Like, there's a kind of maybe an argument that's pushing the lines of what's proper. Maybe a little bit of an argument, because she's not the one who decides. Ultimately, it's going to be the jury's decision. But it is within the scope of what she's expected to do as far as her expertise. Make that determination, put it on the death certificate. That's her job. She wasn't able to make that finding. Doesn't preclude the jury from making that finding. So, I mean, I think he stayed on the right side of what's allowed. But it's very, very, very clever way of bolstering their, interpretation of the case and the facts with the suggestion, oh, this medical examiner, she agrees with us. She doesn't agree with the Commonwealth's theory. She agrees with our theory. It's a good argument that they managed to sneak into opening under the guise of being evidence that's going to be presented. Well, if we have a couple more minutes, I will get to some of your questions and chats and stuff. But I did get cut off at the very beginning before I was able to grade Mr. Jackson's opening. I'm going to give Mr. Jackson a B+. I'm going to give him a B+. I think it was very good. Doesn't have the drama, impact of the Karen Read was framed, but it made the point. There was no collision with John O'Keefe, and here's all the way that we're going to show it. He tied it in very well with the Bowden defense and the whole problem with Proctor, tying the investigation to Proctor, the evidence that they got from Proctor, and the fact that Proctor's theory is inconsistent with the injuries, with the other evidence that they've come up with. I thought they did a great job of transforming what had in the last trial been these guys did it and then covered up into these guys acted shady and he never followed up on it. He wasn't going to do anything to follow up on that because he's a Boston cop too. Tying that to the corruption, that seems like that's a good move. I'm not from Massachusetts. I've been there once. It was quite a long time ago. Yes, it was kind of nice. I mean, I don't know. I wasn't there for very long. I was in Boston and then a couple times over on the west side of the state over at Williams College. That is a beautiful, beautiful area, but quite a bit more remote than the Boston area. So I'm not real familiar with the culture over there. But I've had so many people contact me to just say, Andrea, like you would understand more about the corruption angle and why that's so concerning to people if you were from this area. I have to take your word for it. I don't know. I certainly know about some of the history there. I know about the history with Whitey Bulger. I know that he was working with the feds over there in the Boston office. I know that the feds were letting him get away with all kinds of criminal stuff while he is simultaneously working for them. I know about Sean Ellis and the corruption that was involved in that case. So like I'm familiar with the history. So I guess, you know, I wouldn't be surprised if that's kind of a sense, you know, among people over there. Law enforcement is potentially maybe a little more corrupt there than in other places. And if that is the case, and they've certainly had a chance to feel that out in jury selection in voir dire, then that might land. That might land. Suspicion of law enforcement and just what we're able to show you in this particular case about how they said the quiet part out loud. What are some other things that he do that was effective? Bringing up the new doctor, is it Lopilata? I didn't write it down very well. And I know she's on the witness list, but their new forensic pathologist, that I found very interesting. It's certainly it's new facts from the last trial. They didn't have an independent pathologist at the last trial. So this time she says the injury to the back of the head was immediately incapacitating. That's important because Trooper Paul had, struggled to explain some of the evidence, how things ended up where they were in the position that they were and so forth. And, you know, among those was like the possibility maybe John staggered a few feet or something like that. This is going to take that off the table. If the injury is that debilitating, then he landed as he was found. He didn't move. That he didn't suffer from hypothermia. Well, that's very interesting because, of course, that was part of the initial cause of death determination. He died in the cold. Died in the cold, and that was based on something that was observed in the liver cells, I think, primarily. She is finding he did not suffer from hypothermia, that there is no frostbite and no cold-induced organ injury. Frostbite has long been a big question for me because, again, we're talking about a long time out in the cold. 5 hours out there in, 20-some degree with wind chill and the snow coming down and all of that. Would have been really nice during the first trial to have some testimony about cold injury. What would you expect under these types of circumstances? Now, I don't know if that's something that potentially the ARCCA witness, not Dr. Cook, the other one, can't remember his name now. Anyway, it'll come to me, but it's been an early morning, as you guys remember. He was the one with the biomechanical background. I wonder if maybe he was going to testify about that. Yes, thank you. Dr. Wolf is the one, and Dr. Rentschler. Thank you, Dr. Rentschler. Dr. Rentschler was the one who had more of the medical focus in his testimony. So maybe he was going to get into that. I don't know, possibly, but it would have been helpful information. You know, we know that Judge Bev excluded Dr. Rentschler from being able to testify about injury causation because back then we were dealing with the standard that you had to be a medical doctor if you're going to opine about a cause of injury. That honestly didn't even last through the first trial. I mean, we had Trooper Paul. Guessing about causes of injuries and stuff like that. Trooper Paul's the one that's guessing, well, the injuries on his arm were caused by the taillight. But now with the dog bite experts, we know that standard has been relaxed anyway, but didn't hear about that the first trial. And it's definitely something that I wondered about. It's a big piece of the puzzle. What's the effect of the cold in all of this? What's the effect that would have on John's body temperature? What would we expect it to be? How would we expect it to change depending on different variables? If he died instantly, if he was knocked out and lied there but didn't die instantly, if he was placed out there a couple hours before, like the defense theory seems to be maintaining. What would those different scenarios look like, and how would the cold affect him in terms of his body temperature, in terms of frostbite, and all of that biological evidence? That's what facts and data and science is. Not a single injury on him, consistent with being hit by a car, nothing below the waist, not even a bruise, but those bruises on his hands. Don't forget. Don't forget about those big old bruises on his hands, because we're going to see those. Didn't hear anything specific in the opening from the pathologist about that, but I've definitely always kind of wondered. Sure looks like a boxer's fracture. Really does. Really does. Not even sure how else you get a bruise. Like right there on the back of your hand. I guess if you whack it real hard into something, but that would give you the egg and the swelling. Again, similarly like you had over the head. If it's a blunt impact force like that, I don't know. Maybe we'll get more, but maybe we won't. I've just always been fascinated by the injuries on the hands because, of course, as soon as I saw those, I'm like, oh, it looks like a boxer's fracture. It's all the more reason why this guy vehicle collision does not pass the eye test. This guy looks like he's been in a fight. And this piece of information from the defense's pathologist that the skull injury came from impact on a raised or a ledged surface. That's very interesting. That's certainly not frozen ground, frozen lawn, which, seems so implausible even under the best case scenario. But if you had to have a raised surface, where is it? Where is it? I don't think there's anything out there in the grass. A rock? Wouldn't they have found like a bloody rock if that's what caused the injury at some point in one of these various searches? Just seems like that's the kind of thing that you would come up with. But there was nothing like that from the first trial. So I want to hear how she knows that. I'm going to assume it's because of the pattern of the fracture. There's some way to make that determination that it's not, maybe like it's hit this way, it goes in a star pattern. It's hit in this way, it goes in a different pattern. I don't know. That's just my best guess about how you would make that kind of determination. But so I'll be interested in seeing what her basis is for saying that. No, he didn't fall back on a flat surface. He fell back onto a raised surface or a ledged surface, because that, again, is going to tend to put him inside the house, not out there on the front lawn where there doesn't appear to be a raised surface. The appropriating the Commonwealth's experts, that's always a great move. That's a great move. Their own injury, their own experts will say the SUV was not damaged by hitting John and that John's injuries are not from the vehicle. Well, John's injury is not from the vehicle. We know that Dr. Scordi-Bello is going to say that. She already said not classic pedestrian injuries. But I wasn't aware of a Commonwealth expert who would say that the SUV was not damaged by hitting John. If the defense can follow up on that, if they can deliver on this commitment, it's got to be Welcher, right? It's got to be Welcher. I would think he's the one that knows physics. I hope he knows physics better than Trooper Paul knew physics. But he's the accident reconstructionist, right? So if there's an expert on the Commonwealth side who's saying damage on the SUV was not caused by hitting John, that's got to be him. So that'll be interesting. They know more about triggering events. They have seemingly been able to get some more information, some more of the timeline, perhaps. They know that there have been other triggering events. I don't remember that a ton from the first trial. It looks like they're getting ready to come back now. So I'll get our sound on so we can hear when they get moving. But right now we're just staring at the fan still. But it does seem like they are working into a more technical version of the case. This little timeline he gave, good timeline, 125. Brian Higgins is going to Canton Police Department, 1:30. He makes the phone call, 2:22. Him and Brian Albert talk and then lie about it. 2:27, there's a hostlong to Diane Cold. 2:30 is when Lucky Loughran goes by and sees John is not on the lawn. And then at 3:30 goes back by and sees it obstructed by the Ford Edge. That's a good timeline because that's really all we know about what was going on in these intervening hours. We have, the phone records, the phone calls and the texting and so forth. And we have Jen McCabe's data. Be interesting to see if they're going to lean on how active that data was. To me, that also seems to be an important point. But if they are, they did not lean into that in the opening statement. So all in all, a lot of good things. I think he also did what I suggested that Hank Brennan was going to do, which is kind of mischaracterize the opposing argument so that you can belittle it. Talked about the paranormal events. Folks are telling me court's back on, but it is not back on my court TV. Is it on a different channel? Let me see what I can find here. Oh, it is. Hang on. So court TV led me astray. I'm gonna get us hooked up with NBC 10, I think this is. Okay. Okay. Here we have it. Let's see where we're at.
All right, bring the jurors in, please.
Let me see if we missed something. Well, they came in. Just check that.
You are unmuted.
I was told council wanted to see me about scheduling.
Your Honor, my apologies. That's actually a moot point at this point, so that there's no.
Okay. All right, bring the jurors in, please.
Moot point about scheduling. Make sure I've got court TV off so that if it comes back on.
Yes, Dave. Yes. Yes, please. Yeah.
Well, that was sort of pointless. Trying to skip us ahead a little bit here. Oh, and now it's gonna buffer on me. It's gonna be that kind of day, it looks like.
Please be seated.
All right, Mr. Jackson, you can go ahead.
May I, Your Honor?
Yes, please.
Thank you. Firefighter Nuttall, over the lunch hour, did you discuss anything that we had discussed this morning or earlier in the session with anybody about your testimony?
No, sir.
Okay. You did mention earlier today the EMTs that were with you that responded to the scene. You mentioned, I think you said Tony Anthony Flamati, correct?
Yes, sir.
You mentioned Kelly, and I want to say Matt
Kelly.
Matt Kelly.
Yep.
Yourself.
Correct.
And of the three of you, two of the three of you were and are paramedics, Firefighter Flamati and yourself, correct?
Correct.
Do you know the name Katie McLaughlin?
I do.
Who is Katie McLaughlin?
She is a firefighter paramedic for the town of Canton.
Was she also on the call?
She was.
You didn't mention her this morning.
It did not come up. She responded on the initial dispatch on engine 3.
You were asked who responded with you, correct?
Yes, sir.
By Mr. Brennan.
Yes, sir.
And you mentioned yourself. You mentioned Tony Flamati. You mentioned Matt Kelly.
Yes, myself, firefighter Flamati and firefighter Kelly responded in ambulance 1 together.
Okay. And how did firefighter McLaughlin respond?
So she was assigned to engine 3 that night. She was with Lieutenant Woodbury and firefighter paramedic Frank Walsh.
She also, in addition to Walsh being, it's Frank Walsh?
Yes, sir.
In addition to firefighter Walsh being a paramedic, Katie McLaughlin was also a paramedic.
Correct.
Okay. So she responded to the scene at the same time as you, generally, but in a different ambulance.
In a fire truck, in a piece of fire apparatus. She was in engine 3.
Got it. Engine 3. Okay. And she was with you, generally, when I say with you, at the scene during the entire time that you're describing the events that you described with Mr. Brennan on direct examination?
For the most part.
Okay. She then left in a particular ambulance, correct?
Yes, so she ended up driving ambulance 1 to Good Samaritan.
And ambulance 1 was which ambulance?
Ambulance 1 was the initial ambulance that myself, firefighter Kelly, and firefighter Flamati responded in.
So right after the scene you described, as you're leaving the scene, firefighter McLaughlin is in the ambulance with you and firefighter Flamati, correct?
She is driving. So the 3 of us are in the back in the patient compartment. She is up front in the driver's seat.
Once at the hospital, did firefighter McLaughlin go into the hospital with the other firefighters?
I believe so, yes.
So she was with you in the engine. She was, although in the driving cab, she was with you, ambulance in the driving cab. She was also with you right after the scene at the hospital, correct?
Yes, sir.
And she was also with you later after you cleared the hospital and went back to the station?
Yes, sir.
You had discussions with firefighter Flamati about the incident. That would be normal protocol.
Correct.
Almost like a debrief.
Sure.
You had the same types of discussions with firefighter Kelly, Matt Kelly.
Yes, sir.
I'm guessing that you probably had the same sorts of discussions with firefighter Walsh.
I actually don't know if I saw firefighter Walsh when we got back. The weather was right at shift change, and the weather getting back was also getting worse. So I honestly couldn't speak to that.
And you also had conversations with firefighter McLaughlin after you cleared the hospital and got back to the station as well.
She was part of the debrief, yes, sir.
Okay. And all of you discussed what you did, saw, and heard, generally speaking, while at the scene, correct?
Those are more in terms of getting equipment wrangled, really kind of how they go. What did we use? What do we need? What are we going to have to restock when we get back?
Right. But there also was obviously discussions about what had just happened. I mean, you are dealing with a dead or dying police officer on a lawn, on a snow-covered lawn in a cold environment.
I honestly couldn't speak to that, sir. I honestly don't remember.
It's because you don't remember, correct?
Well, like I said, it's mostly those debriefs they're very equipment oriented because the goal at that point is to get back in service.
My question is not about the equipment. Obviously, you're going to discuss the equipment, make sure that the ambulance is ready for the next call, et cetera. I'm asking about a general debrief with the fellow firefighters, male and female, that you were with at that scene. You're telling me that you don't remember debriefing and discussing the incident and your observations at the incident following that incident?
No, sir.
Okay. But your memory, you indicated earlier, gets better with time, right?
Yes, sir.
You don't remember it as you sit here today?
Ask the question again.
Sure. Do you remember discussing with firefighter Flamati, firefighter Walsh, firefighter Kelly, firefighter McLaughlin, any of them, your observations and what happened while at the scene after you cleared the hospital and got back to the station?
No, sir.
Have no memory of that whatsoever?
No, sir.
At the first trial, you said the case is brought up around the
When we
station
left
pretty
off
frequently.
before lunch, I was asking you about a hematoma and a laceration over the right eye of Mr. O'Keefe. Do you recall that?
Yes, sir.
I asked you, is being punched in the face, can that lead to a small laceration like you saw and a hematoma like you saw?
Objection.
I'm going to allow it. Can you
Uh,
answer that question?
I couldn't speak to how that injury occurred.
Is it consistent? Are those injuries, just those injuries, are those consistent with being punched in the face?
Those injuries could be sustained from numerous ways.
Including
Yes,
being
it could
punched
be.
in
It
the
could
face?
be from that. It could be from others as well.
Okay, so that's what I'm asking you. It could be. In other words, it's consistent
Yes,
with
sir.
being punched in the face, correct?
Correct.
Thank you.
Tried so hard to not give that answer. You just can't help it. Got to comply at some point.
I want to ask you about this statement that you indicate that you heard that now is 3 statements, 3 phrases, correct?
Yes, sir.
When you heard this statement, describe for me exactly where you were. What were you doing and who was around you?
I was knelt at the head of John O'Keefe with a bag valve mask, delivering ventilations. Firefighter Kelly was to the right, and Firefighter Flamati was on the left side of Mr. O'Keefe, and the 3 of us together were working to perform CPR and ventilations.
And your job, and I hate to butcher it, but you'll correct me.
Yes, sir.
Your job was to do the airway, correct?
Yes, sir.
And I'm picturing a big balloon-like apparatus that you put over the patient's mouth. and
Exactly.
Squeeze it.
Yes.
That's as opposed to, it's an advancement on just mouth-to-mouth resuscitation, correct?
Correct. Yeah.
You were the airway person doing the squeezing of the bag.
Correct.
What was Tony Flamati, firefighter Flamati, doing?
He was starting CPR, and which that point was taken over by Firefighter Kelly.
Okay, so firefighter Flamati, when you say starting CPR, describe what that means. What is the physical act of CPR?
So you put both hands together like this, one on top of the other. You put it right on top of the sternum, and you begin doing chest compressions 2 inches deep, allowing full recoil for 100 to 120 beats per minute, compressions a minute to sustain a cardiac rhythm. You're manually making the heart beat with each compression.
Which means that is a rhythmic pumping motion, correct?
Yes, sir.
So if you see someone doing CPR, you're probably going to see their shoulders moving up and down and moving rhythmically, correct?
Correct.
Do you remember what firefighter Flamati was wearing? You had just come off of actually you were just coming onto a shift, so you didn't have all your foul weather gear officially, correct?
I had my puffy jacket.
Okay.
I had my Canton Fire jacket.
Got it. Firefighter Flamati, on the other hand, had a bright yellow jacket.
Correct.
Sort of reflective and a safety jacket.
Yes, sir.
And he was kneeling to your left at the time doing, have I got that right?
Yep, nope, yep, you got that right.
Okay, he's kneeling to your left at the time doing chest compressions. That's when you indicate that Miss Reed walked over and made the statement.
Correct.
And Kelly was there as well?
Yes, sir.
Kneeling right beside all 3 of you as firefighter Flamati was giving the chest compressions, correct?
Yes, sir.
Okay. You indicated that the statement was in response to a question that you asked of my client. Do you know him?
Yes, sir.
Is that right?
Correct.
And she responded to you with the phrase that you've used. I hit him.
I hit him, I hit him, I hit him.
Right. So it's absolutely clear in your mind when that statement was made. You were knelt down over Mr. O'Keefe. Firefighter Flamati was doing the CPR, and Kelly was with the both of you when you posed that question.
Yes, sir.
It's a very detailed memory.
Pretty
Yes, sir.
sure.
You indicated, Mr. Brennan, that sticks out in your mind. Is that right?
It does.
But that's not at all what you told Trooper Proctor on February 8th, just 10 days after this incident, is it?
I don't recall what I told Trooper Proctor.
I thought your memory got better with time.
I don't recall that meeting. I recall meeting with him, but I don't recall the extent of what was discussed.
You literally don't recall anything that was discussed in that meeting in that formal interview with the lead detective on this case?
We discussed the case, but I don't, in his words, I'm not sure what he put down.
What you said to Trooper Proctor on February 8th, 10 days after this, was you overheard Ms. Reed say, "I hit him" one time to another female that she was talking to, correct?
Objection.
No, I'll allow it. Did you say that?
I have no memory of this, Your Honor.
Okay, next question.
Did you
Has
say
no memory
that her statement was an answer to a question posed by the female or a discussion with the female?
Break that down for me, sir.
Sure. Did you tell Trooper Proctor on February 8th that what you heard was Karen Reed speaking to a female, not answering a question that you posed?
Again, I don't recall that specific question.
Did you tell Trooper Proctor on February 8th while you were rendering aid, and at the time you heard the statement, Ms. Reed was actually praying over John? Your words, praying over John.
I don't recall ever saying that.
May I have just a moment, Your Honor?
Yes.
Would it refresh his recollection? You gotta get Spyro on this guy. We're gonna talk about this at the break. He's running up against the limit between impeachment and refreshment, and he needs to nail him down. Do you deny making that statement? Do you deny it?
Did you say that you observed Karen Reed to have blood on her face from providing mouth-to-mouth breaths to Mr. O'Keefe prior to your arrival?
I remember Miss Reed having blood on her face, presumably from attempting CPR.
Do you remember telling Trooper Proctor on February 8th that you saw her with blood on her face from CPR?
I do.
So you remember that portion of your conversation with Trooper Proctor, correct?
Yes, sir.
But the praying over John, praying over the victim, you don't remember.
I don't remember ever saying that.
Do you deny it?
And the statement,
You deny it.
"I hit him" to another female, you also don't remember that.
No, sir.
Would it refresh your recollection if you were to look at a report
Yes, sir.
authored by Trooper Proctor? May I?
Yes.
He gave you that one, allowing him to be refreshed.
May I direct the witness's attention to the second page, Your Honor?
All right, why don't you take a look at that, sir?
We're going to talk about that at the break, the way that Spyro does. He dances this dance, and it's so effective. And Mr. Jackson needs to learn it pronto. He made a lot of faces.
May I approach, Your Honor?
Yes.
Thank you. Sir, did you have an opportunity to glance at the report that you were just shown?
Yes, sir.
Does that refresh your recollection about your conversation with Trooper Proctor that he put in a report?
It does not, sir.
So as you sit here, you have no memory of what you just read in this report from Trooper Proctor, the lead investigator on the case?
I have no recollection of ever saying that anybody prayed over anybody ever in this case.
You did see it in his report, though.
Right.
Sustained.
You've admitted under oath that your memory of the events at that time, from that time frame, January, February 2022, is faulty, correct?
No, sir.
Yeah, he
In
did.
your April 2024, it's April 30th, 2024 testimony from last year.
Mm-hmm.
You were asked whether or not your memory was a little faulty, and your answer was absolutely, correct?
Could I have a page and number,
Where is
please?
that, Mr. Jackson?
Volume 8, page 151, lines 14 through 16.
Yep, it's in my notes too.
Can you give me the lines again?
Lines
Absolutely.
14 through 16. I'll just allow counsel to get that up.
If we could pose the entire question and give content to it, please.
Okay.
May I?
Yeah, so do you intend to show the whole question?
The whole question that I asked and his answer, yes.
All right, and I'll give you the opportunity. I'll redirect Mr. Brennan if it's not. Go ahead.
Is it true that in answer to the question, quote, so it's fair to say your memory is a little bit faulty as it pertains to that time frame? Your answer was absolutely.
That was about what he
Correct.
said to Proctor.
From last year?
What you testified to last year about conversations that you had with Trooper Proctor around February 8th of 2022.
Yes, sir.
And you would agree, as you sit here, that your memory is still faulty about your conversation with him.
With
correct?
Trooper Proctor? Yes,
Yeah.
sir.
So you're not saying you didn't say that the statement was made to a woman, correct?
Objection.
Are you saying that?
No, ma'am.
Okay, next question.
Thank you. And you're also not saying that you didn't say to Trooper Proctor that you saw Karen Reed praying over
Are
John
you
O'Keefe.
denying it?
Objection.
So I'd like you to ask that differently. Did you say that?
I have no recollection of saying that ever.
But do you deny it?
Next question.
My point is, if you have no recollection of it, you're not denying saying it.
Objection.
Are you denying saying it?
Yes.
He's
So you
denying it.
do
Now
have a
you get to
recollection
impeach. That's
that
how
you
it's
never
done.
said it. Do you understand the difference?
Oh, sir, I don't believe I've ever said praying. That's really not something that I would have said. I didn't see it that day. It didn't happen. I don't remember ever saying prayed
You didn't
in
see
regards
it
to this case ever.
You didn't see it that day, and it never happened. That was your words just now, correct?
Break that down for me.
You didn't see it that day, and it never happened. That's what you're saying about the praying statement, correct?
Yes, sir.
And in that same exact statement, you also included the phrase, I hit him, correct?
No, sir.
In the statement that you made to Trooper Proctor?
The report that Trooper Proctor wrote?
Correct.
Again, I don't remember ever saying the words praying over him. I do distinctly remember I hit him, I hit him, I hit him.
Which doesn't appear in that report, does it?
Objection.
I'm going to sustain that, Mr. Jackson. You directed him only to page 2.
Understood, Your Honor. I'd like to show you a short portion of a video, the same video that you were asked to look at on direct examination. And Your Honor, I pray to the court, I can certainly mark it as a defense exhibit or for
So is this
identification.
going to be an exhibit by agreement?
It is.
It is.
So we now that, Madam Court Reporter, thank you.
Exhibit 4. Thank you for making our record for us.
Thank you, Your Honor. With the court's permission, may I play a portion of that video for the jurors, publish it?
Okay. Which portion so people know?
I'm going to start it at about, I want to say 6:55. Mr. Wall, could cue that up? Before you play it, can we have it on that screen as well, or is it only playing to this screen?
I don't know. When Ms. Gilman did it, it was both. Great.
There we go. All right. Before we play it, can I ask you a quick question about this?
Sure.
It appears that this is paused. Do you recognize this as being the same video that you were shown this morning by Mr. Brennan?
I do.
All right. Describe the scene.
So that is 34 Fairview Road. The lights in the background, I believe it is either right as we pulled up or right as we're pulling up.
Okay. Same dash cam video.
Yes, sir.
Can we scroll this to the 6:55 runtime spot, please?
So 7 minutes in.
Pause it. Okay. Do you see the individual on the left? Far, far, far left.
Yeah, The jacket?
Correct.
Yes, sir.
Who's that?
I believe that's Firefighter Flamati.
You previously indicated that when you heard Ms. Reed make this statement, that firefighter Flamati was on his knees providing CPR at the same time you were knelt down providing the airway.
This isn't when it was
That's
stated.
not my question. Is that what you said?
Can you repeat the question, please?
Sure. You indicated earlier when you heard this statement by my client, you were very detailed. Firefighter Flamati was knelt down providing chest compressions at the same time you were knelt down providing airway support for Mr. O'Keefe, correct?
I had also said that at some point,
That's a
Firefighter
yes or no
Flamati
question.
So I'm going to let the witness answer the question.
had transferred CPR to Firefighter Kelly. Firefighter Kelly did take over compressions at one point.
Okay. That's not my question.
Okay.
My question is an easy one. Did you say that when Miss Reed walked over to you and you had this dialogue with her, she made that statement that firefighter Flamati was on his knees providing chest compressions at the same time you were knelt down providing airway support?
Yes, sir.
Okay. Firefighter Flamati, your testimony appears to be standing up right there, correct?
Yes, sir.
Let's play the video forward for just a second.
He's going to continue
Stop it.
standing there,
What
I'm
did you
guessing.
see firefighter Flamati do just now?
I believe he just knelt down.
Okay. So at this point, he's kneeling for the first time, correct?
Yes, sir.
And he's about to provide chest compressions as your memory serves, correct?
Yes, sir.
All right. Let's go ahead and play it forward. Pause. Did you see my client in that photo? I'm sorry, in that clip?
No, sir.
You didn't see her?
Oh, no, I did see her, yeah.
Yeah.
I don't see her on right now.
Right. She just walked off frame, correct?
Yes, sir.
Let's go ahead and play it forward. Stop it. You see my client walk back into the frame?
Yes, sir.
At this point, you were watching firefighter Flamati. He appears to be now providing CPR, correct?
Yes, yes, sir.
Okay. And my client is nowhere near you, correct? At least for this clip.
No, sir.
Okay.
Correct.
And the clip that I just played before, the few seconds that I played before, nowhere near you, correct? Is that right?
Yes, sir.
Let's go ahead and play it forward. Pause it, please. What do you see happening on the screen from screen right to screen left at this juncture?
We're bringing in the stretcher.
Okay, go ahead and play it. Pause it. Do you see where my client is right now?
Can you back it up 2 seconds? I'm sorry, I lost
With
view.
the court's permission, I need to ask the
Yes.
court's permission. Thank you. Okay, let's go ahead and play it. Pause. Did you see my client?
Yes, sir.
Where is she in the frame?
Behind that other individual.
Behind the SUV?
I believe she's in front of the SUV and behind the other individual.
Okay. I meant the SUV, that's the white SUV that's in
Yes, sir.
the far distance.
Yes.
That's the back of the SUV. She's behind it, right?
Correct, yes.
Okay. Not near you.
No.
Okay. Let's go ahead and play it. Go ahead and pause it. Do you see what firefighter Flamati is still doing throughout this entire clip?
Chest compressions?
Okay, let's go ahead and play it. Pause. What's happening now?
We're Mr. O'Keefe's on the scoop stretcher and he's being transferred to the ambulance stretcher.
So that's the entire time Mr. Flamati, firefighter Flamati, was giving chest compressions. It's captured right here on this video, correct?
Yes, sir.
Okay. And now Mr. O'Keefe is up on the stretcher, and you are no longer knelt down?
No, sir.
And firefighter Flamati is no longer knelt down?
No, sir.
And you're now following the stretcher with, it looks like, 2 or 3 other EMTs, correct?
I am not in that frame, sir.
Okay, so you've walked away.
Yes, sir.
All right. Let's go ahead and play it forward. Pause it. You see where my client is?
Yes, sir.
Go ahead and play it. Do you see firefighter Flamati or firefighter Kelly continuing to give chest compressions?
Yes, sir.
Which one is that? Do you know?
I believe it's firefighter Flamati.
Flamati?
I believe so.
Okay, so he's still doing all the chest compressions from start to finish?
Yes, sir.
Okay. And what's happening right now?
Now we are transferring to ambulance 1.
And where's my client?
Right front and center.
May I have just a moment, Your Honor?
Yes.
We can realize that.
So basically not what he described at all. Which we kind of already knew because Kelly said he heard nothing in the first trial. Maybe that's changed now.
If I may have just a second. With regard, just a couple of more questions with the court's permission.
Okay.
I'm going to change gears with regard to what you talked about on direct examination, the hypothermic conditions. You're not a medical doctor, correct?
No, sir.
You don't diagnose patients?
Sir.
You're not diagnosing that John O'Keefe suffered from hypothermia that night?
No, sir.
Thank you. That's all I have.
Okay. Can you follow up?
Please.
Didn't follow up on the bile.
Firefighter Nuttall, the video the defense just showed you, did you notice any differences between that video and when I showed it to you, and that it doesn't have the time on it?
Yes, those were 2 different time frames on that video.
And when we spoke about when the defendant said to you, I hit him, that wasn't shown to you in that video just now, was it?
No, it was not.
So if we go back, will you be able to explain where you came from and firefighter Flamati came from and when you first went over to John O'Keefe?
Sure.
With the court's permission, Ms. Gilman, if you could start that video. I think it is 6:11, please.
6:11.
Now stop it there. Do you see that this exhibit has timestamp on the top?
Yes, sir.
Okay. Please continue. Could you stop, please? Do you see the red lights on the left?
Yes, sir.
Is that when you believe that you first arrived?
Yes, sir.
And that note says 6:11:05. Could you continue, please, Ms. Gilman? Please watch to the left. Stop, please. Is that when you first arrive and walk over to help John O'Keefe?
Yes, sir, that's me.
I'll note that the timestamp is 6:11:21. Okay, continue, please. Stop, please. Did you see firefighter Flamati come after you?
Yes, sir.
Was any of this shown to you during those questions?
No, sir.
No. Continue, please. Stop, please. Do you see the defendant in that screen?
Yes, sir.
Do you see her moving from right to left towards you?
Sustained as to the form.
Okay. What direction do you see her running in that screen from right to left?
She's running towards where the three of us are grouped.
Okay. Please continue. Stop, please. Is it at that time the defendant said to you that she hit him?
Yes, sir.
And you remember that?
I do.
Okay. I'm done with the tape. Thank you very much.
Well, yeah, because Pulmati is walking away, it looks like. He wasn't on his knees. It was very hard to track who was
You were
doing
asked
these
questions
videos.
about your memory?
Yes, sir.
Okay. When you were asked the questions about Trooper Proctor, when you were saying that you didn't remember, were you referring to the conversation with Trooper Proctor, or were you suggesting you didn't remember what happened that morning?
I don't remember the interview with Trooper Proctor. I remember it happened. I don't remember the substance of what was discussed entirely. I remember we discussed that morning, but.
Do you know if that conversation was recorded or just a conversation between you and the trooper?
I do not know if it was recorded.
You asked questions. I want to ask you about questions on Mr. O'Keefe, and you mentioned that there was some type of blood clotting on the back of his head?
Yes, sir.
Okay. You noticed there were abrasions on his right arm?
Yes, sir.
You noticed there was a hematoma on the right side of his head?
Yes, sir.
Did you see any bruising on his right knee?
Don't recall, sir.
Did it stand out to you that all of his injuries, all of them that you saw other than the cut on the back of the head, that they were all on his right side?
Yes, sir.
Did you notice any hematomas on his left side?
I did not.
Did you notice any scratches or abrasions on his left side?
I did not.
Did you notice any marks that would be consistent with an altercation on the left side of his body?
I did not.
You were asked about the cause, and you said that you don't know the cause. You weren't there, were you?
No, sir.
You asked if it was consistent with being punched, and you said it could be.
Yes, sir.
Could it be consistent with being clipped by a car?
Objection.
Sustained as to the form.
You were asked questions about clothing.
Yes, sir.
And you had at one point said you thought that Mr. O'Keefe was wearing a winter jacket. Do you have any memory that when you first got there, or when you first got there, do you have any memory whether there were any towels wrapped around Mr. O'Keefe's head?
I remember there was a white cloth of some sort on the scene.
Okay. And when you were asked about your memory regarding the clothing, was the clothing of what was utmost importance to you at that time?
No, sir.
And why is that?
I was, again, focused on Mr. O'Keefe's airway and ventilation.
Okay. And when you were asked about the clothing, do you remember if you added anything else about your certainty or uncertainty about clothing when you previously gave a statement or testimony?
I believe when I testified last year, I did note I had no part in removing any articles of clothing or anything like that. That was not my job in the back of the truck.
Do you remember any recognition of the fact whether you were certain or not about clothing?
Repeat the question, sir. I'm sorry.
Well, is there anything that would refresh your memory about what you had said about clothing?
Objection.
Ask a different question first.
You had mentioned that you had some difficulty about clothing. Do you remember what you had previously said?
I remember there was some difficulty of getting the individual's fingers through clothing just because they were so cold. They were difficult to manipulate. Just they really was not conducive to getting clothing off easily.
Okay. You met with me 3 times?
Yes, sir.
I had not met you before any of your prior testimonies, had I?
No, sir.
Do you remember meeting with me and discussing this case with me?
I do.
Do you remember me asking you to tell me what you remember?
I do.
Do you remember what I told you about testimony when you come into court?
Yes, sir.
What would I tell you?
I remember we discussed that just tell the truth.
Did I tell you that it doesn't matter? There is no side. Doesn't matter if it helps or hurts, that you just tell the truth?
Sustained.
Did I ever suggest to you that you should stick to a story?
No, sir.
Did I ever suggest to you you should offer your testimony in any certain way?
No, sir.
When I talked to you, did I ever ask you to say anything about your testimony to this jury?
No, sir.
Other than what?
Speak to the jury.
Did I need to tell you to tell the truth?
No, sir.
And in telling the truth, did the defendant say to you, I hit him, I hit him?
I'll allow it.
Yes, sir. 3 times.
And in fact, do you remember, in addition to her saying, I hit him, I hit him, I hit him, when you asked her the question, kneeling down over John O'Keefe's body, do you remember if you ever talked about other times that she said it, not to you?
I do not.
Okay.
The answer is I do not. Next question.
Okay. Do you remember testifying previously in this case?
Yes, sir.
Okay.
So he remembers some things. It's good that we've established that.
Do you remember at all discussing whether or not, after she left you, whether or not the defendant was still talking and speaking?
I'm sorry, sir. Repeat the question.
Do you remember after the defendant left you and made that statement to you, do you remember talking, did you hear her speak to other people after you?
I heard her having conversations in the background, but that was not my focus at that time.
Okay. And during those conversations in the background, did you hear her talk about that same issue again?
I believe she said it several times, but the 3 times she said it to me were what stuck out to me.
Okay. And when she said it to other people, it wasn't directly to you?
No, sir.
So watch the form of the question, Mr. Brennan.
And when she said it to,
the objection.
when she said it to other people, do you know who she said it to?
I do not.
I'll allow it. So the answer is I do not.
I'm sorry.
Do you remember when she said it other times who she said it to?
I'm going to see counsel at sidebar for this.
So now, of course, they're trying to blow it up because they already know. The problem here is that Mr. Kelly, who's supposed to be right there, according to Mr. Nuttall's testimony, he testified that he did not hear her say that. That what he heard her say was, he's dead, he's fucking dead. And that she said that multiple times. Did not hear, I hit him, I hit him. He denied that, repeatedly. He's said the same things multiple times. So Flamatti's version is a problem. It's not going to line up with Kelly's version. He says Kelly's right there. Kelly says something different. So now they're trying to turn it into, she's saying this to like everybody at the scene all the time. And that's why it's not inconsistent. It's just describing different things on different occasions, right? So now it's like she's constantly saying, I hit him, I hit him, I hit him, because she has to have said it under all of the different circumstances in which people reported hearing that. That's the only way for it all to be true, right? So she's saying, I hit him, I hit him, I hit him to various people at the scene, and nobody followed up on this. She left. Nobody did anything. That's what we are to believe. Mr. Brennan sure did take that cross-examination personally, didn't he? Oh, he was quite outraged at having that finger of impropriety pointed at him. The coaching of the witnesses, the oddness of needing to meet 3 times to verify that she said 3 times, I hit him, I hit him, I hit him. Nothing else really to talk about. Had to watch that video and you know, give him a chance to remember when that might have happened. And yet it turns out he still can't tell the correct story, because even after having watched it, the people are in the wrong places doing the wrong things at the time that he said that this is happening. Took that very personal. I wonder if that goes back to the opening statement. That was another thing that Mr. Jackson did, right? He said that the corruption, it taints not just the law enforcement, but this prosecution. And he pointed his finger. He pointed his finger at them. I think he took that a little personally.
Sir, after the defendant came over to you and spoke and then left, do you remember hearing her make further statements?
Yes, sir.
And do you remember her making further statements similar?
I do.
To the statement to you?
Yes, sir.
Could you share with the jury what you remember her saying, not to you, but after she left you?
I remember hearing I hit him several other times. Again, not directed to me, just kind of off in the background. I'd like to reiterate, we were really focused on the patient at that point. We were trying to provide care.
Thank you, sir.
This has become absurd.
So now, after Mr. Brennan asks you a few questions, now you remember her saying, I hit him a bunch more times. Correct?
I remember hearing it in the background several other times.
Really?
Sir?
Never mentioned that on direct examination, did you?
I don't remember being asked about it, sir. I remember saying what was asked to me.
You were asked, did you ever hear the defendant, Ms. Reed, say anything about I hit him? And your answer was, she said to me, in answer to my question, I hit him, I hit him, I hit him 3 times, and that's it.
To me.
You didn't clarify that, oh my gosh, she's running around like a chicken with her head cut off, screaming, I hit him to everybody else under the sun.
It was, again, it was behind me in the background as I was providing patient care. Again, that was not my focus.
Okay, so you didn't really hear her say anything in the background because you weren't focused on that, right?
I remember hearing a generalized commotion in the background, but again, that was not our focus.
So generalized commotion is very different than hearing her say, I hit him to other people, correct? You'd agree with that?
Yes, sir.
So what you actually heard was the chaos and the commotion of a chaotic scene, correct? In the background.
In the background.
As you focused on your patient care, correct?
Yes, sir.
Okay, not specific words coming out of my client's mouth, correct?
To the question that I posed, do you know him?
You're right. We're off that question.
Okay.
That question, I got it.
Yes, sir.
Triple I hitters.
Correct.
But with regard to what Mr. Brennan just asked you, the generalized commotion, to use your phrase, in the background, you didn't hear any specific words coming out of my client's mouth, did you?
I heard I hit him. But again, it was in the background and it was not my focus.
Well, why didn't you say that on direct? That's kind of an important point. That's why you're here.
Again, if it was neglected on my part, it was not intentional.
Not intentional to neglect that part for the jurors on direct examination.
No, sir.
Certainly not intentional to neglect that part of your testimony on cross-examination.
No, sir.
But you decided to bring it up on recross examination when Mr. Brennan is asking you questions again, correct?
It was asked of me. Yes,
and it was after, of course, that your new statement that you've never testified to before, ever, is this generalized commotion included a bunch of I hit hims in the background, correct?
Sir.
And that comes after you saw the video that clearly shows that when you describe having heard this statement, my client was nowhere around you, correct?
That segment of the video that you showed me?
Yes.
That was not the time frame in which she said that to me.
Well, that was the time frame when Flamati was giving CPR, correct?
He was doing CPR down prior to that as well.
Really?
Yes, sir.
Well, you just testified that you saw him standing up in a big yellow jacket and then kneel down and start giving CPR.
We just watched that video.
But again, the clip of the video that you showed me,
Right.
that was not the segment in which you said that to me.
Well, that's what you're saying now, but what I'm asking is, you described a very distinctive scene, a very, very specific scene.
Yes, sir. I remember it vividly.
She said that I hit him, Frank, when Lamani was down giving CPR, and you were kneeling down giving airway support, and he was doing rhythmic CPR chest compression.
Yes, sir. That's what happened.
And then I showed you that very scene, didn't I?
You showed me that clip prior to that.
I showed you the very scene that you described where Lamani gets down and starts chest compressions and never stops until the gurney is taken off the frame of the camera to the audience. Isn't that what I showed you?
That is.
Sure. I don't know if I can do it again. I showed you the scene where firefighter Lamani gets down on his knees, begins chest compressions, and never stops until that gurney is taken off camera, off frame, into the ambulance. That's the clip I showed you, correct?
That is the clip you showed me.
And that's exactly when you described your vivid memory from 3.5 years ago. That's exactly the scene that you described when my client supposedly said I hit him to you, correct?
Again, the clip that you showed me, that was not when it was said. That segment that you showed, that was not when it was said. It was said prior to that, when the three of us were together.
So Lamani was not giving chest compressions then?
He was. The CPR was a continuous effort throughout the resuscitation.
But we saw him start it. Officer, Firefighter Nuttall, we saw him start it. We saw him walk into the frame, kneel down, and begin the chest compressions, didn't we?
We did.
And at no point, at that time or after, did my client even approach you, did she, in that clip?
She did.
What?
We just watched it.
Objection.
Just a question.
Sure. Do you need to see that clip again?
Yes, please.
We're not going to show the video again. We've seen 2 videos. Which one is marked?
The
The
Commonwealth.
one with the timestamp
Right.
at the top?
It's the exact same video. One has timestamp, one doesn't. Just to be clear, you described a very detailed scene in which firefighter Flamati got down on the ground on his knees and began CPR.
Yes, sir.
We saw a clip that it played fully through.
Mm-hmm.
Starts and stops, but it played fully through, correct?
Yes, sir.
That was true and accurate video of what happened that day,
Yes, sir.
that morning, correct?
Correct.
And from the time firefighter Flamati began his CPR, he never stopped. Went all the way through until the gurney was taken off the camera, correct?
Correct.
You also described very clearly before you saw the video that the time when my client walked over and you had this dialogue and you heard this statement, it was during the time that firefighter Flamati is given the CPR, correct? You described it.
Yes, sir.
But when we actually see firefighter Flamati giving the CPR, as per your description, at no time did my client walk over and have a conversation with you, did she?
She did in the video.
But not when
In the
you
portion
said,
that Mr. Brennan played you, was firefighter Flamati giving CPR at that point?
As I said previously
Was
as well.
he or was he not? Yes or no?
Objection.
I'm going to let the witness answer the question.
Firefighters Kelly and Flamati were trading off CPR. Tony started doing CPR, and it was passed off at one point to firefighter Kelly. Firefighter Kelly at that time was a BLS EMT. Firefighter Flamati was a paramedic. They're going to move towards firefighter Kelly performing CPR because at that time his skill set was not as advanced as firefighter Flamati's, as Tony's. But they did switch off. That is a routine cardiac arrest. We switch off compressions.
Handed off
But
to
the
Kelly.
video that Mr. Brennan showed
But
you
that didn't
was
happen.
earlier in time, a few seconds or a minute or two earlier.
Yes, sir.
You'd agree with that, correct?
I would.
And firefighter Flamati had not begun CPR, had he?
I don't believe so.
That's right, he hadn't. But that's the time that my client walked over your general area, correct?
Correct.
Before CPR was started, correct?
CPR was started immediately, sir.
Can we wrap this up?
I don't know if we can, Judge.
Give you a
Good
couple more
job,
minutes.
Ellen.
Do you understand the confusion?
Objection.
Sustained.
All right, a couple more questions on this. The video that Mr. Brennan showed you,
Yes, sir.
and you pointed to and said, oh, that's the time when she walked over and said the statement.
Yes, sir.
Remember that?
I do.
Firefighter Flamati was not even kneeling down giving CPR, was he at that point?
No,
The answer is yes or no?
no.
Okay, he was not. Later, as the video continues to run, at some point, we see Firefighter Flamati enter the screen, kneel down in that bright, reflective yellow jacket, and begin CPR, correct?
Yes, sir.
You had previously said that when you heard the statement and she walked over to you, it was when Firefighter Flamati was giving CPR, correct?
Yes, sir.
And at no point, you'll agree with me, we just played the video, at no point after he started giving CPR did my client come anywhere near you. Isn't that what the video showed?
That was the segment that you showed me.
You indicated on on redirect, that Mr. O'Keefe did not have any injuries to the left side of his body.
Not that I recall.
Isn't it true
Now he
that
qualifies it.
in addition to the egg on the right side of his head, he also had a black eye on the left side?
I remember that the swelling had started to, it's referred to kind of as raccoon eyes. It's a bruising of both eyes.
Do you remember
battle
saying,
signs.
Do you remember saying, in answer to the question, did it look like in addition to the egg on the right side of his head in the front, did he also have a black eye on the left side? Your answer is, if memory serves correct, yes.
Yes, sir.
So it's not true that he didn't have any injuries on the left side of his body or face, correct?
That swelling kind of migrates over time to both sides. That is a common occurrence for both eyes to be swollen.
Did he have an injury to the left side of his face?
He did not.
Did he have a black left eye?
Yes, he did.
Would you consider a black eye an injury?
You don't have to make this point, AJ.
Yes, sir.
Let me ask you the question again then. Did he have an injury to the left side of his face?
Yes, sir.
Thank you.
You don't need to go anywhere further, Mr. Jackson.
One last question. You indicated that it was a chaotic scene outside on that front yard.
Yes, sir.
Fire engines, ambulances, patrol vehicles, engines running, diesel engines, flashing lights, people screaming, people talking over the howling wind, correct?
Yes, sir.
Did you ever see the homeowner come out the front door?
Technically
don't
young
recall.
scope.
You don't recall, or you didn't?
I have no idea who the homeowner is.
And you never saw anybody come out the front of the house?
No, sir.
That's all I have.
One issue. Briefly.
I want to see counsel at Sidebar.
She doesn't like this ping-ponging back and forth. She's going to start putting limits on it. She definitely should let him show the video again if he's continuing to futz about with what's shown on the video and what's not, but it doesn't really matter because we can just revisit it with Mr. Flamati if we need to when he gets on the stand. Now, okay, that's going to be interesting. What does Mr. Flamati have to say? Because he testified in the first trial that he heard the I hit him, I hit him, I hit him. Let me just try to get that context here. It was when she was attempting CPR. I hit him, oh my God, I hit him. And that it was very loud, that he followed up with questioning with your hand, and she would repeat, I hit him. And then they initiated CPR. So it's actually a little bit more consistent with what Flamati remembers than what Mr. Nuttall has described. Maybe they won't revisit it. As we'll see.
Sir, in Mr. Jackson's questions, he asked if you had ever said that you heard the defendant say, I hit him, separate from when she approached you. Do you remember previously testifying that you heard her saying, I hit him in the background, separately from you?
Yes, sir.
You remember testifying that before under oath?
Yes, sir.
In court?
I do.
Anything, Mr. Jackson?
Yeah, just a second, Ron.
That's weird because I don't think any of us do. Maybe in the grand jury?
I'm sorry.
On redirect last time, he said he remembered, I hit him, I hit him, I hit him. Then patient care took priority. Then he remembers the other woman saying, be quiet. So I don't think we're talking about the last trial. We'd have to be talking about the grand jury.
Yes.
Just a quick question, Firefighter Nuttall. When you were asked to recite your memory of that day on February 8th, 2022, just 10 days after this incident, did you ever say that you heard in the background, I hit him over and over again?
I don't recall.
All right.
When you testified at the grand jury, last question, when you testified at the grand jury, did you ever say that?
I don't recall.
But again, your memory is better now than it was then. Right?
Yes, sir.
All right. Firefighter Nuttall, you are all set.
Thank you, ma'am.
You are all set.
All right, your next
Go on
witness,
that.
Mr. Brennan.
Thank you. The Commonwealth calls Kerri Roberts.
Jumping straight to Kerri Roberts. Interesting. The one who was in charge that morning now.
In the
All
stand,
right,
I did have an exhibit I would like to introduce and play for the jury.
Okay.
And this is clip 2.
No objection from the defense?
No, Your Honor.
And you're marking this as an exhibit?
Yes, Your Honor.
Okay. Do you have
Kerri
something for the court
Roberts.
reporter to mark?
Team last time.
We can put it on a zip drive. We can discuss collecting all the clips and putting them on the same zip drive, or we can use different zip drives, whatever the court's preference is.
So we need something. So we need something physical. You can play it and then we'll mark it.
Ms. Gilman, do you have a
Yeah,
separate
you really
clip?
need it to be
Jim, is that right?
consistent.
Thank you.
This was an issue
I
last
can have
time
this
too.
marked, Your Honor.
Thank you. All right, Ms. Roberts, please. Okay, thank you.
We'd like to play this first and then call Ms.
Oh,
Roberts.
okay, I'm sorry.
Thank you, Your Honor.
Did they come back to you with something? I mean, how much do you remember?
I remember it, but I question, do I remember it because it's been relived so much? I mean, when I see the video of me driving from the waterfall, like what I just described, tapping the brakes when I crossed the intersection, Washington over Sherman Street, do I actually remember that I kind of slowly proceeded through that green light? No, I don't actually remember that. But I've seen the video so many times that you then question, did I remember on my own? Or was my memory jogged? But I also wondered, did I say, could I have hit him? Or was it told to me that I said I hit him? And I knew I never could have said that. So the closest I must have said was, did I hit him? And I know I said I hit him, but did I really say it as many times as law enforcement's claiming I said it?
Oh, cut that off right there.
Thank you. I'd now call Kerri Roberts.
Raise your right hand. You solemnly swear the evidence given to the court and jury in the case now hearing to the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
Thank you.
Kerry.
All right, Mr. Brennan, whenever you're ready.
Thank you, Your Honor.
Ms. Roberts.
Good afternoon, ma'am.
Good afternoon.
Could you please introduce yourself to this jury?
Hi, my name is Kerri Roberts.
Ms. Roberts, where do you live?
I live in Canton, Massachusetts.
How long have you lived in the area for?
I was raised in the Boston area, North Shore, South Shore. I went to high school in Braintree and I moved to Canton about 12 years ago.
Do you live alone?
No, I live with my husband and 2 children.
How old are your children presently, this day?
My son is 13, my daughter's 15.
Do you work?
Yes, I do.
Without identifying specifically where, can you share with us a little bit about what you do?
I'm an executive assistant and I've been with my company for 18 years.
Ma'am, if you could just move the microphone just a tiny bit closer. Thank you very much. You have 2 children, you're
Yes.
married,
Yes,
and you live in the area.
yes.
I want you to tell us whether you know a person by the name of John O'Keefe.
Yes, I do.
Would you be willing to share with us when you first met Mr. O'Keefe?
Well, I went to high school with John in Braintree. He played soccer, I played soccer, so we probably hung out in middle school, but we went to 2 different middle schools. And then I hung out with him more in high school. He was a year older than me. His sister was 2 years older than him in school, and his brother was younger, so at some point I was in high school with each of his siblings.
Did you at some point become friendly with John O'Keefe?
Yes.
Could you tell us about that?
When his sister Kristen passed away, and then her husband Steve passed away, they lived in my neighborhood. John took over for the children and moved into my neighborhood as well.
When John took in the children, did you offer any assistance or any help to him?
Yes, before John was even going to take over, he was going to potentially move in with his brother-in-law and the children to help out. And then when his brother-in-law passed away unexpectedly, John took over and I jumped in because I was a friend from high school that he knew and he had all kinds of people helping, but he sort of said, I'm going to lean on you for right now because I know you best. And I knew his parents and his siblings. And so I introduced him to my husband and we jumped in. It was, preschool drop-offs, preschool pickups for my son and his son. And just from then until the time of his death, we were just friends, very close friends. And we hung out all the time. The children hung out all the time. And he was the emergency contact list at my children's school to call if something had happened.
Were you close friends before he took over the care of the children?
No, I wasn't very close friends with him then.
Were you close with his family before he took over care of the children?
No.
Did your friendship with him develop after he took care of the children?
Yes.
You mentioned you have a son,
Yes, I do.
and is your son the same age as John's nephew?
Yes.
Was there any common interests or activities that engaged your son with John's nephew?
Well, they went to in-home daycare together. They went to preschool together. They went to pre-K together, and they went to elementary school. They played baseball together since they were T-ball. My son plays hockey. Patrick tried hockey. He didn't like that. So we spent a lot of time at the baseball fields together.
As you spent a lot of time together and had mutual care of children, did your relationship with him grow closer?
Yes.
And can you share a little bit with the jury how close you became?
Well, John was a bachelor and he didn't have any children of his own. So when he took over for the children, he sort of, leaned on us to kind of guide him and, all the things to do if someone has a headache and, if there's an ear infection or, he had his mom and dad also helping as well, but I was right up the street. So if I would go to BJ's, I would call and say, can I grab you anything? If I would go to Walmart, any of the places I would go, I would call and say, do you need anything? Can I help you? Can I grab something for you? And he did the same. We just sort of all chipped in, helped.
As your friendship grew, could you tell us a little bit about your relationship with John?
John and I were very close. We spoke on the phone and hung out. He became very close with my husband as well because he was right down the street. But we just had a friendship, a very close friendship.
Tell us about the day-to-day activities and how you would try to assist John with the children.
Well, John moved across town. I don't remember when. I forget how many. Patrick, I think, was in 5th grade or 4th grade. And I would take him home with me on Wednesdays because John would be working. So it was more of a, if he was at my house and my daughter needed a ride the other side of town, he would take her with him. We were just very close friends. We did a lot together. We would do baseball tournaments together. We would have drinks together. We would, all the things friends do.
As you grew closer to John and helped with the children, did you become closer with his family?
Yes.
And who specifically did you become closer with?
Mrs. O'Keefe and Mr. O'Keefe, his parents, and Paul I would see from time to time, but not a lot. He doesn't live in Canton. But Mr. and Mrs. O'Keefe would be there all the time to help as well. And Mr. O'Keefe would take my son and Patrick, the nephew, out to Dunkin' Donuts all the time.
Oh, he would take him to Dunkin'.
Can you tell us a little more about the collective effort of other people, including his family, helping John raise these children?
There was a lot of us that jumped in to help. It was not just me. There was a lot of Kaylee's friends' parents that jumped in and helped out for Kaylee, his niece, and Patrick. There was a lot of us that helped out with Patrick. All of the community all came together to help him because there was this guy that just lost his sister and brother-in-law, and he stepped in to take care of his 2 kids, and he didn't really know what he was doing at first, but he got the hang of it pretty quickly.
You have a son that shared a lot of interests with his nephew.
Yes.
He also had a niece.
Yes.
Did you spend more time helping with his nephew or with his niece?
With his nephew.
Were there other people in the community you knew of who spent more time helping with his niece?
Yes.
And who was that?
Jen McCabe.
Did you know Jen McCabe?
I had met her once. John got a discount at Reebok, so he would take the kids. Well, he would take anyone with kids up with him to get shoes, like sneakers for back to school or whatever. So one day he did take Jen and I up to Reebok, but other than that, I never talked to her on the phone. I never saw her out. Her children are older than mine, so we never really crossed paths.
As it relates to the night of January 29, 2022, how much earlier was it that John took you out with the children and Miss McCabe out with her children to get sneakers? How many years before that?
Years, like 6 or 7 maybe.
Okay. And from that time you met
I think it was 6
Jen
or 7.
McCabe in the years past. Did you ever spend time with her again before January 29th, 2022?
No, I did not. I didn't know her.
Were you friends with her?
I was not.
Did you speak on the phone with her?
No, I did not.
So other than that one meeting, you were strangers?
Yep, that was the only time. I knew her. I knew of her. She has 4 girls, but I didn't know her.
At some point, as you were part of John's life, did you learn that he was dating a person by the name of Karen Reed?
Yes, I did.
And do you see that person here in the courtroom today?
Yes, I do.
Could you point her out and describe an article of clothing that she's wearing?
She has a black suit jacket seated at the front table.
When did you first become familiar or know about Miss Reed?
July, I think it was, of 2020. John, we were having people over, and so I invited him, and he said, I'm going to bring Karen over. And I was like, I don't know who that is, but okay. He assumed I knew because he had been dating her for a little bit, but it was COVID, so we didn't see him very often during that time.
Good friends.
So Karen came over that night.
And this is early 2020?
I think it was summer, so I think it was around June or July.
Briefly, just tell us a little bit about where and the circumstances of meeting John and Karen for the first time.
They came over to my house and we hung out on the back porch, had some drinks. There was music, the kids were around. Just a nice, normal summer night. We had other people over as well.
Over the next coming months, did you become more familiar with the defendant?
Yes.
Did you see her more often?
Yes.
And could you generally describe for the jury how you learned more of her and saw her more often?
She would take care of the kids a lot. Mainly, well, not mainly Patrick, but not mainly Kaylee either. She helped out a lot with the kids. So if we were at baseball, she would come to all the baseball games, or she would drop off or pick up my son or Patrick if they were going to the golf course or the driving range.
Would you see her during events with your son and John's nephew?
Yes. We did baseball tournaments. And
so when you go to baseball tournaments, would that be away, an overnight type trip?
One of them was down the Cape.
Okay. How often would you spend time with John and the defendant?
Not that often together, but John would stop by himself. My husband would go out more with John, but I didn't spend much time with the two, not a lot of time outside of the baseball field.
Did you become friends with the defendant?
We were friendly.
Did you ever spend time alone to go out or socialize?
I did not.
Would you see her when you would pick up or drop off kids, or she would pick up or drop off kids?
Yes.
Did you ever speak to her on the phone?
Yes.
In relation to what?
Corresponding with the kids, pick up, drop off, mainly Ryan and Patrick, not about Kaylee.
Did you ever spend any important dates or times or holidays with John and Miss Reed?
No.
I want you to take us ahead to January 28th, 2022.
Okay.
On January 28th, 2022, do you remember that day?
Yes.
Generally, what do you remember about the day of January 28th, 2022?
There was a blizzard coming, and it was my daughter's friend's birthday. So we were going to be going out celebrating that night, but we did it on the early side because there was a blizzard coming.
What was your plan for that evening?
We went bowling. We got dinner, then we went bowling, and then I came home because I wanted to be in before the snow started.
Had you communicated in any way with John that day?
Yes. He texted me. My son had an issue at school. Patrick had been dismissed, I think, for a doctor's appointment. So he did text me to see how my son was doing.
Did you simply text, or did you get a chance to speak to him that day?
I believe we just texted.
Did you go out that night after bowling?
No, I did not.
Was your husband home?
Yes.
Did he go out that night?
He did. He went out with John.
And do you know where he was planning on going?
They went to McCarthy's, a bar in Canton Center.
Had you been to McCarthy's before?
Yes.
Can you just briefly describe what McCarthy's is?
It's a restaurant bar. There's a large bar in the middle, the seating on the left and the right. It's right in the center of town.
Do you remember about what time your husband went out?
I do not remember exactly. I don't know if I got home and then he went out. or if he was already gone when I got home, I don't remember. But it was around, he went out around the same time that I arrived home, which was on the earlier side.
How many times had you been to John's home, would you say, over the past couple of years before this night?
Oh, many.
Many times?
Many times.
Were you familiar with the house and the driveway?
Yes.
May I approach you on?
Yes. Didn't hurt to do some foundational stuff.
Should I return to the podium and ask the questions?
You
John?
can ask them from there.
Thank you.
Ma'am, I'd ask you to take a look at that photo in front of you. Do you recognize what is in that photo?
That is John's house.
Is that a fair and accurate depiction of how his house looks?
Yes, it is.
I'd like to move this to evidence, please.
Okay, any objection?
No objection.
6.
May I publish to the jury, Your Honor?
Yes.
Thank you.
Thank you. You can take it down. I've shown you a second photo. Do you recognize what's in that photo?
Yes, that's John's driveway.
Is that a fair and accurate depiction of how John's driveway appears?
Yes, it is.
I'd move that into evidence.
No objection.
Okay.
Exhibit 7, so marked.
May I publish?
Yes.
Could. Thank you. I'm showing you a third photo. Do you recognize what's in that photo?
Yes.
And could you share with the jury what's in that photo?
It's the side of John's house looking up from the driveway.
Is there anything you notice on the side of the house?
The lights. Or the ring camera.
Are you guessing or do you know that's a?
No, I know there's one there
And how do you know that?
because I got a ring camera and I could look and see who was at my door. And then he said, why didn't you tell me about these things? So he bought one.
I move to introduce this photo.
Okay,
No objection.
thank you.
Exhibit 8.
May I publish, Your Honor?
Yes.
Ms. Roberts, with the laser pointer, could you just point at the picture and show where the ring camera is?
On this screen?
Yes, please.
Whichever one you can do.
Okay. Why isn't it working?
Nope.
It's on.
Okay, well, you know what, rather than use the pointer, why don't we can you describe where you see the ring camera on that picture?
It's in where the two lights are under the top window.
Okay, thank you. We can take that down. How many times would you guess you had been over to his house?
I don't know. More than 50,000. I don't even know. A lot. It was weekly.
That night you told us that your husband went out to meet John at McCarthy's, a bar.
Yes, he did.
Do you remember your husband coming home that night?
Yes.
Do you have any memory of about what time he returned?
I'm guessing, but somewhere around 10:30.
So I'm not going to let you guess. Do you know? Do you have it?
I don't know. It was around 10 or 10:30. I can't be exact.
Did you see him come home?
Yes.
What was the forecast for that night and the next morning?
There was a blizzard coming.
Was that part of the decision-making of going out or staying home?
Yes.
At that time, when your husband came home, did you look outside? Do you have any memory of what the weather looked like around 10:30?
I remember the snow started to fall somewhere around 12 because I remember looking out the window and I could see it starting.
And that was the beginning of the snowfall?
I believe so.
What was the weather out that night?
The weather that night, I think, was fine. It was cold, but it wasn't snowing yet.
I see. I want to move forward ahead. At some point that night, did you go to sleep?
Yes, I did.
Did you sleep through the night, Ms. Roberts?
Yes, I did.
Okay. At some point, did you wake up?
Yes, I did.
I want you to tell us what was the reason that you woke up.
I got a phone call at 5 o'clock in the morning from Karen Reed.
Were you expecting a call?
No, I was not.
Had you ever received a call at 5 in the morning from Miss Reed before?
No.
Share with us what happened that morning. What did you hear?
Karen called and the first thing she said was, Keri, John's dead. And then she hung up. And then.
When she said that, did you have a chance to have a conversation with her?
No, I did not.
Describe her demeanor when she said that.
She was yelling loud enough, my name. I think it was 3 times. It might have been 2. She was yelling loud enough that she woke my husband.
Your husband was sleeping next to you?
Yes, he was.
Was she loud, yelling, screaming?
Yes, she was very loud. She was screaming.
After she said, Keri, John's dead, did you know what she meant?
No.
And did you say this was around 5:15?
This was at 5. She called me at 5 on the dot.
After she hung up, what did you do?
I was half asleep still. I didn't know what was going on. So I started to get up and I think I tried to call her back. I know I tried to call her back, but I don't know exactly when because I was like, what? So my husband said, what was that? I said, I don't know. Something's going on. I don't know what's going on. That was Karen. And then I tried to call her back. I know I tried to call her back, but I don't know if she answered or if she called me back the next time I spoke to her.
After she called you again, did you have another discussion or did you hear her say something else the second time you spoke to her?
Yes, the second time she said, I think something happened to John. I think he got hit by a plow. He didn't come home last night. Kaylee was home. He would never leave her by herself, and I was not supposed to stay at the house last night. So I think something happened to him.
Did she say anything about drinking?
Yes, she said, we drank so much, I don't remember anything from last night. And I said, okay, where are you now? She said, I'm driving. And I said, you need to go home. Where's Kaylee? And she said, at home. I said, you need to go home and be with Kaylee. She cannot handle this, thinking, her uncle's missing. I said, you're going to get a DUI. You need to go home.
Was there anything else in the conversation that she said to you at that time?
She said, I'm going to drive to your house. Would you drive my car? And I said, yes. So at that point, I started to get dressed. I turned on the automatic car starter so it would warm up. Told my husband, I don't know what's going on. John didn't come home. And so I think my husband tried to call him and I tried to call him. And my husband said, you're not going anywhere. It's a blizzard. He's probably on somebody's couch. And I was like, I know, but she's really upset. I'm just going to go. She wants to come here. I'm going to drive her car. And then I went out to my car and sat and waited for her.
When you called John, did you get any response?
No, I did not.
As you were waiting for the defendant, did you make any other phone calls?
I did. When I was in the car, I thought to myself, well, she thinks he got hit by a plow. I'm going to call the police and see if there was any accidents or maybe something happened. They brought him in. And I spoke to the officer who said, no, nothing of that sort. I've been here all night. And then I called the Good Samaritan Hospital and Milton Hospital to see if they had anybody that was taken in an accident.
When you called the police to look for Mr. O'Keefe, did you call 911?
No, I called the non-emergency line.
Do you know if that call was recorded?
I believe so.
Okay. I'd like to introduce an exhibit.
Okay. Any objection?
No objection.
Okay.
Exhibit 9.
Well, that's the clerk for stating the exhibit numbers out loud.
When you called the police, what was your level of worry at that point?
I wasn't super worried. I mean, he didn't come home, but they were out drinking. So I assumed, like my husband said, he's probably on somebody's couch.
The second call you had with Miss Reed, can you describe her demeanor in that second call?
She was frantic. She was frantic. I mean, she couldn't find John, so she was very worried.
How soft or loud was that phone call?
It wasn't as loud as the first one, but it wasn't a regular conversation.
With the court's permission, I'd like to play the exhibit of the call.
Okay.
Brennan said, I'm calling because my friend's boyfriend did not come home last night. We were at waterfowl. And now she is calling me hysterical because she doesn't know where he is. You didn't take anybody outside the name of John Keith, did you? John Keith. Yeah, he's about to call, and it will be on phone,
No.
and he probably got a ride and got to someone's house. I don't know, but.
Yeah, no, we didn't lock anybody up or anything like that. And where does he live?
He lives on Meadow, there at present.
He lives on Meadow, Pleasant. Okay, and where is the wife home? You said your girlfriend?
His girlfriend, yeah, they were out having drinks, and then she left and expected him to come home at some point, and he never did.
Yeah.
And so I said to her, you know, my husband had been out with him earlier in the night, but then he obviously came home. And he has custody with me, the nephew for this year, and passed away.
Okay.
And so she knows when we can have to go down and have to be home. And so she's nervous because he never even called me.
Yeah.
So she's like, I feel like something happened. And I said, okay. Well, so call the area hospital and you'll be happy. I personally think he probably take him out to the castle. I don't know.
Yeah, where did he didn't drive last night?
No.
No. Okay. Again, it's more, it would be driven by you. She would have to, call in a couple of patients and talk to us. But I mean, as of right now, it's more, he didn't come home last night. Is this common sometimes? Yeah. With him?
No, that's why. He didn't tell me. That's kind of why she's more freaking out. So I figured I called the area hospital, and then I called Kansas police just to make sure, they said, like I said, it's not complete possibility or best people. If anybody put a picture up.
Yeah.
We get it off.
Okay.
And we're going to have a little bit of party or something.
Yeah, no,
Just come out.
I won't say I wasn't there. I was not here. But we haven't get any calls, anything like that. Nobody was arrested or anything like that. All right.
All right, well, thank you.
All right, no problem. Good luck.
Thank you. Bye-bye.
Were you in your car when you called the police station and the hospitals looking for John?
Yes, it was.
Do you know at that point whether anybody else had called the police station?
No, I don't know.
Do you know at that point if anybody else had called any hospitals?
I don't know.
How long did you wait in your driveway?
I don't know. I'm sorry.
Okay.
Maybe like 7 minutes, 8 minutes.
What were the conditions like out that morning?
It was bad. It was in the middle of a blizzard.
When you were outside in your car in the driveway waiting, describe the lighting conditions for us.
It was still dark out. It was 5 o'clock in the morning and it was snowing. So it was not great.
How was the visibility?
Not great. It was coming down really fast at that point.
You said that night when you went to bed, the snow just started. Had snow accumulated at that point?
No, I don't think so. It was just starting to stick.
I'm sorry, that was the night before, but at this point when you were in the driveway, had the snow accumulated?
Oh, yes.
Do you know how many inches it was?
No, I don't.
Okay.
Enough that the plows are out.
As you were waiting for the defendant, did she arrive at your house?
She did not.
What happened?
Again, I don't know if I called her or she called me, but eventually we connected on the phone and she said, I said, where are you? I'm waiting. And she said, I'm at Jen's house. And I said, Jen, who? And she said, McCabe, she's going to drive my car. And I said, okay, well, listen, they don't want cars on the road because it's so bad. I'm already in my car. I'll come there to Jen's house, stay there, and we'll follow each other and we'll go back and drop your car off. Did you look in the house for John? Could he just be in the house, passed out somewhere? And she said, no, she hadn't looked in the house. So I said, okay, now I'm going to come to Jen's. We're going to take the car home, drop it off. We'll check around the house. And then I don't know what the next step at this point was. I just wanted to check the house.
At the time you directed that you were going to meet at Jen McCabe's house and then drive to John's house, Was there any suggestion by the defendant where she wanted to go?
I didn't know where Jen's house was. I knew the street. I had dropping Kaylee off or picked her up a few times. So I said, stay on the phone with me so I don't know which house it is. And so when I got there, I pulled in the driveway and there was some conversation about.
Can I back you up and just ask you a little bit about the drive there? I don't mean to interrupt. When you left your house, you talked a little bit about the weather conditions. How long did it take you to get from your home to Jen McCabe's?
Oh, it's quick. Probably 4 minutes.
What was the driving like?
It was not good driving. That's why I didn't want two cars on the road.
Did you have any difficulty driving through that storm?
No, I mean, it was treacherous, but I was in four-wheel drive. I have an SUV.
You mentioned you didn't know exactly where Jen McCabe lived. Had you been there to drop off John's niece before?
Yes, but I didn't know which house it was because when I picked her up before, she was either getting out of the car at the driveway or waiting at the end of the driveway. So I didn't know which house it was.
I think I interrupted you, but were you telling us that as you drove to Jen McCabe's house, you were on a Bluetooth, on an open conversation with her to help with directions?
Yes, Jen and Karen were in Karen's car, and I was on the phone essentially with both of them.
Do you know what type of vehicle the defendant was driving at that time?
A Lexus SUV.
As you drove over to Jen McCabe's home and you had some guidance finding it, did you hear any conversations in that open line with, or even any statements by the defendant?
I remember when I pulled in behind her car in Jen's driveway, and at some point Karen said, my taillight, and I looked, and Jen she must have had the breakdown because you could see that there was missing taillight.
When you say missing taillight, was it merely cracked?
No, there was a piece missing.
Could you see that as you were parked right behind the defendant's SUV or Lexus?
She must have been applying the brakes because you could see it, but there was a lot of snow.
When you saw that the taillight had a missing piece, did you say anything?
No.
Did you think anything of it?
No.
How long were you parked behind the defendant's Lexus while it was parked in Ms. McCabe's driveway?
Not long. We were just, I pulled in and then we stopped, and then the next plan at some point in that conversation as well, or maybe on the ride, because now we're heading to John's house to drop a car off. I pulled out of the driveway, Jen pulled out, and I followed behind all the way to John's house. And at some point, Karen said, I left him at Waterfall. And I heard Jen say, no, I saw you pull up in front of my sister's.
Was anything else said about the broken taillight?
No.
You followed Ms. McCabe?
Yes.
Where did you go?
To John's house.
Did you arrive?
Yes.
I want to ask you some questions about when you arrived and what you did next.
Okay.
When you arrived at Mr. O'Keefe's home, you're in two separate cars. Who pulled into Mr. O'Keefe's driveway first?
Jen pulled Karen's car in first.
So Ms. McCabe was driving the Lexus?
Correct.
And the defendant was in the passenger seat?
Yes.
After you both pulled in, tell us what happens next.
We went, I wasn't sure if it was, at some point Karen showed us the taillight up close, but I didn't know if it was when we arrived or when we left. But we went into the house to look for John.
When the Lexus was parked by Ms. McCabe in Mr. O'Keefe's driveway, was it facing the street or facing away?
Facing where the basketball hoop is, not facing the street.
I'd like to approach.
Okay.
I'm going to show you a photograph. Do you recognize what's in that photograph?
Yes, that's John's driveway. That's Karen's car on the left and John's car on the right.
Do you recognize both those cars?
Yes, I do.
Do you recognize that photo as a fair depiction of his driveway?
Yes.
Do you recognize it as a fair depiction of the motor vehicles?
Yes.
Now, when you went there that night and you pulled in behind Ms. McCabe and the defendant, is there any differences between how that area looked when you pulled in as opposed to that photo?
Well, it was the early hours of the morning, so it was dark out, and there was much more snow. And
Other
there's
than
snow
this-
coming down.
I'm so sorry. You want to finish?
Nope.
Other than the snow and the lighting, is there any other differences?
Nope.
I'd like to introduce this as an exhibit, please.
All right, there's no objection, Mr. Jackson?
No objection. With the court's permission, I'd like to publish.
Okay.
And to help us understand, you see on the left is the house.
Yes,
There's a motor vehicle in the middle of the driveway, but it's the vehicle to the left.
yes,
And whose vehicle is that?
that's Karen's.
Is that where it was parked that night when you went into the house?
Yes,
In the motor vehicle to the right, you recognize that?
that's John's car or SUV.
Thank you, you can take that down. I'm showing you a second photo.
Okay,
Do you recognize that photo?
yes,
What is it?
it's the back of Karen's car.
Does it look like a fair and accurate depiction of her car as it appeared that morning in the early morning hours to you?
Yes,
Do you notice anything that's distinguished in that photo?
the piece that's missing in the taillight,
Which one?
the right passenger rear.
Do you know when, I'm sorry, do you know when this photo was actually taken?
I do not.
Although you don't know when it was taken, is that a similar depiction to your memory of how it appeared that morning at 5
Yes,
or a little after 5?
yes.
I move to introduce this exhibit.
Okay.
Objection. The court's permission, I'd like to publish.
Yes.
It's a big blown up.
We could take that down, please. After you arrived at Mr. O'Keefe's house, what was the plan to go inside? What were you looking to do?
To go inside and look and see if he was passed out somewhere. So we went in through the garage and I started looking. I think Jen ran upstairs to Kaylee's bedroom and I just started looking through the living room. Basement door was locked from the inside, so I knew he wasn't in the basement. And then I checked the other living room. He has a big house. Then I went to the top of the stairs to check his bedroom.
As you looked around, what was your mood?
What was my mood?
Yes, were you calm?
I mean, I was worried, so we were, at this point, Jen had already established that they went to her sister's.
Sustained.
Okay.
Jen had already.
Let
Hold
me ask the
on,
question.
Ms.
I'll
Roberts.
ask the question better. My apologies. How many rooms did you look through in John's house?
1, 2, 5 or 6.
Did you see Miss McCabe looking in rooms as well, searching?
She went upstairs when I was looking downstairs.
At some point, as you were looking, did you see the defendant?
Yes,
Was she looking with you?
she was in John's room.
What was she doing?
She was just standing there when I came up to the top of the stairs.
Did she say anything?
No,
Did she do anything?
no,
Was she searching?
I don't know. She was in the room.
What happened next?
At some point, Jen earlier had said,
Well, let's not talk about what was said. Okay. Let's
Well,
just talk about.
the plan
best
at
you
this
can,
point is to go to
memory of what was
34
done.
Fairview.
Ms. Roberts, I know that I'm just going to ask you to wait for a question
Okay.
because we
Maybe
can only
over
get one
here.
person at a time. So next question, Mr. Brennan.
Again, my apologies. And so as you're looking through the house, you don't find John. What happens next?
The plan was to go back to Jen's sister's house.
Who made that plan?
Karen wanted to go back there.
Well, tell us a little bit about that. How did that conversation come up, and share with the jury what was said?
And the car ride to Meadows, Karen said, I left him at Waterfall. And Jen said, no, I saw you pull up in front of my sister's. So then Karen said, we need to go back to your sister's. And I said, no, we're going to go to Meadows and we're going to drop the car and we're going to look there. Then we'll go there if we don't find him.
When you were at the house, Meadows, John O'Keefe's house, and you didn't find him, was there any further conversation about what the next steps would be?
I said, let's go. He's not here. But I didn't know where Jen's sister lived. So we got into the car. Jen was in the passenger seat. I was driving my car. Karen was in the back seat.
Did you
And Jen
begin,
was giving directions.
did you begin your way towards Meadows?
Yes.
And it was Ms. McCabe who was giving directions?
Yes.
As you began driving to head towards Meadows, in addition to trying to drive, were you doing
They're
anything
leaving
like
Meadows.
looking or searching?
Yeah. We were looking on both sides of the, I was looking on both sides of the road in case he was walking home.
Did you see Ms. McCabe searching?
Yes, she was looking out as well.
So describe a little detail about what you saw Ms. McCabe doing.
She was looking out the window as we were driving. So was I, as I was driving.
And where was the defendant during that time?
She was in the back seat.
Was there any conversation, comments, statements?
Well, she would be in the back seat, and then she would be in between Jen and I, in the back seat, and then
Okay. Was she saying anything?
Specifically, I mean, there was conversation on the way there.
Okay. Was she looking as well? Did you see her looking out the windows like you and Jen?
I don't know if she was because she was in the back seat.
As you drove to Meadows, what was the visibility? The same or better or worse?
No, it was poor.
You
Did you make your way towards Meadows?
I did.
As you finally got to Meadows, was the house on your left side, your side, or on the other side?
Are you talking about Fairview or Meadows?
I'm sorry, Fairview.
Okay.
Yes.
The Fairview house came up on the left-hand side.
Before you got to the house, is there a tree line between that house and the house before it?
Yes. There's a cluster of trees and bushes.
All right, take us back. I want to talk about that morning. As you're driving and approaching Fairview, tell us what you hear, what you see, what's happening.
Jen's giving directions, and it was really bad driving. I was white knuckling because it was getting slippery. Karen wouldn't put on her seatbelt, so because she was in between us again the whole ride, and then sitting back. But she was worried because we weren't finding John.
Were you having words?
Yes.
Tell us.
I said to Jen, where are we heading? And she said, my sister lives on Fairview. And I said, where is that? She said, off of Chapman. I said, oh, okay, near Spring Lane. At some point, Bella's mom came up.
Tell me what that means.
I didn't know who it was, but it was one of Kaylee's friends, Bella's mom. The directions, at some point, Karen was talking about Bella's mom to Jen, saying she never liked me. I didn't know who this woman was that they were talking about, but apparently Bella's mom lived near where Jen's sister lived on Fairview.
Did you learn any more about the relevance of Bella's mom?
No. Oh, well, I think John had dated her.
Objection.
I'm going to allow it.
So as you approach Fairview, tell us what happens.
As we approach Fairview at the house. You mean the house or the street?
Yes, the house.
The house. Jen said, my sister's house is right up here. And I said, okay. And as we approached the house, Karen from the back seat is now screaming, there he is, let me the F out of this car. And she's now kicking the back door to get out.
When you heard the defendant scream, there he is, and started kicking the car door, did you see anything?
I did not.
Did you see anybody?
I did not.
Did you look?
I looked.
Was there anything that impeded your ability to see far?
No, it was just snow.
How far could you see when she was yelling, there he is?
How far could I see?
Yes.
I mean, the visibility wasn't great.
Okay. Was she pointing or giving any direction?
No, she just said, there he is.
Okay. What happens next?
And then I unlocked the car. I looked over, I didn't see anything, and I unlocked it so she could get out of the back seat. I looked at Jen and I said, she's crazy. And then I turned around and watched, and she ran over to a mound of snow.
When she started running, before she got anywhere, did you see anything at that point?
I did not.
Were you looking?
I was looking. She said, there he is, so I'm looking around to see where he is.
And you could see nothing?
I did not.
Did you see her run around or directly?
She ran right over to the mound of snow.
Could you tell what the mound of snow was from the car?
Once she got to it, yes, it was. Once she got to it, you could tell it was a mound of snow that was the length of a body.
Okay.
All right, I'm going to stop you there, Mr. Brennan. I need to see counsel at sidebar for just a minute, please. Regarding.
Because they're going to stop her right here. She found that to be a very convenient time to stop. And they're going to continue with Ms. Roberts tomorrow. I've been tracking my notes from her first testimony as she's gone through it, and it's remarkably in line with what she said last time. There are, of course, a few differences. The first time she had testified that it was when they got to John's house that Karen showed her the broken taillight. She then changed that to after because they have the Ring camera video from when they arrived at
Ms.
the
Roberts,
house.
we're going to have you come back tomorrow. Okay. Jurors, we're going to break for today. So we're going to send you home. The same 3 cautions that I'll tell you every single day. Please do not discuss this case with anyone. Don't do any independent research or investigation in this case. If you happen to see, hear, or read anything about this case, please disregard it. Let us know. Please be extra careful with your social media. Okay? We'll see you tomorrow morning. Thank you.
Court, all rise, please. Jurors, hold your books, put them on your seats.
Doesn't sound like they're doing anything outside of the presence of the jury, but maybe they will. I don't know. I'll mute it just in case they come back, because we know these things can be a little bit unpredictable in this courtroom. So she had described Karen showing the video and how it, or showing the taillight and how it had a piece missing, like a rectangle piece with a piece of metal sticking out. And she remembers thinking someone's going to catch their sleeve on that or something. So that was her description of the condition of the taillight when she saw it. So we don't have that repeated. They are still in the courtroom, but it doesn't really look like they're doing anything. I'll just be ready to bring it back if, oh, yeah, they do want to.
And the motion to continue. All right, thank you.
Thank you.
Sorry, Chrissy, I didn't mean to do that.
So what did she do with them? Hang on, let me back up. Oops, not that far, my goodness. Gonna buffer. So I guess we're not going to talk about them. They're just aware that they're still hanging out there. Oh, I'm going to stop trying to skip it because five seconds are costing me a lot more in buffering. So we'll just wait them out. So anyway, she saw that. She said originally when they got to John's house, but they have the Ring camera video, so they knew. So then she's like, well, obviously it was when we left, but we don't have that on video. That's the piece of the Ring camera footage that is mysteriously missing. Bella's mom never liked me. Like all of this stuff is tracking very, very closely. She ran over to the mound of snow. I said, I saw nothing. I said, you're crazy. She's changed that a little bit. Last time it sounds like she's saying she said it to Karen, but this time she says she turned to Jen and said she's crazy. At some point she realized it was the shape of a body. So that's where they're leaving off. But so far it's a very close tracking. I mean, all the way down to these little stories like about the buying the Reebok shoes, going out on that trip with John and Jen, and that's when they met. Her description was a little bit different from last time of when how she kind of described meeting Karen and their relationship and so forth. Last time she said John contacted them and said Karen and I were going to stop by. I didn't know if he was going to surprise me with some random. Didn't know if he was going to surprise me with some random. So not really looking forward to meeting Karen already. And she described her as she was another person who took care of the kids. I'd coordinate her. We didn't do lunch or hang out like girlfriends. Just one time they came over and they had the baseball tournament down at the Cape. So a lot of those details still kind of repeated. It was a very thorough story, I guess, the first time, and those details are being carried over to her second testimony. Now, we know she didn't get crossed. She didn't get crossed in the first trial. What do we think? Is she going to get crossed this time? I kind of think she's probably going to get crossed. Kind of think she will. We'll see. But it's going to be some important details, I think, particularly relating to John's phone, because Keri is the one who reported that she took John's phone from the scene. They found it under his body when the EMTs lifted it up, and for some reason, the officers that are on scene didn't take the phone. Karen didn't take the phone. Jen didn't take the phone. Kerri Roberts took the phone. And so that's going to be a little bit important as far as it goes to the chain of custody and the activity that phone is keeping track of in terms of the temperature, in terms of the movements, and so forth. I think that's going to be very important. Part of the timeline, the more they can build out this timeline with more detail, the better picture the jury has of exactly what happened. And then they're not stuck trying to piece together this timeline from this video, this timeline from what this witness says. That's part of doing the jury's job for them. You as the attorney, put all that together, know what you need to elicit. So yeah, see a little bit about what's going to be coming likely tomorrow. I would just expect it to be pretty much the same as she testified to in the first trial, because so far it is tracking very, very closely. Still waiting to see what they're going to say about these motions. Dare I try to skip it for 5 seconds? All right, I'll try. I don't know why it's buffering like this. It's quite annoying, but this fast internet era, we don't have any patience anymore. I mean, remember back in the days of dial-up, how long it would take to try to skip a video for 5 seconds? Like you would never do it because you'd be waiting for an hour. I really don't know why. Okay, there they are. I think we were not.
April 16th.
Okay, Sam.
To enforce compliant with the court's April 16th ARCCA discovery order and the motion to continue. All right, thank you.
Thank you.
Sorry, Chrissy, I didn't mean to do that.
So we don't know. She just said that they exist. We know that they exist. I mean, are they supposedly coming back to deal with those? I wouldn't think so. It's the end of their court day for them. So I think the stream is probably ending. Well, I'll keep it on in the background just in case while we kind of recap where we were at today, go through your questions and comments. So, boy, not Flamati. I keep getting those guys confused. Nuttall, Mr. Nuttall, he did not do anywhere nearly as well this time as he did the first time. Really did not do as well. He came across as very likable the first time, This time he came across as extremely nervous and defensive. I mean, see how tight his forehead was the whole time. His eyebrows are up. He's like hyper alert. That's a guy with like major adrenaline flowing through his system. He was anticipating unpleasant things. And unfortunately, I think that probably made it worse for him. It made him struggle and resist when he really shouldn't, especially when he ends up ultimately capitulating anyway. It just makes him look more defensive. It makes him look, less likable than he was. Last time he was pretty accommodating. Yeah, maybe you messed up. Thought you had that really clear memory of that puffer jacket. But they were even able to have that conversation about how memory is a funny thing. Like, yep, it was. I mean, he came across as very likable last time. I don't think he came across as likable this time. He looks like he is just unnecessarily defensive. Like, what's at stake in it? If you got it wrong, you got it wrong. It happens. This was years ago. Nobody expects precision. But he's really, really dug into this memory and does not want to acknowledge the extent to which it has evolved. So that, I think, was not an improvement from trial one. Keri, we're going to have to wait and see. So far. Very similar. Her demeanor seems a little bit different also. She seems a little bit more closed off. I don't want to say hostile. The first time she came across, from my perspective, as just sad, somebody who was grieving, somebody who didn't necessarily want to be there, but wasn't like angry about it. This time I'm getting just a little bit more antagonism. That could just be my read. But substance wise, very, very, very similar to what she had to say before. So, my gosh, guys, day one is in the books. Hard to believe. We're already here back. And hearing witnesses. My goodness. Let's go ahead and take a look at some of your questions and comments. I'm just keeping the live stream up to see. I understand there's some reports that they might be coming back to argue the motion. So I'm just keeping it up to see if they come back in session. We still have the fan. Usually, if they're going to stop, they stop showing the fan. So if they come back, we'll just bring it back up. Left, right, center, Michigan. I'm curious if rewatching the Richard Allen interrogations had an effect on your opinion of the case. No, so I didn't sit down and rewatch the interrogations again. I already saw them. I remember them very clearly. I remember how angry I was when I watched these interrogations. I didn't really consider it necessary. What I remember very clearly is, the overwhelming impression of not just me, but other people in the court, many of whom were not believers in Richard Allen's innocence, that he did not sound like a guilty man. That interrogation did not sound like a guilty person.
Please be seated, court is in session.
So we are going to come back late with the open
All right. So we'll have a quick hearing on paper now 682 and 680. First, Commonwealth's motion to enforce compliance with the court's April 16th, 2025 ARCCA discovery order. Mr. Brennan, you said you could be brief on both of these, so I'll hear you.
Your Honor, I'll get right to the point. On the motion for compliance, our position is that the defense did not comply with your order. This is an ongoing issue which relates directly to the credibility of potential ARCCA witnesses. This is information based on the history and representations made in this case that we're entitled to. I did note before these were produced that we have watched video footage from unaired video from the documentary. We clearly knew that there were text messages and correspondence beyond what was represented to the court. It is not a surprise that I did receive these lists of text messages and calls after I made those comments. However, there is no text message content. There is 99 texts to Mr. Wolf, 6 texts to Mr. Lenschler. That does not reconcile with the past positions and representations of the defense to this court and to the Commonwealth. In addition, there are a number of phone calls. And those phone calls, again, I would suggest do not reconcile with the past representations. We have 52 minutes of phone calls on 5 calls with the ARCCA main line, 133 minutes, 20 calls with Dr. Wolf, 57 minutes, 23 calls with Dr. Rentschler. I find it difficult to accept that these are all for scheduling purposes. We also had your honor's order, not just for the communications, which are not a complete or a fair production, but there was a order by the court to provide all correspondence, text messages, emails, not just with Attorney Jackson, but with the entire team, including the defendant, Karen Reed. And we have received nothing.
So
This
when
is
did these
important because
communications happen?
If we look at the first half of ARCCA's potential testimony, which is limited to their prior report, we cannot fairly and effectively cross-examine the witnesses until we have the information we're entitled, and that's why I've also asked and suggested that ARCCA should be ordered and required to provide that evidence as well, so that we can see what is there. It is concerning that there are this many texts, this many phone calls, and the fact that this is totally in contrast to what was represented in the past. So before there's even a thought of ARCCA testifying, I think we're entitled to the full discovery that we asked for, the full discovery that the court has ordered. I don't see anything to do with billing or anything else beyond these text message and phone call logs. I want whatever content is available. I think it's relevant material. It's pursuant to your order, and this is woefully incomplete. Should I dive into the second motion?
Yes.
Take it more quickly. The second motion, part of it is moot in some respects. I won't go through the tortured history of discovery. We've gone through it too many times. We don't have time for it. But inevitably, it is clear that we have played by the rules, met our discovery obligations, and as we stand here now, the defense is proposing new opinions, new testing, and they don't even have the parts of that testing yet. This is 2 weeks into trial after we picked a jury. This is at the time of the opening. It is ambush. It is unfair, and we have no ability at this point to reconcile or deal with new opinions and new information. Importantly,
Well,
the
how do you
defense's
know?
position is they may or may not have a report by May 1st. Our expert will be testifying somewhere at the beginning or middle of May. He is away. He is not available. And so anything we receive at the beginning of May or end of April, we'll have no opportunity to look at, vet, test, reconcile, or even engage in our own testing. This was my concern all the way back in November. I'm not Nostradamus, but this obviously was something that worried me that actually occurred. And so at this point, it would be fundamentally unfair for the defense to get a bet to comply with discovery orders by waiting until February to seek permission with ARCCA. They could have called any expert, asked for any expert they wanted. They didn't. They chose this method, and this is the consequence of it. And at some point, the defense has to bear the burden of their decisions. We will not have the ability to rush through, have Dr. Rentschler come in days before his testimony, try to reconcile, be inadequate. I've had a brief correspondence with him. It's simply impossible. That's why we suggested, although we certainly didn't want to move the trial date, that was the only remedy if the court was going to allow any new opinions, evidence. I say to the court that they should not be allowed to offer absolutely anything new, not only because they missed the discovery deadline. That's technical, but the reality is we're all trial lawyers. We've all tried a lot of cases. It would be a disadvantage, fundamentally unfair, and because of their own choosing. And so anything new, we will not be able to reconcile. We would not be able to proceed with our expert
Only the prosecution
in a
gets to
fair
bring
manner.
new stuff.
Thank you.
Okay. Mr. Alessi, is this you? I'm going to ask you to be as brief as you can be, please.
Your Honor, I understand your request to be as brief as possible, but this is the first opportunity the defense has had to respond to almost every allegation that's been made. We haven't had an opportunity, so I certainly respect the court and what the court's request is, but it is going to take a bit of time to put facts out. And I want to separate two categories that the Commonwealth has conflated. The Commonwealth has conflated the issue of what text messages exist, which text messages don't exist, what's been turned over pursuant to orders, and I would like that to be clear to the court factually, because the Commonwealth has misstated just now 3 times the facts.
So I asked this morning, there were 100 or so texts referenced in the exhibit, whatever was presented by you folks. I asked if Mr. Jackson, if he provided them, because my order was clear they were to be provided, and he said no. And I asked you at Sidebar whether they were deleted, and you said yes, in due course. I have no idea what that means, Mr. Alessi. Why don't you explain that?
Well, thank you for the opportunity to explain it. Here's what it means. Like anybody's phone, those text messages are 2 years old. They don't exist.
So can you also tell me, aren't the ABA guidelines the council is supposed to keep everything in a case for 5 or 7 years?
I do not believe that is the ABA rule with regard to experts. I'm unaware of that.
In regard to your client, and this was in regard to your client's case, right?
I'm sorry, Your Honor, I didn't hear you.
Records kept regard to your client's case, which these are experts that were, I mean, there's 100 text messages
this is not good.
leading up to trial, when I was told that by you that there was a pause email, and then all of a sudden out of the blue a bill appeared in July. This shows that's not true, Mr. Alessi.
Your Honor, that was a different question that Your Honor asked me back then. That was about emails. That was not about text messages.
Have emails been provided?
Yes, Your Honor.
Okay.
All emails have been provided. And that is why we are in compliance with all orders. And I will say also with regard to text messages, we have provided, pursuant to every order, every single text message that exists. Mr. Brennan just said, I believe there has to be more there. There's not more there, and I don't believe there can be an order of preclusion based upon the speculation of opposing counsel that there must be more. We affirmatively created a document, Your Honor, to be more transparent than the records, where we summarize all of the communications. Yes, we don't have the text of the text messages, but we were completely forthright and set forth every text that was made. Plus, we turned over from Ms. Little, the only other person on the defense team who communicated with ARCCA, we turned over her texts and the text of her text messages. There is nothing else in existence to provide. And importantly, the defense was under no order to preserve the text of text messages. And we have never received, as part of discovery in this case from the Commonwealth, any communications between the Commonwealth and its several experts. That has not been what has occurred in this case. But of course, once Your Honor on Friday issued that order to provide everything, we provided everything we can that we had. The bottom line is, Your Honor, we've turned over absolutely everything we have. And in addition to that, we created a document so that it would be easier. We're the one who showed all of these text messages from Mr. Jackson historically. We created that document. There's no basis for a discovery violation. There's no basis for an order violation. We are in full compliance. So that's the prong one, Your Honor. Prong one is what Mr. Brennan has alleged is incorrect, because we turned over, and we did it recently and consistently. We've turned over all emails and Ms. Little's text we provided. There are no text messages in 2024, and there's no order that required those to be preserved, and there is no discovery violation, because we can't be in violation of not turning over something that doesn't exist.
All right, go to the second.
Thank you, Your Honor.
Motion.
The second part of the motion, Your Honor, is the most maddening for the defense. And this is the timeline that I can go through very, very quickly. And essentially, what the Commonwealth just argued is we will be so prejudiced that if we get the work that ARCCA is underway, working on, that we will be prejudiced because we won't have enough time to address it. Your Honor, the facts show that the timeline for this has been caused by the Commonwealth, not the defense. And I can do it quickly. July 2024, the first trial concludes. November 2024, 4 months later, the Commonwealth decides to retain Aperture. Their decision to wait 4 months to retain an expert, we're the defense. We defend what the Commonwealth alleges. January 30th, 2025, 2 months after that, and 6 months after the first trial, we get an Aperture letter report that's barely discernible about what they've done. It's a 1 page and 1/4 of conclusions and opinions in outline form. Next, January 31, 2025, we get the initial Aperture 140 slide presentation. January 31st, February 5th, we get the case file. In February 19th, we finally get the raw images from Aperture in the scans. That's the first time we get raw images and scans. You can't have an expert work on anything until you even get those raw images in scans. We move and we have a hearing on March 20, 2025 to preclude Dr. Welcher because the slides are so incoherent and the report is so insubstantial. We can't tell what it is their theory is. So then on March 24th, and at that hearing, the Commonwealth agrees to redact and revise that. So we're already into March 20th. The Commonwealth agrees to redact and revise. Your Honor put the defense on a short leash. We accepted it. And by March 24, we received the PowerPoint that was of the Aperture that was supposed to have two things happen. It was supposed to be redacted, and there were certain things that were supposed to be changed. What did we get on March 24th? It wasn't redacted, and there were 3 substantive changes to it. The Commonwealth has said twice, including today, there were no substantive changes. There's 3 of them, and to the extent Your Honor wants to hear, I can detail exactly what those changes were.
So why don't you highlight them very quickly, because I
will, Your Honor. I can do it quickly. Thank you for the opportunity. First one, slide 36, they changed the image of 34 Fairview. No small change. 102, they changed the conclusion regarding the time that the taillight was broken. No small change. 123, they changed the image of 34 Fairview. No small change. So we ended up getting those changes, and I want to be clear on the date. That's March 24th. We have a hearing on March 25th. We agreed to provide our response to these revised Aperture documents. Here is the key data point. On March 26th, the defense engages ARCCA. Just 2 days after we get the revised PowerPoint with 3 substantive changes. And then we started to respond and provide more information. On March 27th, we responded to the Commonwealth's revised PowerPoint and the Welch report. And then the last 2 items, we renewed our request to preclude Dr. Welcher on Dalbert Lanigan grounds. April 1st, and this is another key date, the court decision allowed Dr. Welcher to testify, but also allowed the defense to re-raise objections at trial when Dr. Welcher testified. What does that timeline show? That timeline shows that the Commonwealth took 6 months from the last trial, 6 months, and the defense took merely 2 days after they got the final report of Aperture to retain ARCCA. Last point I want to make, Your Honor, is the argument of the Commonwealth that we strategically waited to retain ARCCA. Nothing could be further from the truth. As the court knows, and has been the case with this unorthodox situation, ARCCA was retained by the U.S. government. They worked pursuant to the U.S. government, and we had to get the permission of the U.S. government to retain ARCCA. We moved expeditiously to do that. We got the permission from the government, and as soon as we got the permission from the government, and as soon as we got the final version of Aperture documents, including scans, we put ARCCA on it. It has only been since March 24th, not even a month, have we had finally the information from Aperture, which is still inadequate. Our experts still say, with regard to what Aperture did, in some instances, they can't even figure it out because the information is so inadequate. Nonetheless, because of all the considerations we're aware of, we had ARCCA proceed forthwith with post haste. And they are working post haste. But, Your Honor, we are the defense. That's where I started. We had to understand as best we could what Aperture did. In conclusion, 2 points. No violation whatsoever on text messages, emails, court orders. All complete, robust compliance. And with regard to the allegation that there was something said, that there's some surprise that there were so many text messages, on June 10th, 2024, and I've got the transcript on an, albeit on an electronic device, right in front of me, I just got to get the passcode. Mr. Jackson read a text message right live that he had with ARCCA. He read it, and here's what it said. The court, okay, Mr. Lally, so her issue is that she is available this week, but not next week, so I really need to get her in on Friday. Mr. Jackson.
Hold on. The court reporter can't hear you. She asked you to stop.
Oh, I'm sorry. My apologies. Am I going too fast?
Yes.
Thank you. All righty.
Now he's too fast.
Go ahead.
Thank you. My apologies. So, Mr. Lally, so her issue is that she is available this week, but not next week, so I really need to get her in on Friday. Mr. Jackson, Dr. Wolf just texted me and said, I presumed you were in court. Give me a call when you're available. The court reporter, I'm getting an interference. Mr. Jackson, I'm so sorry. The court reporter, that's okay. We have been completely transparent that there were text messages as opposed to emails. Text messages about scheduling, about other administrative matters. Mr. Brennan is completely free on cross-examination of ARCCA to address every one of his speculations, every one of his suspicions, every one of the ghosts that have been created on this topic. He can address them. If he thinks that we're wrong, we're misstating, he's got the opportunity to speak to ARCCA and ask those questions. Your Honor, it is improvident to, based upon speculation, preclude the defense from putting in a defense.
I'm not making a conclusion today regarding precluding the defense.
Okay, all right. What's
so,
next?
So I need you to wrap it up because there's something I want to say.
Certainly, Your Honor. I'm going to wrap it up in 10 seconds. There are no violations of any discovery order, no violations of this court's order. And with regard to the retaining of ARCCA, because we're the defense, we acted expeditiously in response to the information we're getting. And this can be tested with ARCCA, the statement I'm going to make. To this date, ARCCA still has trouble understanding what it is that Aperture did and didn't do, which was the reason for my Dalbert Lanigan motion, but we proceeded nonetheless. Happy to entertain responses to any questions.
All right. No, thank you. All right. So as you all know, I previously wanted you to have a seat, Mr. Alessi.
Thank you, Your Honor.
He was fired up.
I previously found and believe Mr. Alessi, when he was talking about the rules of professional conduct, did say, I agree, a violation of Rule 14, but not regarding the rules of conduct. At a prior hearing, I found a violation of the defense's reciprocal discovery obligations. It was clear to me, and I found that it was deliberate. This appears to me, contrary to what you've argued, Mr. Alessi, that this is another violation of my order and of the reciprocal discovery violations. We need to figure all of this out before you're allowed to call these witnesses. So I'm going to have a voir dire hearing this Friday. I know we planned on having you. I need the ARCCA witnesses here Friday morning.
So maybe they'll need to
need a
text
voir
with them
dire
a
if
few
you intend
times.
to call them, a voir dire on all of this. And I will be sending an order for production of records. I just need to amend it for ARCCA to bring all these items with them. So Friday will be for ARCCA for a voir dire hearing in the morning. So we'll see you tomorrow for trial, Friday morning for this.
May I inquire briefly for scheduling purposes?
Yes.
In light of the hearing on Friday, will it still be half a day, or are we expected to call witnesses on Friday?
No, it will be, if we could do, Mr. Alessi, how long do you think this voir dire might take?
Is it his voir dire now?
I don't have an answer for you, Your Honor, right now, because I got to talk through ARCCA and I've got to understand what they have and what they don't have. So I think it can take some time.
All right. So no witnesses for Friday, and I think we'll give the jury the day.
And will it be a full day on Thursday?
Yes.
Thank you very much.
Yes. All right. So we'll see you then. I will issue an order hopefully before the close of business today. Jimmy, can you stay and get this out today?
Sure.
Okay. All right. Thank you.
Okay, so we're going to have a voir dire of ARCCA. They've been building up to that for, I don't know, quite a while now. Oh, Mr. Alessi was hot. He was hot, wasn't he? He was not pleased at all. So these various phone calls, 99 text messages to Wolf. It does seem like a lot. Does it seem like a lot? It seems like a lot, but remember how many times they had to go back and forth? They had to have the whole voir dire the first time. Like, yeah, I would expect there's going to be coordination about that. Where are you going to be? When do you need to be there? Where are you going to stay? Do we need to set it up? You going to set it up? We'll I would kind of expect stuff like that to be in there. Clearly, Dr. Wolf was the lead, and much less to Mr. Rentschler. I got 52 minutes on 5 calls. My notes are all messed up. I didn't catch all that, but I don't know. Multiple phone calls of 10 to 20 minutes. Ask him about it. That's what the voir dire is going to be, I guess. That's what the voir dire is going to be. Like, I don't know how you disclose a phone call anyway. It's not a discovery issue. I don't know how you would disclose that. You just, I don't know, acknowledge it happened. So I can't really tell at this point what the problem is, or if there is one. She's like, well, it seems to me to be a discovery violation. Well, you need to lay that out. If you're going to actually find a discovery violation, you really need to identify what the obligation was and in what way they failed to comply with it. She's saying something about the ABA standards require retaining text messages for 5 to 7 years. I don't know anything about that. I don't know that ABA standards are followed in Massachusetts. Like, is that a binding thing? We got all kinds of different retention guidelines in Washington. It depends. And they're all guidelines too, by the way. These are not hard and fast rules. They're just recommendations. because a client file is the client's property. And so you kind of safeguard it. If they bring you documents or they bring you evidence or things like that, that is the client's property. So you keep it while the case is underway, but you may have an obligation to return it. So that comes up a lot in the context of a criminal case, because what happens, somebody gets convicted and they're looking into post-conviction. They want that file. They want that file so they can see, what did my trial attorney have? What did they do? What did they look at? What did they investigate? Did they fail to follow up on certain leads? So that's the client's property. You have at least a theoretical obligation to retain it for them, but for how long? There's no law. There's no law. So I have had cases. In fact, I had a case about a guy trying to get his client file. This is like, I could go down a bit of a sideline with this, because I am sort of proud to say I made law in the state of Washington on a defendant's right to claim their attorney's file. The attorney has to turn it over. State versus Padgett. It's published a few years back. That was my decision. It was a great job that the pro se defendant had made setting it up. So I was in a very good position, but basically announced a new rule in Washington with respect to the return of a client file. But it doesn't say how long they have to hold it on to, because there's no law about that anywhere. There's just a lot of law that says, here's how the discovery is supposed to be handled. And here's what the general obligations of the attorney are with respect to safeguarding client property. So I had a case under this rule where the client finishes his trial, and according to the explanation from the defense attorney, it's like within weeks he's gotten rid of his file. He's disposed of it. Who knows what he's done. And not a problem. Not a problem in the eyes of the court, because there's no obligation to keep any of that stuff for any specific length of time. If it's not specifically the client's property, like something the client brought to you and gave to you, and you have a duty to safeguard that so that you can return it to them. If it's just something you got through the course of your investigation, your police reports, your notes of your phone calls, all that type of thing, you don't have to keep that for any length of time. So I don't know where she's getting this 5 to 7 years, ABA guidelines, is not about experts. This is out of the blue to me, because I don't imagine there's law on it. I really don't. I would be shocked if there's a legal duty to retain this stuff for 5 to 7 years. I'd be shocked. How much of a storage facility that would make every public defender office? They handle hundreds of cases a year, and they have to keep, you're telling me they're going to have to keep all their text messages for 5 to 7 years? It ain't going to happen. That is not going to happen. It doesn't happen anywhere. That is not the standard in Massachusetts. I refuse to believe that. But that's the only thing that she is handed out as being something of a standard that's violated, that constitutes a discovery violation, an ABA guideline, unspecified. Like, she didn't give us a number or anything. I don't know which one. I guess I'm going to have to research after we get done with the stream and see if I can figure out what on earth is she talking about. And is that law in Massachusetts? If that's not law in Massachusetts, then it's not an obligation, and not following it would not be a violation. So, but she is very eager to find a violation here on the ARCCA stuff, isn't she? All she says, I previously found there's a violation of the reciprocal discovery rules, and this appears to be another one. That's all she said. Don't know why. Don't know what obligation is violated. Don't know how they failed to violate it. Only thing that's come up is the failure to retain these documents, these text messages, which, as far as I can tell, I don't see that they have a legal obligation to retain them. So see if that gets fleshed out more. I don't know. Friday voir dire. That's going to be exciting. We always do love seeing us some crash daddies, don't we? And that's going to give us our preview into, so what have you been doing since the first trial? Oh, I can't wait to catch up. I can't wait to catch up with Doctors Wolf and Richler. I can't wait to hear exactly what are the problems with this this accident reconstruction firm that the Commonwealth has hired. In what ways can you spell out exactly how it doesn't make any sense, how it's incomprehensible, unclear what they did? I'm very much looking forward to the details about that. So no ruling on that so far, and probably won't get one, I don't know, before Friday. She's going to sign an order for production, so don't know, of course, what's in it, but I imagine it's much of the same stuff. This is what Hank was asking for last time. Order ARCCA to produce all of the text messages, all of the emails, all of the communications, etc. So that's probably what it is. If they have them, I guess they'll turn them over, and then we'll see if there's an issue. Then we'll see if this has all been a big fishing expedition on the part of Mr. Brennan, or if his suspicion was founded and there's something in there that goes to conversations that implicate ARCCA's independence and objectivity. We'll see. We'll see. So with that, guys, let's get back to your comments and questions. We got quite a few to work through here, so it might take us a minute. Brooke E., what are some things you're expecting to happen this trial that maybe didn't happen in the last trial? Well, I'm a little bit let down, honestly, by the cross-examination of Mr. Nuttall, because the very first thing that I was hoping for and that I was expecting for this time around was going to be a tighter cross, more targeted. You don't need to go in and soften everybody up and work everybody over on everything they got wrong. You need to focus on the points that matter. That's how the jury knows what to pay attention to. They have a very limited attention span. It's a long day. They're there. It's going to get boring no matter what your best efforts are to try to keep their attention. So I was really hoping that there would be less of this kind of working around establishing a point that may or may not be that significant. Okay. A lot of time spent on his memory is not great. And his recounting has been flexible. You can establish that very clearly and very simply with the right questions. You just go ahead and lay out what you're trying to establish. Do you agree that your statement has changed over time? No, you don't agree with that. So do you agree that on, this date you made this statement? No, you don't agree with that. Would reviewing the report refresh your recollection? No, you don't remember? Well, do you deny making it? Oh, that's that Alex Spiro trick. Okay, we got to come back to that. I'm going to run very far afield of the question here in this super chat, but the whole issue, and the reason why I'm like trying not to jump out of my chair and scream at the camera, this is a technique issue. This has to do with the difference between impeaching somebody with a prior inconsistent statement and refreshing their recollection when they don't remember. You have to be, as a trial attorney, like critically attuned to the answer, the very specific answer you're getting from a witness when you're asking them about a prior statement. Because if they just say, I don't know, that is not sufficient for you to be able to introduce that statement to impeach them, to be able to actually like read it out and present it to the jury of what it was. They have to deny making it. So this is the foundation that you have to lay for impeachment. They have to be presented with it. They have to have an opportunity to explain it, deny it, whatever, adopt it. Maybe they do remember now, before you can bring in the inconsistent statement that they made at a different time. So if they just don't remember, you haven't laid that foundation that it's inconsistent. You haven't laid that foundation that they deny making it. So you have to have them on record. Do you not remember or do you deny? And that's where when we were watching the Alec Baldwin trial, and Alex Spiro, he's got that down. He has got that so down, and it was so effective. And I loved it because it's very simple and it's exactly what you need. He would ask the witness, did you tell the grand jury on X date that, she said he's dead? And he would say, I don't remember. And Spiro would ask, do you deny it? He would just skip over this whole, let's go through the refreshing and let's just get straight to, do you deny it? Because all I really care about is, am I going to impeach you or not? If I don't need to impeach you, it's because you're saying, yeah, it's possible I said it. And that's good enough. That's good enough. If it's possible that I said this other thing, that makes my point. That's fine. But if I deny it, you deny it. Then you get to impeach them with a prior inconsistent statement. So that's just like one example of something, I saw in another trial. It's so extremely effective the way that he does it. It's clean, it's tight. It keeps you fixed on the point that you need to be making and not running around in circles about, well, do you remember this? Well, your memory isn't very good, is it? That just gets a little bit, for me, it gets off topic. We already know you're antagonistic to this witness. This witness is the Commonwealth's witness. Of course, you don't agree with what he has to say. Of course, you think his memory is bad. It's not helping the jury. We need facts. We need facts. So that's the best answer I can give you to this question. I was really hoping, we would see a little bit of a different approach on cross-examination, that we would see it tighter, because they figured out during the first trial how to be evasive, how to run circles around this defense team, given how this team is kind of accustomed to operating it. We saw, he just kind of just pulled what Jen McCabe did on Alan Jackson the first time. Just slippery got away, and it took Judge Cannoni, it took Judge Bev to nail him down. Do you deny it? To just ask the question directly. Are you denying it? The foundational question that we need to be able to impeach him. Mr. Jackson didn't get there. It was very frustrating. So I was kind of expecting that to happen, but it hasn't. Otherwise, I'm generally expecting, more, problematic technical evidence for the Commonwealth. I'm expecting a little bit more trying to make the square peg fit the round hole when it comes to the data, the forensic stuff. So we'll see how that holds up. I see my banner is still up. I can go ahead and get rid of that. Ms. Jake, good morning. LFG indeed. It is time. And hard to believe we're already back, but here we are. Idiot Wind, thank you so much for your tireless work, and also for the drops of sunshine you sprinkle with Chilean poets and soup, bonsai, great art and humor and insight. Somehow we often talk about things that are deeply upsetting, but calm my little fish heart. Well, thank you so much for that comment. That's a wonderful comment. I've said many times, criminal cases can be very dark, and at the end of the day, this is about a tragedy. And when you're in criminal defense, you can really just get buried by the tragedy that you have to encounter. Every crime, even little petty things, they are significant to the person that suffered them. A small. Somebody broke into my car and took my subwoofer. It's a small tragedy. It's not the end of the world, but to that person, that was traumatic. They came out of their car and they realized, came out of their house and they saw their car and they realized somebody had got in, and they realized that their stuff was gone, and they really liked it, and they're going to have to replace it, and they feel violated because their space has been invaded. It's a small thing, but that's what you bathe in the world of criminal defense. And so I learned a long, long time ago, you really do. You have to look for the bright spots where you can find them. You have to try to keep your good humor when you're dealing with cases like this, or it'll just overwhelm you. You can let the darkness overwhelm you. And this is something that, ironically, defense lawyers and police officers, we have so much in common when it comes to Black humor. We have a lot a lot in common, because we both see, some of the darker sides of humanity, and you have to figure out ways to cope with that. Humor is a very healthy way to cope. So happy to share that with you where I can. I don't know that I have a massive amount of like insight or anything like that. I did, speaking of the Chilean poets, I have my canto general, which I can't say very well yet because I'm not very good at the Spanish R's, but very slowly starting to look at some of this. I haven't read any of the actual poems yet. I've gone through and started to work through the prologo. But once I get to the actual poems, I'm expecting some of that to be a lot of fun. Canto General. It's a series of poems by Pablo Neruda that's essentially telling the history of South America from the perspective of the indigenous people, is basically how I understand it. So anyway, if there's any good stuff in that, I'll share that with you as I go forward. So I am continuing to work on my Spanish. I got a couple more tenses now. I'm working on that, working on the past tenses, and yeah. So thank you for that comment. 3.5 Houston. Andrea, most brilliant Karen Reed case lawyer, not representing Karen Reed. Well, thank you for that. I'm not sure about that. There's a lot of excellent lawyers covering this case. There's a lot of excellent lawyers on her team, obviously. A lot of people with really good insights here. I have my perspective. I did trial work. I did it for the defense. So I definitely see things from that perspective. But there's going to be other people that have perfectly good insights too. So I don't want to take too much credit or anything like that. In fact, I actually want to give a shout out very specifically to Emily D. Baker. I often get a lot of really good insight from Emily D. Baker, because she just has the ability to put things into words that often like I think, but I don't necessarily articulate. And there's been a clip going around from when she was watching, Hank's last argument about the ARCCA witnesses and how this is so completely unfair and we're going to have to adjust. We'll have our whole strategy set. And if they're allowed to mention this in opening, and then we have to shift. And her point was, if your case depends on what the defense's expert says, you have a big problem already. You already have a big problem. If your case is that reactive to what the defense is doing, your case should be able to rest on its own merit. You should be able to point to the same facts and reach the same conclusions, regardless of what the defense does. So if that destroys your case, you've already got a big problem. It was such a good point and such a good way of putting it. And just another one of the excellent lawyers out there that I really appreciate. That Southern blonde lawyer. I've missed the AB crew back at a firm doing crypto. Oh, I don't envy you, but means I can't be in on most days. We'll be on replay for trial. I know AB, Jeff, and this awesome crew will keep it real. Well, we will miss you during the lives. I don't envy you with the firm work. I never did like the big firm practice. Closest I came was when I was in the public defender office, the county office over there in Yakima County. Rest of my career, I was my own boss, and boy, was that a nice way to live. Now, granted, it doesn't mean you get any less busy. Okay, you're never really more busy than when you work for yourself. But that whole pace of the law firm, I had so many friends that went in that direction, and saw a lot of people got sucked pretty dry from that. So anyway, I hope you are well. I hope that your time is not weighing on you. I hope that you're finding the work that you do valuable, and that you catch up with us on the replay crew. We will look forward to that for sure. Michelle Johans 1. Is not some of this attorney work product? Yeah, talking about the ARCCA communications, that was kind of my first instinct. I would expect a lot of this, if it is post ARCCA being retained by the defense, yeah, it's work product. This is you communicating with your expert what your thoughts and theories are about the case, and exploring their ability to provide testimony on that. So that is pretty typically going to fall within privileged attorney-client work product. those communications. Now stuff before ARCCA was retained is not going to be privileged. So I think that was really the big question here. And it's still a little bit out there. It's still kind of a question. When did ARCCA become the defense witness for purposes of work product and this type of disclosure? When they were retained in March, back when they were subpoenaed to testify for the defense? I'm not sure about that. I think there could be potentially an argument made either way. But I think treating it conservatively, you'd say privilege doesn't attach until they were formally retained by the defense back in March. So anything before that, you wouldn't have a claim of work product, because your whole argument is they weren't your witness. They were independent. Both parties had the opportunity to hire them. Both parties had the opportunity to outreach with them, to bring them in to testify. The defense happened to be the one that chose to do it. So before that, probably not work product, but anything after ARCCA was retained, yeah, I would expecting them to be saying absolutely not. You're not getting those communications. Those are privileged. Beagle Mom, anti-Karens in the courthouse are acting like children. Sit down, crisscross, and be good. I haven't seen any of the news coming out of the courthouse yet. I'm gonna have to check it out once I get offline. But I'm sure that there are live reports and stories about what's going on. Curious to hear how this buffer zone has panned out for day one. Yeah, there's going to be a lot of reporting on it. So if there's something specific that happened, I'm sure it will come across my radar. Nikki, a streamer, here we go. A streamer from out of town was just arrested on stream. One trooper was explaining to him the buffer zone and nicely telling him where to go, and another cop came and tackled and arrested him. Well, that will make for some good TV, won't it? That's going to be quite a video clip. That's going to be quite a video clip. I'm sure that's probably already floating around too. Oh man, apparently trying to do journalism in the town of Canton or Dedham, I forget where they are right now. Probably should remember that. I think they're in Canton. Trying to do journalism is not going to be good for your health. Seems like maybe that's the point. If you can't even go and ask questions. This was the problem with this buffer zone order from the outset, is how are people going to have notice of it? Are you expecting anybody who shows up within 200 yards of the courthouse or 300 yards of the courthouse, whatever it got extended to? Are you expecting them to have followed all of the pretrial hearings, read the pleadings and orders? How could you possibly do that? You can't do that. There's going to be random people that are walking through this area that have no interest in this trial at all. They have no idea it's going on, and they just happen to be in the area. So if people can't even ask questions about where am I supposed to be, kind of looks like they're trying to make journalism not very healthy in the state of Massachusetts. LTL Media, KISS, keep it simple, stupid. Defense needs to pound home reasonable doubt to this jury. Yes, and that was one of the things that they did very, very well during the opening statement this time. I thought they did a much better job this time of harping on that standard and what a stringent standard is, and identifying specifically, here's how you're going to find it. John, there was no collision. They're not going to be able to prove that. That's reasonable doubt. Michael Proctor is the one that's running this investigation, and he's a mess. That's reasonable doubt. I thought they did an excellent job with it this time around. Melanie Parker, John O'Keefe was killed inside the house at 34 Fairview. I don't know how... this new technical stuff, this temperature evidence in particular is supposed to help the Commonwealth's case. To me, that does not seem to help the case that he's been outside in the cold since the time that he was hit by the car. I just don't know how they're supposed to reconcile all this together. 12:45, right, is when Jen McCabe sent that final text, and that's how they came up with their timeline originally. Because she said, I sent that text. I was looking outside the window and I saw the car pull away. That was her original statement that she made. And then it changed, it changed over time because of that connection to the Wi-Fi. Karen's phone connects to the Wi-Fi at John's house at 12:36 in the morning. So she was not still outside Fairview 9 minutes later at 12:45. So they had to shift all that. But I didn't hear a real coherent timeline from the Commonwealth about these details. I heard little bits and pieces. He insists, okay, here's something that Hank insists. They arrived at 34 Fairview at 12:34:33. Is that from Waze? Because if that's from Waze, we already know the Waze clock is off. We already know it was wrong. We learned that from the last trial. But if they arrived there at 12:34:33, then why is the very next thing he said, Jen is texting to John at 12:27. She's texting park behind me at 12:29. She's asking, are you coming in? John's health data doesn't move until 12:31:56. You just said they weren't even there until 12:34. So this is not a coherent timeline. I don't know how all this is going to get tied together. But then we get this battery temperature stuff. From 77 degrees at 12:37, which sounds like, that's probably the temperature of a hot car, car that you're in with the heater running, the defrosters running. It gets very, very warm in there. I don't like driving in winter because it gets so hot. I can crack the window. From 77 degrees down to 50 at 1:14. But it has that pause. 77 to 72 over a 5-minute period, and then this rapid drop to 61 degrees, and then a rapid drop, after that. Does that sound like somebody that's been lying out on this out on the lawn in the cold the entire time? It really doesn't to me. So I think they are maybe going to have a problem with keeping John out of the house. I think the data is not going to help them there. Duncan, Idaho. I feel bad for Chloe. She probably just thought she was protecting her pack from the stranger they were all beating on, and she lost her home for it. I mean, Chloe's just a dog. The dog is just doing what a dog knows. And what a dog knows is, part instinct and part a product of what the dog has been taught. So, I'm rarely, if ever, going to blame the dog for pretty much anything. It's, you could blame the dog for being a dog. I would sometimes get mad at my dogs. The boys especially were so bad. They just don't pay attention very well. They get in their nose, and then they just like they turn their brains off. They're done. Like they're in their nose. It's a dog thing. I can't make them not nosy dogs. That's how they're programmed with their biology. The girl is a little bit better at paying attention, snapping out of it. It's really, really been interesting to see the difference between the girl dogs and the boy dogs. But, what would be the point of blaming the dog for being nosy? It's made to be nosy. Like there's no getting around that. But I can blame the dog for being poorly trained. I can definitely blame the dog for being poorly trained, but that's not the dog's fault. That's my fault. That's my fault. I'm the one that needs to train the dog. And if I can't train the dog, I need to control the dog. If the dog can't be relied on to do what I need the dog to do, then the dog needs to be under my control so that I can make sure the dog is doing what the dog needs to do. And that's the responsibility of a dog owner. So if your dog is aggressive, if your dog has a problem with biting people, some of that is the dog's fault. The dog has aggression. But some of that is the fault of the people who either trained the dog to act on it, to act in an aggressive way towards humans, or simply didn't correct it, gave the dog the freedom for this type of incident to happen. You have an aggressive dog that you know is not good around strangers, then when strangers are around, what do? You restrain the dog. Put a leash on the dog. Put the dog in a room. You don't give the dog the opportunity to do the bad thing. So, yeah, I definitely feel some sympathy for Chloe on this, because even though, it might be easy to look at like, oh, it's just a mean dog, just a mean, vicious dog, who cares about that dog? The dog didn't ask to be like that. It's people who make the dogs the way that they are in terms of how they express their dog instincts. Desert Quill, on the day of Karen Reed's arrest, Colin's mom offered Proctor a gift to express her attitude. Indeed, she did. Why bother? She knew her son was involved and Michael Proctor protected him. Out of it all, this proved the cover-up for me. Yeah, that was a particularly incriminating one, wasn't it? The message from Julie McCabe about giving him a gift, and that was text messages, if I remember right, between Courtney and Michael Proctor, between the sister who's very close friends with Julie McCabe. Julie babysits her children and so forth. I called her McCabe, but she's Julie Albert. Text message between Courtney Proctor and Michael Proctor that Julie wants to give you a gift, and he says, give it to my wife instead. Give it to Elizabeth instead. Don't give it to him. Give it to Elizabeth. Oh, that makes it better. That makes it better. That's not a benefit to you at all. If it's just given to your wife, I mean, yikes. So yeah, that was a little bit compelling, wasn't it? Why would you be in a position of wanting to thank the police with a gift over making this arrest? I don't know. Oh, I suppose it's possible that there are, perfectly innocuous explanations for it, but that certainly isn't what jumps first to mind, is it? Sarah Boone's left kidney did a Cecil. Ideal iPhone battery temp is 62 to 72 degrees. Interesting. Yeah, I mean, it makes sense. That's probably average, certainly room temp, 70 degrees, decent temperature outside when you're going to be outside. If you're going to be outside with your phone and it's cold, you're probably going to have it in your pocket. You're not going to be like walking around with it in your bare hand. But I can definitely attest to the fact that, yes, phone batteries do very bad in the cold, because when you camp, in the cold with your phone, you can lose your battery very, very quickly. And so there's actually like a whole technique, where you stick it, in which pocket in your sleeping bag, like while you're sleeping. If you want to try to preserve the battery, try to keep as much body heat on it as you can. You keep it very close to your core. So stick it in your jacket pocket, if you have one, and then have that inside your sleeping bag. That'll help your phone battery last on the camping trip. Mimi Lovegood Law, can you please explain what happened about ARCCA this morning? I thought she ruled they could testify, and now no. Am I not understanding? These conflicting rulings are driving me nuts. Thank you. Well, hopefully this is not too late for you, Mimi. I love good law. But the reason why it's confusing is because she doesn't rule on stuff. She just has these hearings and then leaves things hanging out there and doesn't do anything with it. So walking in this morning, all we had was the previous ruling on the Commonwealth's motion to exclude ARCCA for discovery violations way back when, a month or so ago, when she said, I'm not going to exclude them. That's where we left it off. But then Brennan kept hammering on this drum. He keeps bringing new motions. They've argued new motions, and she hasn't ruled on them. First, it was we were going to have a voir dire. Then it was not going to have a voir dire. Then the defense is going to be ordered to turn this stuff over. It's just been kind of a moving target the entire time. So that's why it's confusing. As far as I can tell, what happened this morning is she maintained you don't get to mention ARCCA in opening until we get this sorted out. And probably something along the lines of, Mr. Alessi comes up to try to make the case that he just made at the close of court here, that we haven't done anything wrong. There's no violation. There's no basis to exclude them or to not let us mention them. And she's like, we don't have time for this. We'll deal with it later. Kick the can down the road is a very common theme with these issues. We'll kick the can down the road, but in the meantime, just don't mention them in opening. So they didn't get to mention them in opening. That's my guess about what happened with ARCCA this morning. No final ruling on do they get to testify? What do they get to testify about? Exactly, how does this work? Don't know. We're still waiting. Horse welfare, hit the like button. Thank you for covering the trial. Well, thank you for that. Appreciate you being here with us. Patrick McKernan, Ryan Nagel, and Heather Maxson independently stated they saw Karen Read waiting alone outside. Yeah, they did. They saw the woman sitting in the driver's seat with the interior light on, with her hands on the steering wheel at the 10 and 2 position, looking straight ahead, and there was nobody else in the car. That's what they saw when they were there. That's what they saw. So where was John? When did John get out of the car? I don't know. But he wasn't in the car and Karen was still sitting there. So that at least is consistent with the defense's version. She sat there and waited. And he didn't come back out. Yeah, that would piss me off. That would probably piss me off. Problem for the Commonwealth, that testimony. Dennis Kilborn with the super chat. Thank you so much for that, Dennis. Appreciate it. Steve F. Fluffer Nuttall. You just wanted me to say that, didn't you? Fluffer Nuttall. That's funny. Have I told you the story about how Jeff started baking? Jeff, I think I probably have. He got into it because he really wanted the perfect fluffernutter. And you can't get good fluff over here on the West Coast. Fluff is not a West Coast thing. So he had to make his own fluff, and which is, really from the baking standpoint, the kitchen standpoint, that's going, that's like skipping the beginner and the intermediate levels and going straight to advanced. I would not even try to make fluff. Like it's complicated. You got to have all these things the right temperature and do it the right way, whisk things the right way, have them the right viscosity. Like it's very technical. So Fluffer Nuttall. Allie B from Tennessee. Random question. Was the original plan for John to just run in for a minute? What would have happened if Karen went in with him? Would have messed up their little plan, right? Free Karen. This is such a good question. And I mean, I would love to know. I've thought through so many different scenarios in my mind. Like how did this work? Did they separate him, or like would the plan have been to kind of separate him right off the bat, get him down in the basement, get Karen over here with the girls, keep Karen drinking, and I mean, I'm of the opinion that whatever happened to John was not intentional. I don't think anybody intended for him to die. I don't think there, in that sense, I don't think there was a murder here, except to the extent that if John was not already dead when they dumped him out on the front lawn, that might count. That might count. Allegedly, of course. But as far as like him sustaining the skull injury, I don't think anybody was thinking we're going to kill John by whacking him in the head. I think it was just things got out of control. Don't know exactly how, don't know where the dog fits in, don't know where all the players fit in, don't know who was the initiator. There's a million theories that we can come up with about that. And so I mean, the question is, what was the plan? I mean, was there a plan? Was there even a plan, or was this just drunk people who are, in their feelings and wanting to fight? Guys getting drunk and wanting to fight. I don't know. I don't know if they were thinking ahead to this at all, or if they would have just dealt with whatever happened. You know, I don't know if Karen would have gone in. If Karen would have gone in, maybe they would have just separated her out. Maybe they never would have had this altercation in the first place. Maybe the altercation was triggered by John leaving her out there in the car. Maybe if Higgins is all up in his feelings for Karen, he's like, well, that's really disrespectful of you. And that's what set it off. You know, I don't know. I don't know. $1 million question for sure. But unless somebody in the house decides to say what went on with John in the house, I just don't think we're ever going to know that. Nola CPA. Hi, Andrea. Do you plan on attending any of the trial? I will be there mid-May. That is awesome. I will look forward to your reports. I am not planning to go to this one. It's a little bit more of, a circus kind of environment than I feel like it would be beneficial for me to add to. I haven't gone and gotten press credentials or anything like that. There's no guaranteed seating in the courthouse. I don't really have any particular desire to be out there in the buffer zone, So no, I'm not planning on it. I'm going to go ahead and stream it from the comfort of my home with my, my hobbies and my places, my things that make me happy. Be able to go out and walk my dogs at the end of the stream. Things like that. But I will definitely look forward to hearing from you because, maybe there is a reason why I should go. There's a whole scene that's going on there, no question about it. I'm just not sure that I would really add anything to that given like the number of people and who is already there and already getting those kinds of reports. Vicky McNamara. Thanks for streaming this trial with us, Andrea. Thanks to Jeff and all the mods as well. Thank you very much to Jeff and the mods. Could not do any of this without them. They are essential to this undertaking. So we really appreciate you, and we appreciate you, Vicky, for being here with us as well. James Casatelli, I feel like AJ is too roundabout in his questioning. Takes him too long to get to the point, and I can see how the jury might be checked out at this point and not fully understanding what's going on. Yeah, this is my criticism of Alan Jackson's cross-exam as well. It is a feeling out. It's a feeling out. He doesn't have the technique of just coming in with your best shot. He's like spamming a lot of jabs to try to set it up, but he doesn't always get it set up. So then it's just like, it just looks like kind of a lot of spamming jabs, and nothing's really, maybe you occasionally make a little contact, but it's not, it's not like a knockout shot. So I would have liked to have seen, like I said, and I've said a few times now, I would have liked to have seen more refinement. Know what you need from this witness. Know what your fact is from this witness, and just be disciplined and stick to that. If they go off script, it doesn't necessarily matter. You don't have to follow up on everything just because it happened. If it doesn't matter to your theory, you don't need to follow up on it. I would like to see more of that, but it just seems that really isn't his style. His style is to engage. He likes the battle. And so I think that's what we're going to get. I'm with you. I'm not convinced it's the most effective way to go about this. We'll see. Bird with a $10 super sticker. Thank you so much for that, Bird. Very kind of you. Lady FDD, what about the defense video of where he was versus Brennan's? That seemed to be two different videos that made the defense look shady. They're definitely showing the two parts of the same video, but the fact that one video has a timestamp and one video does not, that's a little bit off. Why is that? I don't know. I don't know who offered which one. I assume that the one that came in is the one that the Commonwealth offered, because that was pretty sure that's when it came into evidence. Let's just double check that. But it does definitely, doesn't it, raise some questions about where exactly did this video come from, and why are there different ones? Who removed or added timestamps to the video? So I didn't see that it got admitted during the state's case in chief, but maybe it did. Maybe it did. Exhibit, it would have been, I guess, Exhibit 4. Yeah, it was admitted as Exhibit 4, but it wasn't admitted until it was the defense on cross. So I don't know whether the timestamp one or the non-timestamp one got admitted. I got to assume it was a timestamp one because when we went back to it on direct, that's what we saw. I think that Mr. Brennan did a very good job of making this look shadier than it was, you know, because yeah, if you're just showing him the wrong part of the video, then of course that's being misleading. Of course that looks like you're trying to distort what the guy said and what actually happened. But I think they did manage to explain, you described a certain incident, and that's the one I played for you. When he came over and did the chest compressions, that's what you had described. So that's what I played for you. And it didn't happen during that time frame. You want to go back then and look at the video and say, no, it happened at an earlier time, but that doesn't correspond with the events that you had described. It doesn't fit your timeline. It doesn't fit your recollection of the circumstances. So does it make the defense look shady? I mean, maybe, I don't know. I could see how a jury could see it that way. It looks like you're being misleading. He said it was this other time, but I think if they're following the testimony, they understand. You said he was giving chest compressions. Here's when he started giving chest compressions, and from that point on, Karen Reed never approached them. So it didn't happen the way you described it. If it happened at all, it happened differently than you described it. And yeah, that's where Mr. Jackson maybe just could get to the point a little bit better, you know. The beating around the bush, maybe just get to the point. You said this is what happened. I'm going to show you the video where that happened. We're going to see Karen never approached him. Give me a second here. Sorry, didn't want to cough right in my mic. I'm going to show you that. So it didn't happen during that time frame. No, it happened during the earlier part. Okay, so it happened during the earlier part, but the earlier part isn't when what you described happening was happening. It means something else was going on when she said that. It's really all you need. Isn't that really all you need? It's almost like he doesn't necessarily know what point he wants to get at when he starts kind of going down to point out the inconsistency. And that's a problem. You need to know what your objective is. Your objective is not just to point out that this witness is being inconsistent, because what can happen, the witness can then be inconsistent in a way that's very unfavorable to you. Like we just saw him do. Now suddenly he's invented a whole bunch more. I hit hims. Because while he's focused acutely on his airway and his role, he is somehow able to pick out from the general, how did he describe that? I forget. Just the noise, the general noise of the background. Karen Reed's voice continuing to say, I hit him. In what context? No idea. To whom? No idea. What did anybody else say? No idea. But just that is picked up by his attention. Is it plausible to me? No, it isn't. If you're focused on your task You're not just hearing one random voice out of the blue when you said previously it didn't matter. It wasn't important to you. If something's important to you, you'd focus on it. But you said it wasn't important to you. So no, I don't believe that this unimportant thing that you didn't even register nevertheless, happened under this very specific set of circumstances that you remember clearly, and then was also happening while you were paying attention to something else entirely. Does that mean the jury is going to not buy it? Well, that I don't know. I don't know if the jurors are going to see that like I do. So it's just a little bit of a risk, I think, of Mr. Jackson's strategy when he likes to get in the ring. He likes to get combative. He likes that fight. You don't know where it's going to go. You can get a punch in the nose. And we saw it happen to the defense a couple times during the last trial. Edward Kirkpatrick. By hook or crook, Judge Bev and Brennan are trying to find a hook to hang ARCCA exclusion on. They need them off this case badly. If not exclude them, at least limit them. I wouldn't be surprised if we're moving in the direction of limiting their new testimony. It wouldn't surprise me, in part because that will be part of Judge Bev's way of dealing with this whole question about, did the defense communicate with them about their testimony before the last trial or not? Does the defense have a role in shaping their testimony? A middle ground solution here is, well, we'll let them testify to the stuff that was in their report to the FBI that the defense didn't even get until after it was done. But anything after that maybe the defense tainted in some way, in some undisclosed text message, phone call, we'll just not let them deviate from their report. I could see her going in that direction because, they are devastating. They are very devastating to the Commonwealth's case. And if they get to rebut Mr. Welcher, I have a feeling Mr. Welcher is going to have a problem. If they can't testify, they can still assist. I think that is important to know. They can still advise the defense. They can watch, especially if they can't testify, then they're typically not going to be under the exclusion order. So they could watch the testimony and they can tell the defense, here's the problems with what they had to say. Here's how you can cross them on it. Here are the things to bring up. Here are the things to confront them with. Stuff like that. They can always advise, but that's never as strong as getting the expert themselves on the stand to do that rebuttal. So I kind of suspect that's the direction that she's steering us. She's going to try to limit it. And yes, Brennan is desperate to get them out because he told on himself, like Emily D. Baker pointed out. He told on himself, if your case is this fragile, that ARCCA can bust it all up just by looking at what your experts did, then you've got a bigger problem. You've got a bigger problem than ARCCA testifying. Michael Muddragon. I love Mad Alessi. Angry, articulate, and full of righteous indignation. Go get him, Alessi. Bring the fury. He does have quite an energy to him when he's worked up, doesn't he? He gets loud. He gets emphatic. He is not having it. He's not having it. And he does not he doesn't hesitate at all about letting you know he's not having it. Judge Bev just kind of lets him go. Kind of lets him go off. Doesn't do the interruptions nearly as much as with the other attorneys. His timeline, he's so systematic. That's what I really like about Mr. Alessi. That's why I wanted him to do the opening. I wanted him to do it because I believe that Mr. Alessi has like a small database or a spreadsheet in his head. He's got in his head like a sleuthy goosey spreadsheet, okay? And it's the timeline. It's every piece of evidence that is dated and time-stamped. He's got that all organized and laid out in his mind, how it all relates to each other. I want him to put it on a demonstrative and be able to show the jury, like, if nothing else, I want this for closing. But it's just how he thinks. It's just how he thinks in that systematic, orderly, chronological type of way, being able to relate things to other things. We're producing this at the same time our expert is doing this other thing. Meanwhile, the Commonwealth is filing this new motion, and then we're having a hearing. He's able to tie those pieces all in together so effectively. So I'm sure he's got something like that with the evidence in this case. And I wanted to see that in opening. I wanted that laid out. I thought that would be a good way to tackle it. Didn't get that. That's okay. We can't always get what we want. Can't always get what you want. So yeah, he's outraged because here's the Commonwealth trying to say, we've been totally on the up and up with our discovery, when they're the ones that have, dragged Mr. Welcher in at the last minute and dragged their feet about providing what his actual opinion and basis is. Under Mr. Brennan's kind of theory of how this is supposed to go, the defense, I guess, should have hired an accident reconstructionist as soon as they disclosed Welcher, even though they have no idea what Welcher is going to say or what he's going to do. Why are we inferring that it would be negative? By the way, with ARCCA doing their own testing, why are we presuming that would be so prejudicial to the Commonwealth? You know what? What is sometimes possible is testing can confirm your theory. It can actually be helpful for you, and that can be really, really devastating with a defense expert. It's one of the reasons why when you see, like in Richard Allen's case, all the requests for defense experts, this is done ex parte. This is done outside of the knowledge and awareness of the prosecution. It's because they're not entitled to know it unless you're going to bring it at trial. You get to test your theories, and if the expert tells you, this looks consistent with guilt, then you don't call that expert. If the prosecutor finds out you hired that expert and they came up with bad evidence, they can call that expert themselves. This has happened on multiple occasions. There's been case law about this. So that's why it's done in secret. The defense has to have an opportunity to be able to flesh out their case on the same type of basis as somebody who has the ability to hire their own experts would be able to do it. Somebody who hires their own experts would never have to disclose it unless they're going to use it at trial. So just because you're poor and you have to go to court to get permission to hire somebody because it's going to be funded by the court, that doesn't change your status somehow in terms of what the prosecution is entitled to know or not know. They're still not entitled to know what your strategy is and what your work product is. So that's why all that typically happens behind the scene. It can be very damaging. You got an expert and they go do a follow-up and it's, oh shit, this ain't helpful. Why are we assuming that ARCCA's follow-up is going to be so damaging to the Commonwealth's case? Why would we be reaching that assumption? If your experts are so good and their testimony is so solid and well-founded, and it's based on facts, science, and data, then why would you be concerned that ARCCA is going to reach a different outcome? Surely they would reach the same outcome as your experts, right? I don't know why we're presuming it would be a negative. But yeah, he's clearly outraged because here's the Commonwealth that's set on their hands and they're shifting the blame. He's pointing the finger at the defense. This is your fault. And the Commonwealth's, the Commonwealth's the one who has hired the witness, fairly late in the day, disclosed it fairly late in the day. And the defense has basically has had to respond to their trickle of disclosure, with an instantaneous flood. So I can understand very well why he is frustrated by that. It's blame shifting, and that is pretty annoying. Edward Kirkpatrick, has she ever found a discovery violation on the Commonwealth? Boy, great question. Not that I remember. Not that I remember. I mean, even the stuff like the late turning over of the Sallyport and stuff like that. Even Proctor had it and sat on it, and they knew. And she didn't even find that was a problem. Now, granted, that's in the Brady context. That's not specifically in the Rule 14 context. But no, I mean, even in writing an order, I don't think she ever even said like they shouldn't have done that. Would have been better. Would have been better to have turned it over. With the Commonwealth filing all their certificates of compliance this whole time and then coming up with stuff later in the day, like, I don't know, inverted Sallyport video, all that stuff. Yeah, I don't know that she has found a discovery violation. Remember last trial, the thing that the Commonwealth brought in at the very last minute was the hair. The hair and the mitochondrial DNA testing that they waited until the 11th hour to do it. They didn't have a result like right before trial is starting. I don't remember exactly when they got the result in, but it was like right around the time the trial started. And talk about ambush. You just go ahead and sit on stuff until it's convenient to you to know if it's going to be helpful or not. I understand. Mr. Alessi's frustration because this is part of it. Has she ever found a discovery violation? I don't think so. Definitely can't think of one off the top of my head. Edward Kirkpatrick, she's trying to get Brennan a free deposition of ARCCA that is not allowed under Massachusetts law. Yeah, I mean, he already got one the first time, right? Lally got one the first time. Mr. Brennan already got his free deposition of Dr. Russell. That was, I guess what he gets. Got the free free questioning, free preview of what the testimony is going to be, and particularly how it's different this time. So getting yet another voir dire of ARCCA, and now it's also going to get into what's new, right? What are you doing now versus what you did before? All under the guise of it being some type of Rule 14, because they waited until March something to provide, final data from their expert. It's pretty nice work if you can get it in that courtroom. I agree. This does look a lot like they're just getting a free preview of what the testimony is going to be so that they can prepare for it accordingly. Peter Sitchell, Bonsai workshop at the Burkhart residence, please. I keep killing mine. It's in the nature of bonsai. You are going to kill a lot of trees if you are into bonsai. You just can't get around it. It's extreme horticulture. That's why I got interested in it in the first place. Because it's taking growing things and, pruning and shaping and stuff like that to a level that is, very thin margins when you're working with these trees in pots. So you're going to kill a lot of trees. I have killed a lot of trees. I still have my juniper. I've been waiting to repot the juniper. It can wait a little bit longer than all the rest of the trees. They have all leafed out now. It's too late to repot any. Some of them I might regret that I didn't get them done this year because they are a little bit compacted. We'll see. I'm just going to do my best. But the juniper can wait a little bit longer because it doesn't start kind of waking up. What happens is the tips of the foliage. My juniper that I'm going to be repotting is it's a western juniper. So it's got like a scale type foliage, And the ends start to swell a little bit and get kind of golden in color. And that's kind of the equivalent of your deciduous trees when they wake up in the spring. One of the first things you notice is the little buds, they start to swell. And then eventually sometimes they'll change color a little bit. Sometimes they kind of get a little glow about them. It can be very attractive when the trees are in the bud swell. And that's typically when you want to do your repotting. They're just starting to wake up. All the energy is coming out of the roots and out of the vascular system, and it's starting to move around. It's starting to enter the leaves and fuel new growth and stuff like that. So you want to do it just as that process is starting. Happens a little bit later with the juniper. So I do still have that on the horizon. I have it set up to where I can film it. I'll try it. I can't promise to talk about anything else while I'm doing it because it's going to be intensive, and you'll understand if you eventually see it. Because not only is it a big tree, it's a collected tree. It's only been repotted one previous time, so it's still new to the pot. Means there's a lot of like rough root growth to have to kind of sort through and deal with. I'm also changing the angle of the tree in the pot, which means I have to change the shape of the root ball. Gonna have to pay attention to all this stuff, figure out how I'm going to tie it down again. It's going to be a lot to think about. So I can't promise that I'll be able to really talk about anything else but trees. But I'll definitely consider doing that, Peter, and just kind of chatting about my experience with them and, what I've learned, what's worked, what doesn't. Our problem here is borers lately has been a big problem. I lost all of my pines to borers, which is heartbreaking. I had a beautiful pine that I lost. Lost another juniper to borers. This juniper has borers, but it's only just taken out the top so far. So going to be working on that. I'll talk about all that, I guess. Why not? Edward Kirkpatrick, defense. We don't have texts. Judge Bev. ABA 7 years. Commonwealth. We auto-delete video every 30 days. Judge Bev, what do you want me to do, AJ? Auto-delete, no harm, no foul. Please move along. Yeah. Yeah, good point, isn't it? Is there a specific ABA rule for text messages that's different than Sallyport video? That's not the 5 to 7 years retention policy. Different rule for private attorneys versus prosecutors. I don't know, but it's clearly not the same standard that's being applied, is it? Because when Commonwealth stuff disappears, oh, well, it's just gone. Don't know what we can do. Oh, you know what? The video's gone, and also the logs telling us what happened with the video win. Those are also gone. Unfortunate. Shame that we'll never know. Shame that we'll never know. Yeah, that's the standard. Edward Kirkpatrick, worth noting Judge Bev is at play with AJ Cross. He has to stay inside her lines, and she sustains very normal questions that should not be sustained. So far, the objections have been pretty minimal. Not seeing a ton really from either side. But yeah, she is unpredictable. And I think you do have to be cautious about where you're getting to. That's all the more reason to be targeted, to be focused, to know going in, these are the facts I need to get out of this witness, and that's all that I need. Because she might cut off one of your ways of getting there. Okay, maybe you have another one. You better have thought about that ahead of time. Maybe you have another way to get this fact in. But if you let yourself kind of get distracted and just run down every reason why you're not getting what you're trying to elicit from this witness, you're just kind of opening up the door for her to interfere more, for yourself to get cut off. And then where are you? You lost your initial point that you were making. You went into combat over the inconsistency, and you didn't get to conclude that. It doesn't end up looking like a winning cross. So one more thing to be careful about. I agree. She's very unpredictable. And that's the frustrating part about trying a case in front of a judge like this. The whole reason for having rules, having a rule of law, is so everybody knows ahead of time. They can predict, here's how things are going to go. This is how we're supposed to behave. This is what the consequences are going to be if we don't. And so when you can't rely on those rules, you have somebody arbitrarily deciding how they apply, rather like that John Adams quote that Judge Cannoni mentioned in her preliminary instructions, a government of laws, not men. When you just have a person up there who's applying what they think should be done and not what the rules allow or don't allow, it's very unpredictable. And so it's very hard to plan for that. That's all the more reason. Know what you need out of this witness. Know how you're going to get it. Know what your facts are, your evidence. If you need the fact that Anthony Flamati, I keep going back to him, Mr. Nuttall, Timothy Nuttall, told Trooper Proctor on February the 8th, that was the first time he ever reported anybody saying I hit him. And he reported it in the context of overhearing Karen say it to another woman and the woman telling her to shut up, to be quiet. If that's the information that you need to elicit, you need to know your pathway to get to it. And your pathway is he told it to Proctor. So it's hearsay, but I can get it in as a prior inconsistent statement. If he doesn't admit it on the stand, then if I can get him to deny it, then I can bring it in through Proctor. You know what you need and you know what your pathway is to get it in. And that's really the best thing you can do, not just to prepare for a judge like Cannoni, who's gonna try to, get you off your game. You're prepared for that because you know, if I can't get it in through that pathway, what's my alternate one? Is there an alternate one? I guess if I have to refresh him, I can. You can try that. But also just because it will help you make your record, because you're going to be able to articulate exactly what you were trying to do, exactly how you were trying to do it, and why that's okay, and why her ruling is therefore bad. Would like to see more of that. Just don't know that that's the style of this team, so I don't know that we're going to get it. Prime Finder with a $2 super chat. Thank you so much for that. Thank you for your support. Almost 9 hours in on day one, guys. That's not too bad. That's not too bad. It's almost 3:00 over here. We're going to have, I think we got some Phillies baseball this afternoon. Got some Phillies baseball to look forward to. Excited about that. It's a nice day outside. I'm going to take the dog for a nice long walk. We've been going on some nice long walks right now. It's been very helpful for me. We do miss Rupert very much. I know you guys miss his nice, we would have had so much snoring going on today. He wouldn't have known what an exciting day it was back on day one with Karen Reed. Instead, we just have Buffy here with us, and Buffy is a much more quiet sleeper than Rupert is. But being able to get out and walk her around definitely just, helps us remember him and kind of honor him, in a way, because that's the stuff he loved to do also. And so he would like that. He wouldn't want to be sitting around moping or anything like that. So Phillies baseball, dog walk, and then, boy, I'm going to have to catch up on what the internets have been saying about today, what's been going on outside that courthouse, what's happening with people being arrested in the buffer zone. This is our life now, back in the Karen Reed trial. This is how it's going to be. Long day, watch it all, take it in, recap. Take your questions, get some rest, see what happened in the rest of the world, and then be right back at it tomorrow. So finishing up Kerri Roberts' direct examination tomorrow, and then the $1 million question, is she going to get crossed? Is she going to get crossed? I think maybe I'll put a poll up in the next video description. What do you guys think? She wasn't crossed the first time. Is she going to get crossed this time? I think she is. I really think she is. I don't know, but I just feel like they're going to have some questions about how she ended up with John O'Keefe's cell phone and what exactly did she do with it? Who did she give it to? Where? Because there's no record, right? No chain of custody on any of this stuff. So we got to try to reconstruct it as best as we can. And if it started with her, yeah, I feel like she's got to answer some questions about that. Lorelei Annie, any judicial review for biased judges besides appeal? No. They can move to disqualify her. I mean, that's step one anyway. They're not even going to really be able to raise it on appeal if they haven't raised it with her. If they haven't brought it to her attention and said, hey, you might not have noticed, but the way that you behave with the double standards, the patterns of your ruling, the way that you interrupt us, but not the Commonwealth, the way that you chastise us for things that they do that you let them get away with, you may not be aware that this makes you look biased. And because of that, we think you should disqualify yourself. You got to give her a chance to rule on it first. If you don't do that, it's not going to come up on appeal. The only way you get there on appeal is proving actual bias on the part of the judge. And that's a very, very difficult hurdle to clear, because when you're talking about actual bias, you are talking about she is demonstrably prejudiced against Karen Read, has a vested personal interest in the outcome of the case, something like that. And it's very difficult to prove that. You can have circumstantial evidence that that's the case, but circumstantial evidence can usually be interpreted in multiple ways. So not a very easy standard to meet if they don't bring it to her first. So expect that as a precursor. If they plan to go down that road, they need to raise it with her. My Mini 67, having now dissected the Canton Town DVR system, I can say with certainty the logs have been deleted. Also, Lori V and Daryl B need to appeal. There's video evidence. Karen Read did those too. I don't know. Oh, Daryl Brooks and Lori Vallow. Well, I don't know what happened to the logs. All I know is what we've heard so far in the pretrial testimony, which is that the logs should be there and they aren't. And there's no apparent record of what happened to them. So I'm sure we're going to hear more about that, at least once we get into the defense case, if we don't hear it through cross-examination of the Commonwealth's custodians of the videos before that. We might hear it in cross, but definitely by the time we get to the defense case. So yeah, kind of a question what happened there. All right, guys, we're going to call it a day. We're going to check out. Thank you again for all of your support. Thank you for being here. Thank you for your comments. Thank you for your awesome chat. Thank you for supporting the mods and for supporting Jeff. Really appreciate all of you being here. Do get out and enjoy your day some. I realize not everybody is here on the West Coast where you still have a lot of afternoon left. But you know, we're getting into summer, days are getting longer. This is the time of year when it's good to be alive. It's good to be outside. It's good to be awake. You know, I'm one of those very light sensitive people. When it's dark out over the winter, I just have a very hard time dealing with that. And then as soon as it starts getting more light, oh, my mood's better. My energy's better. Maybe that's just me. It's not just me, but it may or may not be you. But either way, it's just, you know, we were made to be out under the blue sky with the wind on our skin. Try to get a little bit of that. It really does do a lot to just improve your well-being. So I'm going to be out, guys. Thank you again. We will look forward to seeing you bright and early tomorrow. Come back for day 2 and see what happens with Kerri Roberts. Take care, everybody.